Good morning. It is Monday, September 9th. It is 9:01, and this is the Energy and Carbon Management Commission, and we will take a roll call.
Thank you. Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Robbins,
Here.
and Commissioner Shea.
Here.
Mr. Chair, you have 6 of 7 commissioners present.
Excellent. Great to see everybody. I hope everybody had a wonderful weekend. It's nice to feel fall in the air. We are undertaking an additional couple of days on the cumulative impacts and enhanced systems and practices rulemaking. That is docket 2406-00145. With all due haste, we will move into, so we're taking cases in chief. And so we're going to start this morning with the case in chief from Save the Aurora Reservoir, which is a community group, and they have 15 minutes.
Good morning. Thank you, Mr. Chair, Commission and ECMC staff. On behalf of Save the Aurora Reservoir, or STAR, we really appreciate the opportunity to share feedback about the draft cumulative impacts rules. And we also really appreciate your willingness to accommodate some of our unique scheduling needs. My name is Sarah Matsumoto. I'm a law professor and the director of the Getches Green Natural Resources, Energy, and Environmental Law Clinic at the University of Colorado Law School. With me are 2 student attorneys in the clinic, Eric Nicholson and Andrew Osgood, and together we'll just offer a few points on behalf of STAR. STAR is a community-led grassroots organization with many members who reside in and around Southeast Aurora, and STAR advocates for the protection of communities and the environment and seeks to engage with regulators at all levels of government in support of its advocacy efforts. We recognize and appreciate the significant work that Ms. Trask and staff and all of you have dedicated to an issue that can be somewhat challenging to address, and we think that the June draft of the rules did make substantial progress on many issues. This morning, we'll focus our time on a few remaining concerns about the draft rules. We'll address 6 recommendations this morning. Those include defining the impact area at the resource level instead of relying on a static 1-mile default, relying on quantitative data over qualitative descriptions and applications, require collection of baseline data, amend Rule 315 to include a separate section for traffic impacts, expressly authorize denial of applications where impacts cannot adequately be avoided, minimized, or mitigated, and lastly, to require informed consent from residents and owners in disproportionately impacted communities when an operator proposes a well pad within 2,000 feet. I'll turn it over to Eric to begin.
Thank you, Sarah. And before I delve a little further, we would once again like to thank the Commission for their efforts to incorporate environmental and community concerns into this June proposal. However, STAR still has several different concerns with the proposed operation of the Commission and urges the Commission to adopt several different changes to improve the accuracy and completeness of environmental impact data to promote a more effective fulfillment of the Commission's duties. I will begin with STAR's concerns and then discuss some alternative solutions. Firstly, the proposed cumulative impact area of 1 mile around an operating facility needlessly restricts data collection on environmental contamination metrics and results in lost impact data, particularly when it comes to pollution runoff. The 1 mile cumulative impact area is an arbitrary and capricious standard that limits the Commission's ability to make fully informed decisions about all the environmental effects in a sufficiently broad context, and in some cases may lead to outcomes counter to the Commission's goals of maintaining a more protective role in industry regulation. STAR proposes 2 solutions to this information gap created by this new draft, which, if implemented together, would greatly expand the amount of cumulative impact information available to the Commission for use in evaluating applications. Firstly, data collection for cumulative impacts should be quantitative rather than qualitative. This would ensure all data collected are equally measurable, resulting in a more accurate assessment of cumulative impacts and a more informed evaluation. Rather than attempting to field metrics based on things like lightly or heavily polluted, data will be contextualized, such as by measuring at the parts per billion level. Data could be collected by third-party experts in their respective fields or from publicly available data banks. Further, cumulative impact rules should authorize the Commission to address known cumulative impacts rather than merely receiving information of their existence. Secondly, the 1 mile radius of measured cumulative impacts must be expanded. STAR proposes a cumulative impact area should encompass all disturbed surface areas and all areas that may be affected by contaminated sources from any facility. This approach would lead to cumulative impact areas being defined at the resource level rather than arbitrarily at the project level. By measuring cumulative impacts in this way, a more complete study of environmental impacts can be conducted, one that considers each separate environment's unique features and communities without discounting the impacts that individual environments can have on each other. I will now turn over the rest of this discussion to Andrew regarding some of STAR's additional recommendations.
Thank you, Eric. So I will be presenting 3 specific recommendations from STAR. First being a call to include language that requires baseline data collection with these cumulative impacts. Secondly, adding a subsection specific for traffic impacts that concern STAR. And lastly, expanding the definition of denial within the 300 series rules to include references to these cumulative impacts. So to start, STAR would urge the Commission to reevaluate its lack of a requirement for baseline data collection for an operator where it may be affecting a community. STAR supports Conservation Colorado's proposed edits for the need to collect baseline data to properly measure the impacts of proposed paths. The definition of cumulative impacts in Colorado statutes necessitates an evaluation of impacted air, water, climate, and other environmental metrics in addition for new oil and gas development, in addition to past, present, and foreseeable future development. Without any baseline data, the reference to this addition is not being fulfilled by the current rulemaking and would not allow for the Commission to properly evaluate potential impacts over time. For example, the draft rules requirement to measure the expected increase in, say, benzene would lack the baseline context needed for the Commission to properly evaluate the magnitude of how operations may affect that particular pollutant and the local air levels. STAR recommends either taking Conservation Colorado's proposed draft edits or modifying sections like 315A2BI to include language that requires both a quantitative evaluation of pre-operation totals and the incremental increase of total hazardous air pollutants. Similar subsections should be edited likewise. So for my second concern I'd like to address is the lack of a specific subsection for traffic impacts. STAR appreciates that the current draft rules do include a few mentions of truck traffic in the context of emissions. We also support the recognition of noise, dust, and odor impacts under the context of public welfare under section 315A2F. But we agree with the allied local governments that separate sections addressing traffic as a source of impacts would ensure things like vehicle and pedestrian safety risks, potential road maintenance risks, and travel disruption can be identified and evaluated by the Commission. For a specific example, we can look at the recently approved Lowry Ranch cap to showcase some of the concerns STAR has with traffic impacts. Crestone, the developer for that cap, noted that it expects new wells will initially produce about 3,500 barrels of water, and then once well stabilized, that number will go down to about 1,500 barrels of water annually. Crestone estimated that the total annual barrel production for every single well would reach about 300,000 barrels of water. Crestone then stated that produced water would be transported by truck during the production phase of each well, which means that millions of gallons of produced water will need to be transported by truck every year for that specific cap. In addition to STAR's concerns about the intense use of that level of water, STAR also has concerns about the amount of trucking required by this produced water. STAR thinks that safety risks and travel disruption are separate traffic concerns that should be addressed in a separate subsection as proposed by the allied local governments. The addition of truck traffic roads, especially to roads near a recreation site, such as the Aurora Reservoir, where many of the group's constituents currently reside, should be identified and addressed in the cumulative impact analysis. And thus, STAR supports the Allied Local Government's recommended revisions to Rule 315, Section B2E. Lastly, STAR recommends that with these additional metrics being recorded by the cumulative impact rulemaking, Rules 306 and 307 should be edited to authorize the Commission to base its denial on these cumulative impact analyses. The Oil and Gas Conservation Act requires that the Commission first take steps to avoid adverse impacts, and if impacts are unavoidable, make efforts to minimize or mitigate them. With that being the statutory basis behind some of the Commission's stated goals, we believe that giving express power to deny potential permitting based on these cumulative impact analyses would give the Commission the power and the rulemaking the power needed to avoid such adverse impacts. Some proposed edits would either include adding cross references to specific subsections of Rule 315 in Rules 306B3 and 307B2, or to use the defined term of cumulative impacts to then give weight to the proposed rules in general. The expanded definition will make the resulting Rule 315 more enforceable and give oil and gas developers more notice that such cumulative impacts will impact the Commission's decision-making. Thus, the Commission will have the ability to fulfill its goal of maintaining a healthy and safe environment by avoiding impacts. And with that, I will pass the remaining time over to Professor Sarah Matsumoto for STAR's final recommendations.
Thank you, Andrew. STAR's final recommendation this morning is to urge the Commission to adopt the June 14th version of Rule 604, which would require operators to obtain informed written consent from owners and residents within 2,000 feet of a working pad surface when a proposed oil and gas location or when an oil and gas location is proposed within a disproportionately impacted community. This requirement is consistent with state law and express legislative goals. Under the Oil and Gas Conservation Act, the Commission is tasked with minimizing adverse impacts to disproportionately impacted communities that are negatively affected by oil and gas operations. This is a clear acknowledgement by the legislature that some communities are already more heavily burdened by this particular industry than others. Additionally, HB 1266, or the Environmental Justice Act, expressed a legislative goal for the Commission that it would not only provide opportunities for DI communities to influence policy, but that it would actually modify or take some action in response to DI community input. And we think the requirement for informed written consent that's outlined in the June version of Rule 604 fulfills that goal and also adheres to state law. Another reason that we think this informed consent requirement is really important and should ultimately be adopted by the Commission is that this included provision would further aspects of environmental justice. Over the years, environmental justice scholars have worked to, and leaders have worked to define what that term actually means. The first word in the phrase environment has been kind of refocused on, to center people and to talk about places that people live, work, play, learn, or practice spirituality. And I know that these are likely familiar to many of you already. Justice, on the other hand, can come in many different forms, and that can include some aspects of justice that are already kind of embedded within these rules or that the Commission has certainly discussed and contemplated. That could include distributive justice, focusing on more equitable distribution of both burdens and benefits. Procedural justice, I know other parties have kind of focused on that in their presentations to you. Could also include corrective or restorative justice, social justice, recognitional justice, and structural justice. And in my view, the proposed informed consent requirement in Rule 604 would advance multiple forms of justice. Procedural justice would be served because it not only would give residents of DI communities a direct seat at the table when decision-making is happening, but it also allows them to potentially influence the outcome of that decision-making. Social justice is advanced here when the informed consent requirement is kind of paired with the definition of DI community that already recognizes that there are some existing inequities, historical disparities, power disparities that affect different people differently. And here it's kind of situating an environmental justice issue within some of those broader social contexts, recognizing that some Coloradans may be experiencing socioeconomic stressors, some Coloradans may have experienced a history of discrimination. And so it does kind of make sense to, in our cumulative impacts rules, recognize these historical and social differences for different groups of people. And lastly, kind of the most straightforward aspect of justice here is distributive justice, by which DI communities or certain members of DI communities in the specific case could actually affect a decision-making outcome and potentially, if they so choose, prevent additional environmental burdens near their homes unless they actually understand and consent to that development. So for those two reasons, because the informed consent requirement is both consistent with state law and expressed goals, and because it furthers aspects of environmental justice, we would encourage the commission to maintain the language of the June version of Rule 604. That concludes our presentation this morning. We thank you very much for your time and your attention, and we're happy to answer any questions that you might have.
Thank you very much. Commissioners, the panel is open for questions. Commissioner Cross.
Thank you, Mr. Chair, and thank you for that. I just had one quick clarification question. I believe it was with respect to what Mr. Nicholson talked about. With respect to the impact area, I believe I heard you say encompass all disturbed surfaces, and then I didn't quite catch the latter part of that. Disturbed surfaces, and then as far as things could be spilled, I think that was kind of the gist like that, but I just wanted to make sure that I understood.
Yes, thank you for your question. To clarify that statement, I had stated that all disturbed surface areas and then any areas that may be impacted by contamination sources from any facility.
Other questions for the panel? Commissioner Ackerman.
Thank you and appreciate you being here today. Thank you for the concise and informative presentation. I think it was well done. I just wanted to get a little bit further thoughts on, you mentioned baseline data collection a couple of times. Wanted to get some further thoughts on kind of your ideas around the gathering of baseline quantitative data in the broad area that you've suggested. Any further thoughts? Do you want to expand on that at all?
Well, I can start. All right, thank you for your question. So as Eric had mentioned in his part of presentation, we believe there is some publicly available data that may already be addressing some of these baseline concerns. An additional recommendation we made is either having the industry gather third-party experts who can collect such data. Those were kind of two solutions we proposed, just making sure that this is done pre-operation as well as part of the whatever predictive metrics they're making for fulfilling the obligations of the cumulative impact rulemaking that we're discussing today.
I'll add one additional thought, which is just that, I want to make sure it doesn't seem like we're encouraging people to be duplicative or reinvent the wheel. I think we recognize that there are already existing great sources of data and that some of those data sources are updated frequently. And so part of this process wouldn't necessarily need to be starting from scratch and collecting entirely new collections of data every time with every application, but could at least be looking to these readily available sources to begin with, and then filling in the gaps where there may be some gaps.
Thank you. I appreciate that response. Nothing further, Mr. Chair.
Further questions? Commissioner Shea?
Yeah, I just had a quick question. And again, thanks for the information. You'd mentioned additional data collection surrounding traffic impacts. And I was curious, kind of your thoughts on how that would be in addition to what's already required. If you could expand on that a little bit. In Form 2A and 2B.
I think the idea is we've seen some mention throughout the draft rules where specifically like emissions from trucks or vehicles or some kind of traffic impacts are scattered throughout other rules. we think it might make sense to kind of capture those in one additional section and include a little bit more focus on some of the projected safety or road maintenance or potential kind of like travel disruption concerns that may exist. And we recognize there may be times where traffic is more intense than others during various stages of development. So it might be helpful just to have that sort of almost a predictive or an estimated timetable of when we could expect traffic impacts of various sorts to be more intense than others, rather than having to kind of comb through the application and try to piece things together from other sections.
Okay, thank you.
Further questions? All right, we thank the applicant for their case in chief and their testimony this morning. Thanks for kicking us off today.
Thanks very much.
Thank you.
All right, we now will move to the Colorado OG Society. Why don't we take 5 and get that panel impaneled, and let's return at 9:29. All right, we are back. It is 9:29 on September 9th, and we continue with docket 240600145. We now have before us a case in chief presentation by the Colorado OG Society.
Thank you, Mr. Chair. Are we good to begin?
You are.
All right. Thank you, sir. Good morning, commissioners. Hope you are having a good morning so far. My name is Chris McGowan. I'm an oil and gas attorney who represents oil and gas operators here in Colorado. I appreciate your time this morning and today and the opportunity to provide comment in this rulemaking. I am here today with Ms. Tricia Fanning, and we represent the Colorado OG Society, which is a nonprofit organization that represents smaller to mid-sized oil and gas companies who operate inside Colorado's borders. Our members' operations range from single well to multi-well pads, and they are located throughout the entire state of Colorado, from the West Slope to the Eastern Plains and everywhere in between. Smaller operators are an integral part of Colorado's oil and gas industry, making up a significant amount of the production within the state. Typically, our operators are family-owned, privately operated, and generational oil and gas operators. Their desire is to exercise their property rights and contribute to Colorado's local communities and general health and well-being, much like all other businesses who are located inside Colorado. This morning, we would like to go over a few pertinent topics that we feel are most relevant to your decision-making process. So I will now pass it over to Ms. Tricia Fanning, the OG Executive Director.
Good morning, commissioners. My name is Tricia Fanning. In addition to my work with the OG Society, I am president and owner of Ardor Environmental, an environmental regulatory consulting company which provides permitting and compliance support with ECMC rules. I have appeared before you in multiple capacities, including nearly all of your previous rulemakings since the passage of Senate Bill 81. As a regulatory consultant, I have been successful in representing more than 10 operators to obtain unanimous approval on their OGDPs. Whether it was for a vertical wildcat well in Washington County or a coal bed methane development on the Western Slope and high priority habitat, or most recently a multi-well pad development within the city of limits of Loveland, each of these OGDPs are unique in their type of development and geographic area. But there is one thing they all accomplished, and the commission unanimously agreed upon. They protected public health, safety, welfare, environment, and wildlife resources. In all cases, each of these OGDPs met the standards, but also each operator chose to commit to enhanced systems and practices. We believe that it's important to begin our presentation with some context around the positive aspects of ESPs that operators have already been voluntarily committing to in their permits. We believe it's important to establish a baseline of existing ESPs that are addressing many of the things that have been alleged to be problematic. Examples of ESPs that operators have committed to implementing include, but are not limited to, electrified drilling, electrified production, when it's technically feasible, Group 3 drilling mud tankless facilities, no routine maintenance, activities on high ozone days, no permanent lighting, additional air monitoring beyond CDPHE's required timeframes. These are just to name a few. These ESPs are determined in a case-by-case manner, implemented on those permits that are 1, feasible to implement, 2, where they may provide additional public health or environmental benefit. However, on some permits or for certain operators, these conditions would prevent the development of oil and gas resources, despite the other additional protections that have previously been put in place. To put it another way, we believe that appropriate permit conditions should be placed where they are most necessary and reasonable and will provide intended benefit. They cannot be done with a one-size-one-rule-fits-all approach. This can be illustrated by the OGDPs that have previously received approval by this commission. I have permitted wells under the new rules in nearly every basin and viable producing county in Colorado. I would argue that each location is unique in nature and character, and as such, we should tailor these rules to allow for the most flexible approach available. This rulemaking has provided you with a significant amount of information that seems to argue that all oil and gas is the sole source of all states' ills. However, the actual data shows that the past rulemakings covering setbacks, public participation, notification, informed consent, environmental protections, cumulative impacts, emissions, and wildlife are in fact effective at remedying many of the concerns that have been highlighted. We believe, and based on prior comments of this commission, that oil and gas is being extracted safer than quite possibly anywhere in the world. Further, we believe the sheer number of new rules have not only shown progress, but also illustrated the impacts of regulations on current and future development. The same statements and accusations being made that the commission isn't doing enough to address and specifically deny permits are simply untrue. In Colorado, it takes on average 260 days to get an OGDP approved, where our bordering states to the north, east, and west are significantly less. Let's take Wyoming, for instance, which has been in non-attainment and has strict air regulations. Operators can often obtain permits in 60 to 130 days. The same goes for Utah, and you potentially can process a permit in Utah even quicker if operator can prove rig availability and waiting. To the east in Kansas, a permit can be obtained in just a few days. My point in representing this comparison is not to show that Wyoming, Kansas, or Utah takes environmental less seriously than Colorado. Indeed, we would argue they do. The difference is the amount of information Colorado operators must provide to prove that it operates in a manner protective of health, safety, environment is substantially more. Keeping in mind that many operators have assets in one or more of these states, we have not seen any evidence that they operate any less protective in other states that don't have the same regulations as Colorado. OG believes that the commission has addressed many of the topics that this rulemaking that's in this rulemaking through a significant number of previous rulemakings. We believe those rulemakings have resulted in the strictest regulations in this country. Truly, we believe our position is reflected by the past statements of many of the same proponents of changing these rules and or members of past or current of this commission. There has been former public acknowledgement that Colorado has passed rules that are the strictest in the country with the utmost protections for health, safety, and welfare of the public and biological resources, which have taken into account cumulative impacts and provided currently in place protections. These regulations passed by the ECMC were developed along with other agencies, local governments, and the public. Industry has been in ongoing regulatory rulemakings at multiple agencies for the last 6 years. More than 14 alone were held by ECMC. This does not include the plethora of Air Commission rulemakings revising air regulations and permitting rules. This has resulted in a significant regulations that requires operators to submit plans that demonstrate protections in more than 19 different areas: noise, water, cumulative impacts, wildlife, community engagement, address air emissions with considerations through consultation with CDPHE, protect wildlife and sensitive habitats through consultation with CPW, require operators to have both local government permit and state permit, create a comprehensive area plan process that enables the commission to view the proposal holistically and to quantify and address cumulative impacts through landscape level master planning, create the cumulative impact database from oil and gas operations, and a task force that will continue to improve cumulative impacts permitting process, strengthens its operations in reporting and notification requirements, including adopting statewide prohibitions on certain chemical additives and hydraulic fracturing fluid, such as PFAS. Expand the productive setbacks and siting requirements for schools and homes to 2,000 feet, except for certain off-ramps to the siting requirements, including when the commission approves more protective BMPs. Strengthen its protections for groundwater public water systems, along with prohibiting routine venting flaring of natural gas. Significantly speaking, almost every single aspect of oil and gas development has been addressed via regulation. These regulations were developed pursuant to a statutory mandate to impose protection surrounding oil and gas development, and the basis for this implementation of rules was a statutory reference to public health, safety, welfare, and wildlife resources. These regulatory efforts are relevant and should be considered when making a determination as to what is necessary or reasonable with respect to the current proposals, as well as the request to expand the proposals. In particular to air quality, from 2014 to 2024, CDPHA has undertook a multitude of rulemakings that has addressed all manners of regulatory aspects of air quality. This has included LDAR, GHG, pneumatics, engines. Nearly 20 different subjects were addressed in one fashion or another. CDPHA has continued to promulgate more regulations as illustrated here. The point being that in context, air pollution and oil and gas development has been highly regulated on all fronts for many years, with increasing frequency and effect, consistently pushing Colorado to the forefront of an increasingly complex and difficult regulatory scheme involving multiple agencies covering multiple jurisdictions. This has promulgated a scenario where many, if not all, issues raised thus far have been regulated in one capacity or another. I will now turn it back over to Chris McGowan.
Thank you, Ms. Fanning. As stated earlier by the AG at the beginning of this rulemaking, the basis for this rulemaking lies in the March 2023 letter from the governor making certain directives and 3 pieces of associated legislation that were signed into law. Collectively, this action required that the commission work with CDPHE together to develop rules to reduce nitrogen oxides, NOx emissions from upstream oil and gas operations, adopt environmental best management practices addressing ozone, to prioritize the development of an environmental best management practices program aimed at incentivizing operations, demonstrating industry-leading environmental performance, and promulgate rules that evaluate and address the cumulative impacts of oil and gas operations. Much of this was codified within Article 60, the Oil and Gas Conservation Act. The cumulative impacts rulemaking is being undertaken pursuant to Article 60, the Oil and Gas Act. The Act provides the authority and basis subject to the APA for the proposed cumulative impacts rules. However, one concern we have is that not all relevant statutory provisions are being adequately considered. Colorado Revised Statutes 3460-106 2.5a, which was modified via Senate Bill 181 in its original form, states that in exercising the authority under Article 60, the Commission shall regulate oil and gas operations in a reasonable manner to protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources. The definition of minimize adverse impacts being provided for in 3460-103-26 is to the extent necessary and reasonable to protect public health, safety, and welfare, the environment, and wildlife resources. As stated in the governor's letter, the rulemaking was taken not only pursuant to, but subject to the statutory text of Article 60. In other words, we believe all of the applicable statutory provisions are relevant. Therefore, we believe the baseline established in Senate Bill 181, as I just stated, of necessary and reasonable applies to all powers exercised under Article 60, which would include any rulemaking undertaken by the Commission, such as this one. We believe the applicable interpretation means regulations governing oil and gas operations should be reasonable in character, promulgated in a reasonable manner, and should be only implemented to the extent necessary to protect public health, safety, welfare, and the environment, by avoiding adverse impacts from oil and gas operations and minimizing and mitigating the extent of severity of those impacts that cannot be avoided. When read as a whole with appropriate context, the statutory provisions indicate that the rules imposed by the Commission are subject to certain statutory limitations. We believe the applicable definition of necessary aligns with that of Black's Law Dictionary, which is, quote, needed for some purpose or reason, essential or that must exist or happen and cannot be avoided. We also believe that same definition applies to the term reasonable. Reasonable is defined in Black's as reflecting good judgment, fair and proper under the circumstances, rational, sound, and sensible, or within sensible or rational limits, not excessive. I would now like to turn it back over to Ms. Fanning for some more substantive data to support our findings.
Thank you. We believe it's important to note the context around permitting. It has been suggested by certain parties that oil and gas development in Colorado is exploding, and that there's a basis to impose regulations that would consider unlimited growth in the expansion of the oil and gas industry. However, this slide suggests the truth is actually quite different. Permits, locations, and wells are not, in fact, increasing or growing at an exponential rate. In fact, it would appear that the approved permits, locations, and rigs are substantially down year over year. Additionally, as the mandate is to decrease emissions, and if the argument is that oil and gas is a substantial contributor and that emissions from the sector alone should be decreased, the projected decrease in approved permits, locations, and development should be considered within the context of this rulemaking. In other words, less development would theoretically also contribute to a reduction in emissions and projected emissions given the substantial amount of additional enhanced special protections that have been committed to above the standards. We believe another important piece of data is that according to CDPHE's Oil and Gas Health Information and Response to Public Concerns related to oil and gas have had a straightforward downward trend since Senate Bill 181 rulemakings commenced. Indeed, it would appear yet again, data proves that the rules that have been previously promulgated have the intended results and address the concerns of the public, and this should be considered when determining what rules are necessary. With respect to air quality, we recognize Colorado has an ozone issue. However, we don't agree with all the numbers that have been represented. We would like to point out that the asthma data is another relevant consideration when evaluating what further regulations or expansion of this proposal are necessary and reasonable. It would appear that based on the state's data, asthma rates in the counties with oil and gas production are actually lower in a few different metrics. While this is certainly not dispositive, it is relevant. And we believe that perhaps the threat posed by oil and gas is not as dire that has been presented over the past several days. Taking into consideration the plethora of rulemakings and the previously articulated progress that has already been made, OJ supports many of the recent changes in the August draft rules. We believe the rules overall represent a step forward as opposed to the June draft rules' breadth and scope. OG supports a future rulemaking regarding permit durations in Rule 311. OG supports the August draft Rule 315 ALA requiring operators to prepare the narrative and the removal of a cumulative impact analysis for all locations. OG supports the removal of draft Rule 316D2. OG supports the August draft Rule 604, striking the changes to the rule in the June 14 draft. OG supports the August draft changes to biological resources, focusing the analysis identified in the 2015 SWAMP and also forthcoming changes expected in 2025. OG does support the role of a community liaison. OG supports a defined impact area with limits of expansion, and OG would request to leave the lesser impact exemptions of Rule 304D as previously utilized. I will now turn it back over to Chris for conclusion.
Thank you, Ms. Fanning. We would note that one pressing concern is rolling back any of the progress made thus far. We believe more than ample evidence exists that any further expansion of the proposed rules would be problematic on many fronts. Further, the OG Society would respectfully ask that specific reference to already submitted permits be included. This has been something that's previously discussed, but we would like to put our support for that on the record as well. This would respect the statutory language of the APA as well as the spirit of the Colorado APA, allowing for operators that have submitted previously submitted their permits under a set of rules that was in place and that they commenced under at the time, and that those permits would be governed under that set of rules that was in place. We believe the statements submitted by other industry parties in this matter are also reflective of a thoughtful and pragmatic approach. Multiple different proposals have been submitted by operators and trade groups alike, and we believe the best approach is one that takes into consideration what is necessary and reasonable, i.e. what is needed and what is reasonable considering all factors, including those past rulemakings and their outcomes and the rules that were promulgated. We believe that the recent draft marks a good step forward, and we believe that our industry partners will further articulate additional considerations that should be incorporated. Again, we would like to thank you for your time, and we would like to respectfully request to reserve the remainder of our time for rebuttal. Thank you.
Thank you both. I'm here. I have family members walking around my room, so I've got my video off. Ms. Fanning, if you could go back to the slide that talked about the number of permits pre-181 versus today. Yeah. So talk to me in a little more detail about this. You had to kind of move through this pretty quickly. But talk to me about talk specific numbers, pre-181, number of locations and wells, post-181.
So let me move over so I can see what I'm looking at. So when you're looking at pre-181, I think what I'm representing here is actually 2021. But if you were to look at prior to January 15, 2021, I would say there was more than double the number of permits were passed routinely, and it was passed at a rate probably more quickly. However, I would state that the public health, safety, welfare, and environment with those things that were submitted not under the title of an OGDP were still that most protective of public health, safety, and environment. I think what's creative now is while we have the most rigorous set of rules, at times in the process, even a minor error in our submittal of our OGDP starts the clock over. It could be a typo, it could be a mislabeling of a map, something very insignificant that isn't specific to public health, safety, environment triggers a significant duration by staff that creates a very big lag. And I think that needs to be considered. I'm not going to state that permits that were submitted prior to Senate Bill 181, because if you remember, we had a limited director's review. So the rules went into place. However, we didn't have forms in place. And prior to January 15, 2021, we had a not regulated temporary setback of 1,500 feet, right? It wasn't 2,000 feet. And we were working off an Excel spreadsheet of what was expected for us to permit under. That was like the beginning of the slowdown, right? But yet you've more than tripled your staff, and we have less permits coming into play. And yet the permits are being approved at a rate of what? 260 days on average. And I think that's just very difficult to operate, because it feels that operators, even though they're operating protective, it's almost like we're being made guilty before we're innocent.
Yeah, and as I look at it, if I'm looking at the slide to the right, the number of wells approved 2017 to April of 2019 was 10,000. And then the number of wells approved in 2021, it was 681, and then about 1,000 in 2022, and then about 1,000 in 2023. Is that accurate?
So yes, and that actually was taken from Commissioner McGowan's presentation on cumulative impacts in the beginning. But remember, the thousands that you're looking at as Form 2s, those are APDs. Or are you looking at location Form 2As? Yeah.
Yeah, and then location.
Correct, in total, and that's total 2017 to 2019. And then
Right.
post is 149.
And where did you get this data? Where did these
This,
slides come
I
from?
believe, was provided by Commissioner McGowan in her, before she started cumulative, we started the cumulative impacts rulemaking. It was done when she introduced the stakeholders group that was put together.
Okay, and if you could move to the next slide that talked about citizen concerns.
Correct.
And we see a downward trend there too. And this, if I read the note correctly, this is information that are self-reported concerns?
This is self-reported concerns from oil and gas health information that's been provided. It's in the CDPHE. If you look at the database for health concerns, whether it's complaints, and then whether CDPHE is called upon a complaint that's filed and does further research on an emissions event. And in that emissions event, then they determine whether it's has a potential to be health related, or if it's non-health related, or if it's just a question about an event. So if you go into CDPHE, they log all of this data, and you can see a significant downward trend, and the blue bars represent non-health related data. And so whether a actual inspection has been commenced or not, and whether it's just been rolled out from a data evaluation from a desktop, that's how I understand the data has been provided. If it's a health related, it doesn't mean that actually someone was harmed. It means there's a potential for a health related incident. One of them, if you look just in the recent years, it was for a particular operations that had an emissions event. And I believe CDPHE's CAMEL was issued. They did a study, and then they determined that the operator's short-lived emissions event was due to a particular type of practice occurring. And that's what increased the emissions, and additional BMPs were put in place to control that single event.
Okay, thank you very much for going back through that. I find the context helpful. Commissioners, we have a panel that is available for additional questions. Commissioner Messner.
Thank you, Mr. Chair. Thank you for the presentation and the data that's provided. I also think it's good to look at the data and try to better understand kind of where we've come over the last few years. I did have some questions about the data, though. In your opinion, I think that table it's a little hard to read, but 2010 to 2023 or 22, is that right? The table that shows the number of kind of the decline curve of permitting.
Yes, sorry, I have it on a much smaller screen. I have to move over to reference it.
Am I right?
Correct, yes, 2010 to 2023.
Great, okay. And just so that we're comparing apples to apples, the permits, either location permits or the Form 2s around, let's say, 2010 to even up to 2017, and in your opinion, how many of those were single vertical wells, individual locations with one well versus multi-well pads with horizontal wells?
I don't have that information readily available to do that comparison to you. I can tell you that I'm probably the only regulatory company that has handled OGDPs before you for single vertical well development. And there hasn't been that money out of the, let's see, 13 OGDPs I've had in front of you.
I'm talking about more towards the beginning of that chart.
In the beginning, if I were to guess, Commissioner Messner, there'd probably be a significant number of wildcat wells that were in that area, but I would have to actually go in and actually speciate that data to provide that to you, and I can do so in rebuttal.
Yeah, that's fine, because understanding that now we're seeing multi-well pads, anywhere from 10 to 45 wells per pad, that are doing horizontals anywhere from 1.5 miles to 4 miles now, and that each individual well on that well location is now covering, I'm guessing here a little bit, but let's say a dozen what would have previously been vertical individual wells and individual well pads per well. So if you've got a 10 well pad, it's potential that that's taking the place of what in 2010 could have been 120 vertical wells and 120 individual locations. And I'm not saying this is accurate. This is what I'm asking that analysis to be, so that when we are looking at these trends, that we really are comparing apples to apples from a permitting standpoint. Now, understand that there's a lot of benefits to horizontal development and consolidation of facilities and those type of things. But I think that sometimes these numbers get a little skewed when you look at the type of technology that was being implemented 2010 to 2017 versus what we're seeing today from a technology standpoint, which will affect the number of rigs that get utilized and the number of permits that would get issued. And so I would ask that if there was data that could be looked at that did kind of make that comparison, I think that would be helpful for me.
Yeah, I absolutely could do that. But I would also then say that, would you state that a horizontal development is less impactful than a single well vertical development in a rural area?
I think it depends on where it is and what it's doing, but I do think that from a surface impact standpoint, the consolidation of wells in a lot of situations could be beneficial, sure. But not, I mean, there's certainly additional impacts when you consolidate those more centralized to the receptors to the immediate adjacency of the pad. So and so that, I think that would be helpful. And so I just want to make sure that if it's possible to get that perspective, that would be helpful. And then I had a question for Mr. McNown. Appreciate your points on the necessary and reasonable, and certainly when I'm reviewing rules, I'm always looking at it through that lens. But the necessary piece, and I appreciate that you bring in the act, but I mean, a question for you is, if this agency is statutorily directed to develop rules on a particular topic, is that necessary for this agency to do?
Well, yes, Commissioner. I think, but those are not mutually exclusive, and I think that's the exact point that we're trying to make. So a court will interpret a statute in collectively, right? We had the law in there. Effectively, it looks at the entire statute, tries to harmonize effectively all the provisions within a statute. So to the latter part of your question, yes, if the legislature says make these rules, then yes, I don't disagree that you notice that rulemaking. But when you make those rules, our argument is simply that needs to be done in the context of the other statutory limitations, which is necessary and or reasonable. So if it directs, I guess the best way to illustrate it would be if it directs you to reduce NOx as it has here, what we're saying is that what we believe is important is that you should go, is the commission should look back and say, okay, what have we already done? What achievements have we been able to get through previous rulemakings, right? What reductions in NOx have we already been able to achieve? What else have we been? I'll give you an example that we did a little research when we were looking through this particular rulemaking. So one of the sources, for example, of methane or greenhouse gases or NOx is in fact a study done for the ECMC that showed that orphan wells were a significant source of leakage, right? And of those of those orphan wells in particular, there was what they called a couple of, believe they called them super emitters, right? In other words, there was a couple of particular orphan wells that leaked at a higher rate than others, right? So a substantial portion of those emissions come from one subset of wells, and then of that subset of wells, another particular subset of those wells is a significant contributor. And so then our point is to say, all right, when you look at that, then you say, what have we done to address that already? And you look at the financial assurance rulemaking, which then addressed both orphan wells, it addressed funding, and created a new program. So in other words, we've done a lot of things to address those particular problems. All we're saying is not that necessary and reasonable prohibits you from enacting statutory mandates. We're saying that when you enact those statutory mandates, such as here, taking all facts into consideration, what we feel as though the commission or that there's a starting point of zero, right? It's always a march forward. It's always the things that we haven't done, or it's always taken in context of we have to effectively do all of these things proactively. We don't believe that there's ever consideration given, and that's kind of the point here of what's been previously done and what we've already achieved, and that those things should be taken consideration as well for necessary. Does that make sense?
Yep, that makes sense. I better understand your argument. So thank you for that.
Sure.
No further questions. Thank you.
Further questions for the panel? Commissioner Oath.
Thank you. So one question, I guess, since your slides are still up, I think it's this the next slide after this that Chair Robbins asked about. I just want to clarify with you, you would agree though that while this is about concerns that folks have self-reported, there's no relationship here with actual public health risk or public health outcomes.
Well, with the exception of the fact that I took it one step further to look at those that CDPHE determined from the concerns that were promulgated to the source, CDPHE, that if they felt that they had to look into it further, those that were looked into further were either categorized as health related or non-health related. So that's where when I looked at the data and said, okay, if something was health related, then did the CDPHE send an inspector out and was something looked into further? I would assume that somehow these data sets got categorized based on that further look.
Okay, but it's not, but still, it's, you know, there's not necessarily a relationship with how many people saw it had health issues. And whether, because what it's disconnected from that in terms of like whether folks called in. I hear what you're saying, and that it's, you know, there was this further look into whether or not their reach out was based on a concern about a health related issue or a non-health related issue, but it's still is disconnected from kind of health risks and health outcomes.
I'll leave it at that. Chris, it's fine.
Okay. And then you talked at the start of your presentation about various ESPs and particularly about electric drilling rigs. And I think you even had like a star at the bottom of it about, you know, these are things that operators have agreed to in times when they're doable, basically. So a number of parties have proposed that there be an ESP to require electric drilling rigs in the non-attainment area where practicable, which I think is, to me, the same. So do you have a concern with that proposal?
I do, because I've actually experienced it. From a permitting standpoint, we had previously for an operator 2 proposed permits that we were considering in development, which consideration for permitting starts far before we submit an OGDP. And in that process, looking just 2 different locations less than 3 miles apart, in one instance, we were capable with a base load study to electrify the drilling rig and provide electrification and production. And just in a short distance away in another oil and gas location, it was infeasible. And so technically we could not electrify that location. Both of these locations were within city limits. And so what I'm representing as well, it's a case-by-case basis. The operator, without the directive of whether it was local government or an ask of the commission, chose to put the enhanced practice in place when it was technically feasible. But if that was forced upon on the other location, they wouldn't have been able to permit.
Okay. But in that's a really helpful example. So to me, I think, you know, if this were adopted with the where practicable, it would require a case-by-case analysis. And so presumably would result in different outcomes for those cases where one, it was feasible and one, it was not. And so would be required in the first case and not in the second.
Correct. And I use technically feasible or where practicable. I mean, in the rules, I think there's certain things that we just need to consider. And in that statement of, you know, electrification is a significant request just across the board, right? It's an ever-changing environment that I believe could potentially be less and less available based on more and more demand to the grid. And I would say where practicable needs to be considered in the rule development for sure.
Okay, thank you. That's all I have.
Further questions? All right, thank you very much. We appreciate your being with us this morning and providing your perspective. Let's take a 10-minute break and we'll set up the next panel, which is TEP operating, and come back at 10:18. We are taking up docket 240600145. And our next case in chief is from TEP Rocky Mountain LLC. Mr. Joel.
Thank you, Commissioner Robbins. Good morning, Commissioners. Michael Jewell of Jewell Jimerson Natural Resources Law on behalf of TEP Rocky Mountain LLC, which is proud to be the largest and most innovative operator in the Piceance Basin of Colorado's beautiful West Slope. I fly solo this morning, though my comments are supported by the full analysis, work, and expertise of TEP's regulatory planning and operations team. As you're familiar from TEP's OGDP presentations, our transparency efforts are spearheaded by our innovative and comprehensive plans of development that you see attached to our OGDPs. And that is presented to the public to clearly track how we unfold our operations, complete with our contingency plans. Therefore, it's in that spirit, we tend to front load our information in order to meet the invitation that Commissioner Robbins offered early in the mission change. That is to enter into conversation. So it's in that spirit that we offer a short respite to the death by PowerPoint in a media-saturated world. We are able to work any language proposals over and above those presented to you in our pre-hearing and response statements. So TEP appreciates the working relationship it enjoys with you, Commissioners, but also with ECMC staff and also with special projects, such as the Produced Water Consortium, wherein TEP's regulatory manager, Jeff Kirtland, whom you know, serves with Commissioner Messner. So we're no stranger to you, but we want to quickly make a few introductory points about TEP's operations and environment that differentiate TEP from what might be an archetypical view from a Colorado oil and gas operator. So it's 4 really quick points. 1, we are a natural gas producer. Most of our sales go for heating. 2, a super majority of our lands are federal, so the royalties go somewhat co-equally to state and federal chests. The federal royalties are distributed between the federal coffers and to the state of Colorado. And that, by extension, means we are co-jurisdictionally regulated by you, primarily for operations, but also the BLM for permitting and also for land management. 3, our drilling is somewhat lower impact as vertical and directional drillings. Yes, there is horizontal drilling that is nascent in the Piceance, but ours is still directional drilling. We use smaller pads, usually recycled pads, and our drilling rigs are high tech that are designed for altitude and terrain drilling. And as you know, we have cutting edge water recycling program that is used basin-wide. And 4, we're in the West Slope. The topography is very much different. The culture in the West Slope is different. And we are integrated with our neighbors. And by neighbors, I mean mostly wildlife and the way we work with wildlife in timing therein. Now, none of this means TEP suggests that we are immune from regulation, not at all. This just colors the way that we approach this rulemaking, just how we approach the mission change rulemakings, the financial assurance rulemakings, and others. You recall in the mission change rulemaking that this conversational approach yielded 3 collaborative language sharpenings that made it possible to forge certain improvements, such as the water recycling program that made our operations clearer on the West Slope. We thank you for those conversations. Happy to report that years later, they have indeed produced fruit. Our perspective means we reflect and will elaborate without hopefully being too redundant to much that you have heard already from WRLG. We thank them for their comments and insights. TEP also broadly supports the positions of the industry group, including COGA, particularly West Slope COGA, while leaving them to their larger discussions that you will hear shortly. And lastly, many comments from other parties you've heard, sometimes from apparent opposition, can actually be, frankly, aligned, supportive, or even helpful to our cause. So we appreciate those. Nobody wants a dirty environment. Everybody wants a higher standard of living, an increased, as we call in public health, quality adjusted life years that come from public health advances. Indeed, the history of public health shows the greatest advances to life expectancy come from 3 things in reverse order. 3, the development of and the access to the broad spectrum antibiotics. 2, the worldwide water hygiene improvements that come about after John Snow's famous Broad Street cholera experiments in 1850s London. And 1, the increase of global public health life expectancy from none other than the global access to increases in clean energy. Of course, this never means we give up the fight to improve and apply growing scientific understanding to defeat negative externalities. TEP does just this by fitting the latest venting and monitoring technology to its wells before it's required of them, quietly, because it's the right thing to do. We are excited, tickled even, to soon announce our new e-frac fleet to you in an upcoming hearing. But suffice to say, energy development and public health can and do go hand in hand, and TEP has not only shown that, but will continue to do so regardless of the rules prodding us to do just that. The TEP's case in chief here will unpack our pre-hearing statement and response statement on the topics of biological resources, impact area, and what we see is a collision of very well-intentioned OGDP and CAP proposals under two recent rule proposals. I'll conclude with a few quick hits and then request my remaining time be reserved for rebuttal in closing. So first, on biological resources, in our pre-hearing statement, TEP requested that the commission strike the once proposed definition of biological resources from this rulemaking. TEP indicated it would be incumbent on the commission to ensure there was clarity in that text to avoid an overly broad definition that would not serve the cumulative impacts purpose for the protection of ecosystems, plant and animal species. Operators, ECMC staff, and other stakeholders equally deserve clarity in working with sensitive species. To that end, staff recognized a few exclusions, as they said, in the previously proposed definition. The use of the words, some of which Commissioner Ackerman suggested similarly to our pre-hearing statement, like other organism, undesirable, nuisance, and invasive, do indeed invite relative and inappropriately inconsistent interpretations. So staff were justified to strike this definition as TEP requested in its pre-hearing statement. We thank you for that. So I want to keep this presentation as a proper case in chief, but also want to collaborate in conversation to say we agree and do not hate Western Colorado Alliance and say, yes, quantitative data is key here. And TEP listed many other sources of quantitative data in our pre-hearing statement that should be taken into account for a proper definition of biological resources. We need to sort through these and apply the hard work of analysis to properly gauge the expertise and jurisdictional application to arrive at the correct legal answer to the statutory mandates. That day is not today. It was not housed in the first language attempt in the definition that TEP respectfully challenged. It just strikes me that after the testimonies you've heard so far, that our point is somewhat ironically made by other parties. A separate rulemaking is not only necessary, but would also be required if we are and must have such a definition at all. There's too much we need to iron out, too much data, too high stakes, not to have a narrowly tailored and well-crafted definition to achieve the specific goal in mind. Collaboration wins. So number two, impact area. Okay, so I want to avoid that potentially tired trope that the peons is different, but I must take a moment to spotlight a few facts that, regardless of the popularity of this position, TEP would like to have on the record for your serious consideration when taking a hard look at a statewide definition of impact area. If our state were somewhat uniform in topography, population density, and land management, then a one-size-fits-all would be efficient. But as WRLG prefaced, the starting point of 1 mile takes its model from the Front Range, and we believe that fairly disincentivizes development in the area of the state where the impacts intended to be examined by such a definition are actually less prevalent. So I will unpack this issue in 3 quick parts: topography, non-attainment, and federal lands. First, topography and acreage. The area of a radial mile encompasses about 2,010 acres of flat surface. Acreage necessarily is biased against the mountainous peons in most cases. For TEP, you would experience significant elevation gains, say if you're in a truck, about a mile before reaching a given well pad. In most circumstances, you can imagine a plat of a random location, and you were to iron out that linear mile on a map so that it were to be flat, you would not have 2,010 acres. You would probably have 2,400 or maybe even 3,000 acres instead. When it comes to issues that affect the land and cumulative impacts, wildlife, building units, maintenance of those lands, et cetera, that's a lot more than what is intended with that 1 mile. CPW and BLM both note this elevation and topography are actually providing built-in protection for wildlife mitigation. Those tree bluffs, the elevation gains provide natural barriers that reduce impacts. I believe it's fair to suggest that it's more than a fair argument. The Piceance receives a harsher brunt of the burden with this 1 mile definition. This isn't the first time you heard this. We made similar discussions in the mission change rulemaking. We're just raising them again here. It's difficult to bear a statewide rule since the Piceance is not in non-attainment, avoids population density, and Piceance operators are essentially programmed to avoid wildlife timing restrictions, especially TEP with our federal lease stipulations. But again, this statewide 1 mile starting point would be a front range presumption punishment. TEP asked for a 2,000-foot starting point instead of the 1 mile, but we are open to working with you on something that would work with the west slope, understanding and open to the director always having the ability to change that if we are not dealing with these presumptions, which I've colored for you here. So number 2, the impact area is designed for non-attainment. Now, Jewel, you say, all right, I might stipulate your argument as to land. I get that, but it doesn't hold as much weight when it comes to air. Air is not limited to topographical or acreage problems. I got you there, but fair enough, I'll say. Touche. I welcome that proposition. But TEP does not believe that's the whole story with impact and air. The problem is that the default 1 mile radius is still coming from 2 problems that originate from other sources: EPA non-attainment and high density population DI communities. We put aside the issue of DICs for now, as TEP agrees with the comments made by WRLG, but I just want to put a finer point on the rural nature of the Piceance and remind the commission of what you know, that we operate in an area that is not in a non-attainment area. If Colorado were not in a non-attainment problem at all, then I doubt we would have a 1 mile starting point. So it seems logical to me that the Piceance would then not have that basis without any interjection. So furthermore, in latching with Ms. Trask's example of co-emitters such as the cement plant example she used, we have fewer points of emissions that would qualify as co-emitters like cement plants and similar, that would cumulatively magnify sources of potential emissions. We don't have as much industry here. The Piceance is home to many, if not mostly, relatively remote oil and gas locations. Horizontal development is only nascent, and TEP does not want the Piceance, especially choice locations that are actually away from population centers and wildlife centers that are not governed by restrictions that keep us away from them during their migration corridors, when other regulations that are tailor-made will achieve those purposes intended by you and the legislature. So having gone over acreage and non-attainment, lastly on impact area, federal layers of protection. We know you are well acquainted that we have most of our lands that fall under the jurisdiction of the National Forest Service or BLM, and those lands are governed by resource management plans. Those resource management plans are planners' dream documents because they take into account so many subject matter experts and a significant amount of time, public comment, and feedback that ensure each and every facet is taken into account. Each impact is taken into account. TEP and other operators thrive within these RMPs. They're our guiding documents. They help us secure permits with BLM as our co-jurisdictional authority. So therefore, given the comprehensive nature, we believe ECMC staff was correct by adding federal agency to the pre-application consultation process to rules 301 F1 and 301 G. We envision that ECMC staff can easily apply the same data, information, and deference to the BLM and NEPA processes implicated in the BLM's decision-making scheme when evaluating cumulative impacts under 301 G1C, which would instill a collaborative spirit and confidence among operators, BLM, and ECMC permitting staff. Therefore, TEP encourages this confidence to continue into the definition of impact area so that the Piceance Basin is properly recognized as distinct from the Wattenberg, yet comprehensively understood, studied, and implemented by NEPA and relative RMPs that not only protect but assure public health, safety, welfare, the environment, and wildlife resources despite the topographic challenges imposed in the basin. So having gone over biological resources and impact area, permitting, my last big point under rules 311 and 314. So I want to say Tara has enjoyed working with you over these past several years and getting a number of OGDPs improved, including several firsts. We welcome previously proposed change to the permit lifespan in Forms 2 and 2A in the first round of rules in 311B to 4 years. And given that proposal has been removed to a future rulemaking, TEP anticipates that we will continue to apply for OGDPs in the foreseeable future, just as we have been. Although we hope that the future rulemaking will look at that 4-year program, because that is a tool that is fantastic in the Piceance for wildlife migration mitigation. But Commissioner Robbins, when you held that stakeholder meeting a few months ago and asked for operators to brief on the cap issue, we thought this would be a great time to informally discuss our thoughts and experiences on caps. A few times after OGDPs, Commissioner McGowan, who's no longer here, we're not going to say anything bad about her though, so not here to defend herself, but somewhat jokingly, Mr. Kirkland and I would say, what are we going to say this time when asked if TEP is going to file for a cap? And we would parry around that. And the cap wasn't always the best idea for Tara for numerous reasons, but we would give it serious thought and consideration. And we would mull that idea and we would ponder what answer to give when asked. But the more we mulled it and the more we considered how much we looked at BLM's master development plans that we are thoroughly entrenched in, and we decided to go for it. And my client has authorized to tell me we have been working hard, not only on 1, but 2 caps in our area. Frankly, until this series of rules came out, because we're at a bit of a clash right now. We thought the first idea with the OGDPs, with the 4-year extension and the way it can help us work around wildlife was a big plus. But then the caps we were working on seemed like a good way to go. However, it seems like those requirements for operators to take the additional steps in the pre-application consultation, the filing of the maps with the proposed utility lines and the transmission lines in the substations, that's actually a little more difficult than it might seem in the Piceance, because, again, looking at Tara and our supermajority federal lands and the process it takes to get new generation lines out to where we are, it creates environmental havoc more than you might realize to get lines up into the mountainous terrains. And on balance, that creates a lot more disruption for wildlife and for streams and other terrain than I think we're going to get on the benefit. So it's making the once Cadillac and preeminent planning tool that we would like to otherwise use, it kind of tilts it on the other side a bit. And so if there's a way that we could work with you and with staff to maybe work around this and get the cap to work again, that might be something we can get back to work on. So we don't suggest any malevolence on staff's part by this means, but similar to impact area, the rules are skewed in a manner that it's not taking into account the peculiarities we have in the Piceance. So that's what I have on my big 3 points of biological resources, impact area, and permitting. Just a few quick miscellaneous points is the ongoing discussion that we have with defer versus consider. Just legally, it's just a strange evolution we have, this discussion back to the Bowe and Edwards days for the lawyers in the room with who has jurisdiction and whatnot. I'm not going to rehash that. It's just strange about who's arguing what these days with authority. I think Tara's in the camp. Defer is the way to go, but we do admit, to be intellectually honest, that that does mean there's a strange cart before the horse sometimes. You know, if we have to wait on the county before, or the municipality before the ECMC, and that could be problematic. So we do admit that, but it does seem like the conversation might be going in a way of, well, can it be defer minus or consider plus, if you will? Maybe there's a way that we can craft language around that with interested parties. I don't know. So I just want to throw that out. And lastly, I just think there's something that needs to be said about the conversation around permit denial. Tara does believe that commissioners are doing a great job around considering OGDPs, and we thank you for that. The logic about permit denial might be accurate if the rules never had changed and commissioners had only changed hands, and we were just going about business without any new discipline. But the fact is, there are new rules, there's a new discipline, and operators have put their arms around that new discipline, and everyone is putting together new plans that make sense and are purpose around the new policy that is in place. I know even internally, we've had other operators look at TEP and say, well, those are getting approved because they're simple. They're not simple. We take a hard look at our lands and say what makes sense and what complies with the rules, and we bring that to you. And that's what I believe all my colleagues are doing, all other operators are doing. We are taking those hard looks ahead of time, and that's why things get approved. And we thank you for that, and thank you for being a collaborative partner. So on that, I would like to reserve the rest of my time, and thank you for your time and consideration, and we'll welcome any conversation and questions.
Thank you, Mr. Jewell. On that last point, talk a little further about the new rules, new discipline, taking a hard look ahead of time. What do you mean by all that?
Well, that being said, I mean, I'm not trying to say regulation's always easy. Let me not take it that far. I'm not saying it's not difficult and it's not growing pains. But for instance, when I'm working with, I'm gonna keep picking on Jeff because y'all know Jeff. A lot of our work is on the front end. We're looking at plats and maps and saying we have these 3 options. And what is going to make the most sense for public health, safety, welfare, the environment, and wildlife resources? And under the rules we have now, maybe under the previous regime, we would have gone for project X, but now we go for project Y because this is what makes sense under these rules. And maybe it's going to require an ALA, and that's fine. We will do the hard work of the ALA, but it just changes the mindset, and that's what rules do. It's almost like disciplining children in a way. We're not children, but if you're going to take things a certain way, you go down those guardrails, and those guardrails mean you're going to take a certain project over another. And all of my clients have had to go down those paths and make those hard choices. But the public doesn't see those hard choices, and everyone has to make those difficult decisions.
On the question of defer versus consider, you suggest that your client would think defer might be better, but you can see that creates problems at times. Does the creation of or insertion of the SBP language around consider, does that help?
We're looking at that right now. I think I'll have a better response for you in our closing statement, but it may. I think it's simple for us because we typically are working with Garfield County and we have a wonderful relationship with them, and timing usually works. It doesn't mean it always will, but we have to speak with industry as well. And in working with industry on this, they don't always have that luxury. So I just want to be careful there and make sure I'm looking at that SBP language and reporting back to you then. Okay, we'll look forward to your response or rebuttal or closing on that point. It's something I'm interested in. And I look forward to hearing about the EFRAC fleet from TEP that you dangled out there. Yeah, the next month or so. Yes, sir. We got a few presentations lined up soon, so look forward to that. All right, great. Commissioners, the attorney is open for questions. Well, we're not seeing further questions. Thank you very much for your presentation. Thanks for your time. All right, next up is Evergreen Natural Resources. I believe that's Mr. Lepore. If we could elevate him, we'll try to keep moving.
Good morning,
Mr. Joy and Mr. Lepore. You are recognized.
Thank you, Mr. Chairman. Good morning, commissioners. This is Matt Lepore on behalf of Evergreen Natural Resources. With me today is Michael Joy, the President and Chief Operating Officer of Evergreen Natural Resources. We appreciate your close attention to these proceedings and your thoughtful questions, and we look forward to more of both. I would like to give a shout out in particular, appreciate the staff's hard work, and in particular the work of Elias Thomas, the hearing manager, and Jana Jacobs, the hearing officer, for their very professional and responsive approach to herding a lot of cats and keeping the trains running on time in the right direction. Let me share a screen. If I can find the right one. Okay, you can see the screen now.
Yep, it's up and running. Thanks.
Very well. And with that, I will turn it over to Mr. Joy for his testimony.
Thank you this morning, commissioners, for your time. Wanted to come here personally because I think it's important that the commissioners hear from the decision makers of some of these companies, particularly ones that are operating outside of the Denver, Boulder, Front Range community in rural Colorado. Like TEP. Oh, I'm going to ask Mr. Lepore to move to slide number 2 for me because frankly, I don't have that technical capability. Like TEP before us, Evergreen operates in a rural portion of Colorado. We operate in Los Animas County, Colorado, and we have for 25 plus years. And as the commissioners know from other matters where I've been before you recently, we intend to do so for another 30 or 35 years. But I'm concerned about how these potential rule changes will adversely affect our operations and frankly, the community that we operate in. As you already know, Evergreen, I think, is the 7th largest operator in the state by well count. All of our wells were drilled and predated Form 2As and OGDPs. That does not, however, mean that when these wells were sited, we didn't take into consideration, and the Los Animas County didn't take into consideration, many of the same concerns the commission now appears to be getting to relative to the Front Range. I want to give you our perspective on that, and frankly, our perspective on what it means to operate in a DI community, because our impact is substantial. About a week ago, I had an opportunity at the invitation of the Los Animas County Board of Commissioners and then with the Trinidad City Council to give them an update, as we somewhat frequently do. We were talking about Evergreen's impact on the community, on the DI community, and some factors I want to give you. 1, Evergreen is the backup emergency coordination center for Los Animas County. So in the event of an emergency, if their facilities are not operable, they come to us and we provide that service to the whole of the county. And it's been used before. Evergreen provides the predominant water source, not the exclusive water source, but the dominant water source for wildfire suppression west of I-25 to the Continental Divide. And that's because of the amount of water that we produce in the course of our operations. Evergreen maintains, depending on how you count it, 1,000 to 2,000 miles of county road west of I-25. Now, when I say how you count it, some of that's because it's wholly private to us to access well sites, but much of it, as you heard in other forums, is multi-party road. Some of it is county road. In fact, quite a bit of it is county road. By way of comparison, CDOT manages 9,000 miles of road across the entire state. So our impact, our ability to manage that road in Los Animas County is fairly substantial. The list can go on, but I want to put in one more factoid about our impact to the community. In 2018, we were asked to meet with the Los Animas County Sheriff. And when we did so, the sheriff pointed out that they have the largest county by landmass, and at that time, and it's probably still the case, the youngest department in the state. And their vehicles didn't have GPS units. And they couldn't afford them, and the state couldn't afford them. So Evergreen provides them. We provide them, I think, to this day, although this sheriff may have been able to pick it up. His concern was then he was sending some young deputies in single occupancy vehicles across the largest county in the state and didn't know where they went. So we stepped in to provide them. The list of things that we do like that for our community. And the list of things that other rural operators, whether it's in northeastern Colorado, whether it's in the Piceance, across the state, we're called upon in the communities that we operate in to provide those kinds of services and work with the county. It's not a technical issue that you would typically deal with in a rulemaking. But if you're going to talk about the impact that we have on DI communities, those types of impacts need to be considered. We have no plans to drill new locations, and to the best of my knowledge, we haven't put in a new location since 2015. But we do have an extensive and ongoing well, either recompletion, or restimulation program, again, depending on the definition. We've recompleted or restimulated over 1,000 wells in the last 5 years. We put in new capital of $10+ million a year to do that, in addition to the cost of operating the field, landowner royalties, etc. About 1.5 years ago, the state made a significant investment into Los Animas County. So significant that the governor actually showed up to announce that the state was committing $20 million to buy the Crazy French Ranch to create Fisher's Peak State Park, largely to be used as mountain biking, terrain, and hiking. That $20 million investment brought out the governor. Every year, my company makes about a $200 million economic impact on Los Animas County, 10 times the investment that brought out the governor to our county. That's the kind of impact that we have. In a very rural, sparsely populated state. As TEP discussed, they also operate in a rural area. I'm not even sure it's as rural as us. There's only 3 persons per square mile in all of Los Animas County. So the whole county is actually a DI county. When you look at the hundreds of square miles that encompass Evergreen's operating area, our population density is 0.4. And south of Highway 12, we recently did a calculation, and there's over 100 square miles of area that has absolutely no permanent residents whatsoever. So when we look at some of the rules and how they would be applied to this county, and it's the same again for other operators in other parts of the state, their circumstances will be unique to them. But we have to find someone to impact. Mostly the impacts that we have are impact on wildlife. And that 1.5 million gallons of water a month that we put onto the ground sustains that wildlife. Also sustains critical wildlife habitat, let me say better. Also provides water resources for the domestic cattle operations that are going to go on in the state as well. Mr. Laporte, could you give me the next slide, please? Our predominant concern with this rulemaking actually relates to rules 308 and 312 and the vagueness and the uncertainty associated with it. As I said, depending on the definition, if there is one ultimately adopted, that could impact over 1,100 wells in the last 5 years for Evergreen. And it appears as though at a minimum, it would impact the recompletion program that we talked about extensively with the commissioners, where we have done and plan to do 50 to 100 nitrogen foam restimulations every year as we go forward. We've done over 160 of them in the last few years. There's no definition that we can find of recompletion in the rules. There's none that's been proposed that I'm aware of. But in the absence of that, it appears as though the director has unfettered discretion to decide at any point in time that we'll have to do a cumulative impact. It's not that I'm opposed necessarily to doing a cumulative impact. But for the most part, Evergreen did that 20 years ago, long before the concept of cumulative impacts and OGDPs were put forth by the commission. Los Animas County has had an oil and gas regulatory professional on staff for over 25 years. We and our both predecessor and successor, Pioneer Natural Resources, worked closely with the county. Most of the commissioners here have in fact toured our operations to see how we sited wells and how we drilled wells to fit into the topography, to fit into the geography, to take into account landowners, their rights, their wishes, their desires. how we mitigated noise. For example, we bought all the land surrounding our compressor stations. We meet all state and local noise ordinance, but of course we bought the land around it to minimize our impact. We were doing these things 20 years ago. So apparently I've hit my 10-minute mark, but I want to conclude that 10 minutes and open up the questions to point out that we were doing these things years and years before these new rules were to come into effect. And we're concerned that the vagueness in the new rules and the application of them may adversely impact the very things I think you're trying to accomplish.
Does that conclude your opening presentation?
It does, Mr. Chairman.
All right, so you're reserving the rest for rebuttal.
Yes, please.
That's great. The panel is open for questions. All right, I'm not seeing questions at this time, so we thank you for the presentation. And we will continue. Next up is Laramie Energy, Karis Piance LLC, and Fielding Hill LLC. Why don't we take, that's a number of folks in 30 minutes. Why don't we take 5 minutes and return at 11 a.m. September 9th, and this is the Energy and Carbon Management Commission's continued deliberation on docket 240600145. At this time, we are going to hear from three parties: Laramie Energy, Fielding Hill, and Karis. Who is taking off? Ms. Hill?
Yes, thank you. And if Chris, Katie Middleton, and Doug Dennison can turn their cameras on. Perfect. Thank you. Thank you, commissioners. I'm Holly Hill. I'm here with Fielding Hill, and apologies for my literal snottiness. I'm getting over COVID. I am here representing or advocating for Laramie and Karis. Let's see this PowerPoint working. Okay, sorry for that. Today, the parties have joined together in this rulemaking and have a general position to support protection for marginalized communities, as well as supporting cumulative impact assessments for reasonable impact areas. Today, you will hear from Doug Dennison regarding disproportionately impacted communities definition versus the cumulatively impacted community definition, in order to find a definition that will not preclude operators on the West Slope from endeavoring best management practices. Next, you will hear from Katie Middleton with Fielding Hill, requesting the reinstatement of Rule 304 b 2 Big A and B regarding the alternative location analysis criteria that incentivized operators from citing locations in 10 critical areas of concern. Next, I will discuss further the deference to the BLM NEPA process in regards to the ALA process. And lastly, you will hear from Chris Clark regarding the reinstatement of the June 14th, 2024 draft Rule 311 that provided very attractive incentives to operators permitting oil and gas development plans. Those incentives would provide Karis and Laramie immediate relief in their permitting endeavor. I will now hand it over to Doug Dennison.
Thank you, Holly. Doug Dennison, Senior Regulatory Manager with Karis Oil and Gas. I will continue. First, I wanted to start off by thanking all of you for your efforts during this rulemaking. I don't envy the position that you are all in to try to synthesize all the information that you've heard so far and will continue to hear during this rulemaking process, and then formulate some final rules that try to address the concerns. I will try not to repeat a lot of what you've heard from other presenters. I think the WRLG that spoke last Thursday did a great job of outlining some of the concerns on the use of the DIC designation in Western Colorado and frankly in other rural parts of the state, as you've heard this morning from the previous two speakers. But I do want to provide some additional context We believe that the use of the DIC designation is a too blunt of a tool to be effectively used in the Piceance specifically, but probably in other rural parts of the state. I will also go where Mr. Jewell said he did not want to go, and I'll clearly say that the Piceance is different than the DJ. I've been fortunate to have spent 10 plus years working in each basin, and they are very different, whether it's from just the sheer population, from non-attainment, and I'll talk more about how the DICs are designated and just the makeup of the DICs being different, the type of development, the horizontal wells versus directional wells that we do in the Piceance. There are a lot of differences, and I know it's a challenge for you all to come up with a solution that fits, but there truly is not a one-size-fits-all solution to this issue. So our position is that potentially the CIC, or the cumulatively impacted community designation, may be more appropriate, or retaining a lot of the flexibility that's in the existing rules that allow ECMC and CDPHE staff to tailor their assessments of particular areas based on the specific circumstances present in that area. In my experience, CDPHE staff has done a great job of developing and applying practical and common sense solutions during consultations that are required under the existing rules when you're operating in a DIC. And I think that may be a good option for how we continue going forward. Next slide, please. I'm not going to spend a lot of time on this slide. All it's showing is that whether we use the DIC designation or the CIC, that functionally the process that we would be required to go through as an operator is the same. Next slide, please. One of the things that we did want to point out, and I know it's not the topic of this particular rulemaking, but how this commission decides to implement the DIC designation in Western Colorado could set a precedent for how this issue is ultimately addressed in the upcoming produced water rulemaking. And one of the significant unintended consequences of the application of the DIC designation to operations on the West Slope is the language in House Bill 23-1242 that specifically prohibits new centralized produced water storage or treatment facilities in the DIC. The Piceance has historically, for many decades, recycled and reused a lot of the produced water. It's an integral part of all of our operations. It allows Caris and other operators to significantly reduce the amount of fresh water we use for our development. In addition to conserving fresh water, these facilities are critical because of the terrain issues you've heard from other speakers and other consideration that necessitate that these facilities are in proximity to our development operations. If we were required to site such facilities outside of a DIC, which I'll show you here on a map, would be impossible or very difficult. It would prohibit us from being able to transfer water to and from our new development via pipelines, which would result in a significant impact or a significant increase in truck traffic and the impacts associated with that, and likely would have an unintended consequence of putting more emphasis on using fresh water than recycled water. And just for context, of the water that Caris typically uses for new well completions, 80 to 90% is recycled water. Our ability to build recycling facilities near our operations allow us to pipe the vast majority of this water to and from the locations, eliminating tens or hundreds of thousands of truck trips. Additionally, Caris owns a significant amount of water rights in Western Colorado, and our ability to recycle and reuse this produced water has allowed us to contribute billions of gallons of fresh water released from Rudai Reservoir for conservation purposes, such as maintaining downstream flows for threatened and endangered fish species. Next slide, please. This slide shows the DICs that are designated throughout Colorado and the population in each of the counties. Because the way DICs are designated, they're based on census tracts or blocks, and that process defines that all census tracts or blocks have the same range of population regardless of where they're located. It just fundamentally leads to these DIC designations in Western Colorado and other rural parts of the state being much larger geographically than they are in the DJ and in the more populated portions of the state. And as a result, most of the DICs in Western Colorado and in the Piceance Basin specifically are very large geographically and also very sparsely populated. For example, approximately 85% of the population of Garfield, Mesa, and Rio Blanco counties and about 70% of Moffat County live within the municipalities within each county. However, there's little or no oil and gas development currently taking place in proximity to those municipalities. As you've heard from other parties, OGDPs from the West Slope, the proposed development within 2,000 feet of an RBU, regardless of whether it's in a DIC or not, have been very rare. To date, there's only been one such OGDP since the mission change rules took effect. We fully support the existing requirement for obtaining informed consent from residents when a location is proposed within 2,000 feet of an RBU, a HOBU, or other designations, and believe that the existing requirement adequately addresses the situations that will occur on the Western Slope. In addition, with the exception of some very limited areas designated as CICs in Mesa and Delta counties, the EnviroScreen scores for areas designated as DICs in Northwest Colorado are relatively low when compared to DICs in the DJ. Many of the EnviroScreen scores for the DICs in the northwest corner of the state are in the single digits or the low teens, so they're very low EnviroScreen scores. Most of these DICs are also designated solely based on the low income factor. And I would also argue, as you heard from Mr. Joy in the previous presentation, that oil and gas development in these counties provides positive benefits for residents that meet the low income threshold in the form of tax revenue that provides local government services, funding for schools, fire districts, and other quasi-governmental jurisdictions, and lessens the overall tax burden on all residents. Next slide, please. This slide just shows areas that are currently designated as CICs within the state. And as you can see, they're very limited in Western Colorado. And I'll talk more about that here in a few minutes. Next slide, please, Holly. This slide just takes that DIC map and then superimposes the well dots from ECMC's GIS system showing where wells currently exist relative to DICs, and then also the estimated population within 3 of the primary oil and gas producing portions of the state. As indicated, there are a lot of wells that currently exist in DICs in Northwest Colorado. However, as I discussed previously, a lot of these areas are located in areas that are large or very sparsely populated, very rural. Additionally, much of the DICs in these counties, particularly in Rio Blanco and Garfield counties, are federal surface managed by the BLM or the Forest Service, and those areas are not inhabited. Also, much of these areas are also large private holdings, many held by oil and gas companies such as Caris, with no permanent residents. As Holly will touch on here shortly, we believe that ECMC should defer much of the analysis required for new locations to the NEPA process that we have to complete whenever there is a nexus with federal surface and/or minerals. Next slide, please. And this slide is just the CIC map again with the well spots superimposed. And I know at this scale it's hard to see, but if you were to zoom in on the areas in Mesa and Delta County more closely, you would see there's very little development that occurs adjacent to those CICs. As I said, our recommendation is that the CIC might be a better alternative. However, to be completely honest, I think this map shows that maybe that is not the best approach for Northwest Colorado, since CICs are very limited. I think potentially retaining the flexibility for ECMC and CDPHE staff to analyze every proposal and the surrounding circumstances in that DIC separately to come up with the most common sense approach is probably the best approach and will have the most impact. Thank you for your time, and I will now turn over the presentation to Katie Middleton.
Greetings, Commissioners. My name is Katie Middleton, and I am the Planning and Permitting Manager with Fielding Hill LLC. I have 15 years experience in local, state, and federal permitting, environmental compliance, and land use. I've lived on the western slope of Colorado since 2006. I'm testifying today in support of the reinstatement of the Alternative Location Analysis, ALA, applicable criteria pursuant to Rule 304B2B and 304B2A in the current 300 series. The draft rules proposed on June 14, 2024 suggest the removal of the 10 ALA applicable criteria, which plays a vital role in guiding operators in the selection of oil and gas locations. These criteria, introduced in 2021 rules, have been beneficial in providing valuable guidance during the current OGDP and Form 2A permitting processes. They assist operators in avoiding sensitive receptors when siting oil and gas locations and offer incentives for choosing sites that do not require an ALA. Furthermore, the ALA applicable criteria effectively categorizes locations into two main groups, those that necessitate an ALA and those which do not. This classification simplifies the process and helps operators make informed decisions. We also recommend that operators be permitted to request a waiver from Colorado Parks and Wildlife for the ALA criteria if they have completed the National Environmental Protection Act, NEPA, assessment from the BLM. The NEPA assessment, a comprehensive federal evaluation of oil and gas impacts, has been developed and refined over the decades. Given that the BLM is the largest mineral and surface landowner on the West Slope, their expertise should be recognized. Next slide. Due to the steep terrain and challenging topography of the Western Slope, suitable surface locations for development are significantly limited. To comply with the ALA process, some operators in the West Slope must identify potential sites that could theoretically develop target minerals, but are clearly impractical due to steep slopes such as mountainous terrain or canyon walls. Operators often visit the general area of mineral interest and quickly recognize that feasible options for oil and gas locations are severely constrained. As a result, the process tends to be more theoretical, crafted to meet the Commission's current regulations. If a West Slope operator can identify a viable oil and gas location outside the 10 criteria, they would prefer to avoid conducting an unnecessary procedure in order to submit an OGDP. This would allow both operators and ECMC staff to apply more efforts and attention towards cumulative impact analysis. Now, I'd like to turn it over to Holly Hill for the next part of our presentation.
Thank you, Katie. In line with Katie's testimony, today we are requesting that the original ALA rule criteria be reinstated. Both Laramie and Karst request a deference to the BLM NEPA process, where operators have acquired NEPA assessments in advance of submitting an oil and gas location permit. In that process, both Karst and Laramie would like to seek a waiver from the director for the ALA process if CPW concurs with the findings. The BLM has a robust environmental assessment tool that evaluates impacts of proposed oil and gas development on natural resources and human beings. BLM field offices often establish a resource management plan, or RMP, that assesses impacts of oil and gas in a large geographic region. These RMPs are the result of a comprehensive input and evaluation depicted in this 9-step plan, which involves broader public involvement as well as review from the governor of each state. The goal of the RMP is to maximize responsible resource mineral development while fostering the protection of natural resources and humans. RMPs are thoughtful approaches to plan development and can take anywhere from 3 to 7 years to create. Furthermore, these RMPs evolve by way of amendments because they contemplate ongoing and current impact assessments. These RMPs set the stage for the parameters in which the BLM field offices assess impacts on a smaller scale for smaller scale oil and gas development projects. This slide provides a snapshot of the specialist and subject matter experts that are involved in the NEPA evaluation, which assesses all of the subjects the Commission is proposing to be evaluated in a cumulative impact assessment. They are also excellent documents that capture the past, present, and reasonably foreseeable impacts of the proposed oil and gas projects, and the parties request that the Commission defer to the NEPA evaluations when contemplating proposed oil and gas locations. As such, CARIS has been able to seek and obtain director waiver approvals for ALAs because they had a NEPA evaluation provided with the oil and gas development plan that was submitted, and because CPW provided a waiver because they concurred with the findings in the NEPA. Now I will hand it over to Chris Clark. Chris, you might need to unmute.
Thank you, Holly. And thank you, Chair Robin and Commissioners, for giving me an opportunity to present today. Just as an introduction, I'm Chris Clark. I'm the Vice President of Field Operations for Laramie Energy here in the Grand Junction office and in the Peons. You know, I've proudly worked in this industry for 30 years, and 25 of those have been in Western Colorado. My testimony today concerns the draft rule of 311 from the draft rules that were released on June 14th. We noticed when the August 2nd rules were released that the 311 rules as previously drafted were notably omitted. The June 14th draft rule 311 include 3 significant modifications regarding the validity timeframes for Form 2s and 2As. Particularly relevant to the unique circumstances of Western Colorado, these modifications were the 4-year validity period, extended validity duration. 311 provided operators with the option to request a longer validity duration in their OGDP if they knew they had a complex project, and it also allowed for an extension request for the OGDP. The original proposed 311 draft language offered substantial benefit and flexibility for the Western Slope operators, and their omission from the recent draft warrants reconsideration. Benefits of 311 rules for West Slope operators would give West Slope operators greater length of time to conduct pre-production activity, especially when considering West Slope operators can face up to 270 days of wildlife timing stipulation, which prevent activity and operations. 311 B4 would allow West Slope operators to include more than one Form 2A in their OGDP, providing the Commission with a holistic overview of the intended developments. Rule 311C provides the operators a rule-based opportunity to seek extension if adverse weather can prevent operations inside. And we'll show a little more of that as we get further on in the presentation here. Next slide, please. So operators on the West Slope do face unique challenges, which are much different than those in the DJ Basin. So I'm not going to really go into the details necessarily of the slide, but I do think it should be noted that, you know, in the Peons, a high proportion of our acreage, both minerals and surface, our federal acreage managed by the BLM and the Forest Service. We have multi-well pads almost as a common practice these days, with 20 to 40 wells as a standard development program per well pad. Our well pads are very remote and in sparsely populated areas. Most of our regulations are going to focus more so on wildlife and wildlife protections and mitigations. And again, we do have limited seasonal window due to wildlife timing stipulations and weather. Next slide, please. So we put together a couple tables, and I wanted to just go over these real quickly without, again, going into great detail. But Before you is a table showing the duration of pre-production activities without timing stipulation. So this is best case scenario. The first table displays a perfect timing scenario of permits being issued in early May and no weather caused delays. Under this scenario, a multi-location OGDP could potentially be implemented. However, as we know, things never go as typically planned, including timing of OGDP approval and weather, not to mention resource and vendor availability, rig schedules, board approvals, and the list goes on and on. The second table shows a likely scenario at a remote location, oftentimes at high elevation, if the OGDP is approved in October and construction will not commence until mid-May the following calendar year. 7 months have passed since the OGDP was approved before a shovel even touches the ground. Chipping away at the 3-year time frame, the drilling rig mobilizes in July and completes drilling in December. The rig demobilizes in the winter. However, the severity of the snow prevents continuous pre-production operations, which are delayed until the following summer. These delays are cumulative and delays domino the entire process and subsequent pads if it's a multi-pad OGDP. These types of situations do occur and can make multi-OGDP locations very difficult to permit and execute within a 3-year time window. Next slide, please. So this slide is really pretty busy, and I'm just going to summarize a little bit of what we're showing here, but this shows the impacts, that is, of wildlife timing stipulations which are very prevalent in Western Colorado. As you can see from the detailed table, numerous wildlife timing limitations may be applied and possible timing stipulations are in place during optimal weather season. This slide demonstrates some of the unique intricacies that operators must plan for at both the permitting and execution level. If an OGDP is approved in May and construction cannot commence until September due to wildlife issues, drilling activities must halt and resume the following fall. Timing limitations can reduce pre-production operations to a mere window of 3 months out of the year where we can actually operate. Both severe winter conditions and layered timing limitations pose complexities which are challenging to navigate. The draft rule 311B4 rule would allow operators to present to the commission a path forward of a possible timing of multi-location OGDPs in remote areas where severe weather and wildlife stipulations may impact the expected operations. Next slide, please. And I'll just finish it up here. I know we talk about weather, and I think sometimes it's not fully counted, but this is some slides from a recent winter 2 years ago up in the Cascade Creek area where we actively are drilling today. So high elevation and severe weather in conjunction with challenging terrain limits construction activity windows. The construction activity typically can occur between late May and through September, and that window may be reduced even further if we have a big winter like we did here. If the previous winter had significant snowfall and high precipitation, moisture could delay construction activities until mid-June. And in fact, just a caveat on this particular pad that we built up here, we encountered snow middle of August still when we tried to work on that pad. Construction might not be able to occur until fall due to the early onset of winter storms. Limited timing for construction activities with unpredictable weather can halt operations and push pre-production activities into the next calendar year, delaying summer operations for up to 9 months. Severe weather can also prevent mobilization of rig, completions equipment, potentially causing us to miss expiration dates, First and foremost, safety is the company's priority, and weather events like shown in the phone before you can pose a tremendous safety risk. The previous draft 311C would allow operators to request an extension in these situations. That's all I have today, commissioners, and I thank you for your time and consideration. I'll now turn it over to Holly to field any questions. Thank you.
Yes, that concludes our testimony, and we would request any remaining time be reserved for rebuttal.
Great, thank you. Commissioners, the panel is open for questions. Commissioner Cross?
Thank you, Mr. Chair. Mr. Jennison, I have one clarification question for you. You talked about having the director and staff have some flexibility with the DI communities. Could you explain that a little bit further, how you propose kind of the assessment of the application to DI communities?
Sure, and I can explain that based on our recent experience with that process. But typically, if you're in a DI community, you do have to consult with CDPHE as part of the process. What we have found is when we are in a DI community, however, there are no RBUs or other residences, in many cases within miles of the location, CDPHE staff has taken a very common sense and practical approach to those consultations. And they've accounted for the fact that there's no residents nearby, that the impact to people living in that DI community are minimal. And so we still go through the entire process to identify the BMPs that will be implemented, but it's a different process than you would experience if you were in a DI community and there were residents nearby. I think they also recognize some of the other limitations that we have that you heard, I think, from Mr. Jewell this morning, that we don't readily have access to electrical infrastructure that's available in the DJ. So it's very difficult or impossible for us to get electrical power to new locations to power drilling rigs. So I think the process today works very well in these kinds of DICs that are very sparsely populated.
So with the recognition that, especially based on the consultations with CDPHE working currently, I'm curious only because you talked about some discretionary flexibility from the director side. I'm curious how the discretion from the director side would work as compared to some of the proximity proposals that are in the current draft of the rules, the August draft of the rules, talking about not only within DI communities, but within 2,000 feet of an RV in the DI community. Is that something you would support, or do you have something different that you would propose?
Yeah, I think we would support that. And in my testimony, I did state that we fully support the existing rule that requires informed consent anytime you're within 2,000 feet of a residence, whether it's in a DI community or not, and definitely would support that if we are in proximity. I think the preponderance of locations you will see in the peons will not have any type of residence in proximity to a proposed location.
That's helpful. I just wanted to make sure I wasn't getting another proposal in there with some kind of determination by the director as to what the DI's community would apply.
Right. And in all honesty, Commissioner Cross, I think our bigger concern is probably where the produced water piece will go, because as I stated, those recycling facilities are key to our ability to continue to develop.
Completely understand. I appreciate it. Thank you for the presentation.
Thank you.
Other commissioners with questions? Commissioner Essner?
Appreciate the presentation and the considerations for the Western Slope and the rural parts of the state. And I do acknowledge that there are different activities and different challenges and different applications scenarios in different parts of the state. And I think that's appreciated. Although I did want to just clarify the map that you put up identifying disproportionately impacted communities, was that only statutory defined disproportionately impacted communities, or did that include Justice 40 communities as well?
Thank you for the question, Commissioner Messner. It's just the whole entire May 2023 mapping layer. So it did include all of those tiers that you're questioning.
Okay. So in application of the rules as proposed, it would be slightly different than that. Is that correct?
Yes, with the CIC inclusion, yes.
Okay, and the Justice 40 piece, right?
Correct, yes.
Right. Great. And then understanding the challenges of the statutory language that does prohibit some issues with, or prohibit the centralized produced water treatment facilities or storage. Do you bring that up in this rulemaking because you think that if we, because my understanding at least, and so this is a question, is that is in statute, in a different statute, in HB 23-1242, and wouldn't be, it couldn't be changed by this particular rulemaking because at this stage, that's a statutory directive that utilizes the statutory definition of disproportionately impacted community, irregardless of what happens in this rulemaking. I'm not sure what your take is on it, but that's my understanding.
I'll take a first crack at that, Commissioner, and you're right. I think it's a difficult conundrum that you're going to face in the produced water rulemaking, and I wish I had the answer. I don't. We just wanted to raise it here because I think from two aspects. One is just to reinforce the fact that the DI communities that are designated and the peons are very different than what you see in the DJ, but also just to hopefully if you can come up with some creative ways of addressing the DIC issue as part of this rulemaking, it might lead into the produced water rulemaking, but I honestly don't know how that legislative mandate's going to be resolved in the produced water rulemaking.
And if I may expand upon that, effectively the proposed rules, the DIC and the CIC definitions apply across the board the same. The operators are being compelled to provide the same information, same citing, same notifications. I think we're just trying to look ahead here, and we're concerned that DIC definition being broadly applied would really prevent operators from permitting those water treatment facilities. So we just kind of wanted to set the stage for thinking ahead.
So if I could also just tack onto that a little bit, and it is a little off topic, but I think as we look at DIC, what we've noticed as West Slope operators is most of our areas are DIC due to economic factors. And we feel like we're really up against it, whether it's permitting, we're seeing it in multiple ECMC rules. We see it regularly in CDPH rulemakings. What we're struggling with is most of our DICs are DIC for economic reasons. We provide so much economic growth and opportunity in these communities. We feel like it puts us at a disadvantage as we try to give these communities away jobs and economic prosperity to get out of that DIC designation. I think the way it's calculated, which I know is nothing that could be tackled in this rulemaking or necessarily anything you guys could do, but we certainly see it as a issue in almost every rulemaking we're facing. So.
Right. Thank you for answering my questions. I appreciate it. And thanks for the information you provided.
Commissioner Oath?
Yes, what was my question? Mr. Clark, it's a clarification question for you, I think. So you were talking about the provisions of 311, and it's my understanding those are from the August draft. Staff's intention is not address some of these issues, but to revisit them in a future rulemaking hearing. So wanted to your sense of timing and urgency in terms of kind of having future conversation, robust conversation around kind of some of those provisions that are important to you.
Yeah, I think for us, I mean, it's a matter that comes up. We all have active OGDPs here in the Western Slope, the three big operators, we've got ongoing drilling, and it would provide immediate relief and ability for, more than one location to be assessed at one time. And I think the other thing that gives us pause is, as we understand how busy the commission is, and we're fearful a little bit of just the time, since there's no date set. We have, multiple rulemakings come up, and without having any idea of when those will come up, what the timeliness of that is. And then again, I think I just can't be hit on enough that the June 14th draft just really allows operators to seek a longer time period on their OGDPs, so that it's not duplicating work for the commission and others in these remote locations. It's just, as we looked at those tables and earlier, it's just really difficult for us to successfully accomplish every project in the 3-year time frame. So I think looking for the immediate relief, and again, no certainty when the rulemaking will come up, would be the main items we would focus on with that. We were very pleased when we saw the original June draft and thought that was a positive acknowledgement, I guess, of the difficulties that we face in all of Western Colorado, and the Piceance specifically. So.
Any follow-up, Commissioner Oath? Other commissioners with questions? All right, seeing none, we'll let the panel move on. Appreciate the perspective added to the rulemaking this morning.
Thank you.
All right, commissioners, looking amongst ourselves for next steps. The next presenter is KOGA and API, and they've set aside 175 minutes. I'm wondering if maybe we take a little bit of an early lunch break and then come back to take on KOGA and API. Commissioner Cross?
I think that would be appropriate so as not to break it up. I was wondering, I know we have one shorter one with Prairie. They would be available.
You're breaking up on me.
I apologize. I was going to say, I think it makes sense to take a break if KOGA goes next. But I also know that Prairie has a shorter presentation, so I was wondering if they'd be available to go first. That would be easier.
Hearings Manager Thomas, did you get that?
I did, and I would note that Prairie specifically asked to go after API and KOGA in order to avoid certain duplicative testimony. Obviously,
Okay.
I would defer to Mr. Lepore if he's changed his position on that, but I have not heard otherwise. So,
Okay. Well then let's do that. It's 11:41. Maybe return at 12:30. A little bit more, 44 minutes for a break, and then we'll start up with KOGA and API. Thanks, guys. We're coming back. This is the Colorado Energy and Carbon Management Commission. It is September 9th. It is 12:30, and we're continuing our work on docket 240600145, the Cumulative Impacts and Enhanced Systems and Practices Rulemaking. Before us next is the case in chief from Colorado Oil and Gas Association and API Colorado. I see a whole bunch of folks that are on the screen. Whoever wants to go first, unmute yourself.
Hello, good afternoon. My name is Julia Ryan. I'm an attorney with Braunstein Hyatt Farber Schreck, appearing before you on behalf of the Colorado Oil and Gas Association, or KOGA. Joining me today as presenters on behalf of KOGA are my colleague, Mark Matthews, Christy Woodward, Regulatory Affairs Advisor to KOGA, Jim Martin and Chris Kolkluscher, both with the law firm of Beatty and Wozniak, representing API Colorado, and Dr. Tammy McMullen with CTEH. Anytime we don't use today, we will please reserve for rebuttal and closing. So, Christy, let's go ahead and go to that next slide, please. I'm going to kick things off by discussing issues with the definitions proposed in the August 2nd rules and why requests to change the impact area set by the most recent rules are unworkable. Mr. Matthews will discuss why the June 14th Rule 604 proposal was properly discarded by staff in the latest version. Mr. Martin will discuss why post hoc legislative rationalizations carry little weight, why a requirement to require electrification unless an electric utility provides a letter stating it is unavailable is unworkable and unwise, and why Green Latino's proposal to extend the existing Rule 604 beef siding requirement to 1 mile in disproportionately impacted communities is unreasonable and unnecessary. Mr. Martin will also explain why a no net negative impact standard for oil and gas impacts must be rejected. Ms. Woodward will discuss air monitoring data showing there is no need for the June 14th Rule 604 proposal. Dr. McMullen, API's expert witness, will provide additional air monitoring testimony confirming there is no need for the June 14th Rule 604 proposal. Mr. Kolklischer will discuss why the Enhanced Systems and Practices, or ESPs, in the August 2nd proposed Rule 316C4A should not be required in all DI communities in the ozone non-attainment area. Mr. Kolklischer will conclude with NOx intensity target issues, explaining why the August 2nd version of the proposed rules appropriately remove the ability of the director to take action against all operators, including operators in compliance with their intensity targets. Mr. Kolklischer will also discuss Rule 316 ESPs and how some should not be mandatory requirements. Mr. Mike Paulus of API will not be presenting, but he will be available for questions, and Mr. Martin will return to wrap up with our conclusions. So before I launch into the particular substance of my remarks, I would like to thank the Commission and its staff on behalf of all of COGA and API members for the hard work they have undertaken in this rulemaking. On the whole, the trades do regard the August 2nd version of the proposed rules as an improvement over the June 14th draft rules. To be clear, however, the trades continue to have significant concerns with the August 2nd draft rules. We will touch on some of our concerns in our presentation, but as one overarching comment, we observe that the scope of the proposed rules is enormous. Operators will be subject to pages upon pages of new procedural and substantive requirements. The cumulative impact analysis breadth and depth called for by draft Rule 315B in particular will be burdensome to operators and, quite frankly, we expect for staff too. We urge the Commission to direct staff to issue guidance promptly on the rules you ultimately adopt. Next slide, please. Right, and one more, yep. So I'm going to discuss why the definition of industrial facility is unworkable and the definition of reasonably foreseeable future development needs refinement. The phrase industrial facility needs modification because it's vague. It doesn't tell operators, staff, or the public in any meaningful way what qualifies as an industrial facility. This is a significant problem because ambiguous regulations foster confusion and lead to inconsistent application and enforcement. In recognition of these dangers, the Administrative Procedures Act, or APA, provides that no rule shall be adopted unless, to the extent practicable, the regulation is clearly and simply stated so that its meaning will be understood by any party required to comply with the regulation. The definitions I will discuss do not comport with this APA standard and will lead to delays in completeness, inefficient returns to completeness, and also inconsistencies among applications. It's very possible that two different oil and gas location specialists could come to different conclusions about what the definition of industrial facility means and how to implement reasonably foreseeable development. Next slide, please. So the definition of industrial facility is circular. These types of definitions aren't helpful because the term is defined by using the term itself. Without knowing what these operations are, operators can't possibly define what is an industrial facility. The definition is simply a facility that conducts industrial manufacturing operations. but we don't know what industrial or manufacturing operations mean. The definition does list some examples, and they're helpful to an extent. I mean, dairy is maybe more agricultural than industrial or manufacturing, but the definition is expressly, and we've bolded it here, non-exhaustive. So we really don't know what else would be an industrial facility. A second problem with the definition is that even if we knew what industrial facilities were, it's not clear at all how operators are to obtain information about these uses that they don't own or operate. So for those reasons, COGA strongly recommends that ECMC provide certainty by defining the phrase to mean a stationary source facility for which emissions and/or water discharge permits are required by the state. A facility is an industrial facility only if its permits are available on a publicly maintained website with search functionality. This definition, unlike the proposed one, comports with the APA, and it also ensures that the information the Commission receives about industrial facilities is accurate because the information will be publicly available online. So it remedies the vagueness problem and allows not only operators, but also ECM staff and other interested stakeholders to understand what kind of industrial facilities should be included in a CI analysis. Next slide, please. As for the definition of reasonably foreseeable future development, the definition tracks the statutory definition, which is appropriate. However, agencies are in charge of implementing statutes, and it's unclear how this definition will be implemented. We do know, of course, that the ECMC must act in a reasonable and necessary manner. And to ensure this definition is implemented in such a manner, ECMC should specify in the statement of basis and purpose, or perhaps in the definition, that future development only qualifies as reasonably foreseeable if the applicant has paid all applicable permit application processing fees and the application has been deemed complete by the relevant local governmental permitting agency. Ms. Trask mentioned on September 3rd that it did not adopt the suggestion to require completeness because not all local governments require completeness. That may be the case, but there's an easy fix. We would suggest that the rule or SBP simply state that if the local government process does involve completeness, then the ECMC will also require completeness. These changes will help ensure that the proposed development is not speculative and make it more likely that a detailed description of the proposed project and its timeline for development are available for review. Without a permit application being complete or fees paid, it's ineligible for approval. And it's just less helpful to ECMC because without a development application being complete, it's possible there won't be enough detail for its potential impacts to be assessed or its timeline to be known. We did appreciate staff explaining during its presentation that it intends publicly available to mean available on a permitting authority's website. We think this will increase transparency for all stakeholders. But we did notice that this is not yet in the draft SBP that was released on the 29th. So just mentioning it quickly here to make sure it's in the final SBP. Next two slides, please. So I want to switch gears to discuss the impact area concept. The term impact area is embedded into the definition of cumulative impacts. So I'm actually going to start with that definition. Cumulative impacts are defined pursuant to statute and staff's proposed definition in relevant part as the effects on public health and the environment, including the impacts to air quality, water quality, climate, noise, odor, wildlife, and biological resources caused by the incremental impacts that a proposed new or amended operation regulated by the Commission pursuant to this Article 60 would have when added to other impacts. We have bolded the word would here because it's important. It demonstrates the legislature's intent that the cumulative impacts considered in the analysis not be far-fetched, theoretical, or speculative. The Commission needs to understand what will occur if a project is approved so it can properly evaluate what the cumulative impacts would be. Next slide, please. Turning to the rules implementation of the impact area, The revised SBP persuasively explains the rule's justification. The SBP states, the Commission agreed that the presumptive 1 mile impact area, coupled with the Director's discretion to expand the impact area early in the application process, provided the most predictable and implementable process for its staff, as it reviews and considers cumulative impact analyses while retaining sufficient flexibility to ensure that cumulative impacts are appropriately analyzed and addressed for a particular proposed operation. COGA agrees with the SBP that the 1 mile impact radius allows for a predictable and implementable process, and for that reason is willing to accept 1 mile as sort of a compromise position. I say compromise because there are many impacts from oil and gas that are not felt at a mile, and we believe, quite frankly, that this cannot be reasonably disputed. Later on in this presentation, in fact, our panelists will be discussing air monitoring data that does not show impacts measured beyond 300 feet, let alone a mile. But nevertheless, at the end of the day, the impact area must be predictable and implementable as recognized by staff. A mile distance achieves these goals consistent with the Act's broader mandate that ECMC regulate in a necessary and reasonable manner. And the distance is furthermore consistent with the 1 mile radius that has been required in operators Form 2Bs since the mission change rulemaking. In setting the 1 mile distance for the Form 2B information, the Commission took a conservative approach to set a distance at which operators can actually evaluate cumulative impacts with reasonable accuracy. There is not evidence in the record suggesting cumulative impacts extend beyond a mile in a way that operators can actually evaluate. If information presented to staff regarding a particular OGEP suggests there may be cumulative impacts to evaluate and address beyond a mile, the director can expand the impact area pre-consultation phase, ensuring the operator's analysis is comprehensive, or ask for specific information about a particular use or resource. For example, I think the cement example came up in someone's testimony that would be just outside a mile. Nothing prevents staff from just asking, hey, what's going on with this cement plant? Proposals to extend the impact area or to have the impact area decided later in the process are impractical, unreasonable, and unnecessary. In fact, one COGA member's response statement characterized the proposals quite bluntly but accurately as wildly impractical. For example, some parties suggest that the impact area for climate be the entire state of Colorado. COGA does not understand what this analysis would even be asking for and questions whether staff would have the resources or technical expertise necessary to evaluate climate impacts within the entire state. Next slide, please. Others suggest impact areas that are similarly too broad. As I mentioned earlier, the definition of cumulative impacts refers to impacts that will occur. The greater the impact area, the more speculative and remote the impacts become, which is inconsistent with statute. With respect to wildlife, the proposal to use data analysis units not only discredits the work CPW has done to create high priority habitats, but would also require operators to evaluate areas thousands of miles in size. Impacts at those distances are too tenuous, remote, and speculative to yield helpful information. Any such analysis purporting to cover that large of an area would generate a catalog of data so vast it would not be possible for ECMC staff to assess the information in a meaningful or timely manner. The suggestion to use United States Geological Survey hydrologic codes, or HUC codes, suffers the same flaws. The 12-digit HUC suggested by some stakeholders covers watersheds that are 10 to 40,000 acres in size. But there is nothing in the record demonstrating that oil and gas operations have impacts at those distances or anything approaching those distances. Spills from oil and gas locations are very rare, with most spills occurring from historic wells. In fact, the majority of spills that have occurred in recent years are due to the plugging and abandonment of legacy wells. Spills at new locations are not only rare, but when they do occur, they very rarely leave the location because of ECMC's extremely stringent rules around wellbore integrity and requirements for secondary containment. For example, operators must design secondary containment structures in a way that they contain 150% of the volume that they would be expected to contain. And for locations 500 feet and upgrading of a water body or wetland, tertiary containment is required. These redundancies have been very successful in making sure that modern oil and gas locations do not result in off-location spills. There wouldn't be anything to evaluate in a 10 to 40,000 acre distance. The proposals on this slide would all render cumulative impact analyses that could easily be thousands of pages long, as they would cover tens or hundreds of miles. How an operator could generate this information in the first place is unclear, and then it becomes equally unclear how staff could evaluate it. At the distances contemplated, operators would no longer be discussing impacts that would occur, but just guessing at impacts that might occur. The scope of the cumulative impacts analysis has to be manageable for it to have any meaning and for it to help guide commission decision-making. Impact areas of this breadth would look like environmental equity and cumulative impact analyses that the EJ task force recognized would take years and could not be done by a single agency. Proponents of impact areas this broad say they are asking for a smaller scope, but it's difficult to see what difference is between what they're asking and these larger analysis. Even Earthworks stated in its testimony that the type of analysis it was looking for, I believe, and if I miscite, please let me know, but 2 to 3 years. These are quite long analyses. And then finally, with respect to impact areas, the August 2nd draft gets it right because the impact area would be known early in the process, and this is absolutely critical. Operators undertake a great deal of planning and design work to prepare an application that meets the rules review criteria and scope. If the radius of the impact area is increased by the commission after the director's determination at the pre-application phase, or changed by the director after application submittal, operators would have to restart the application process from the beginning. This would be very inefficient, undermine any sense of certainty, and be troublesome for a functional permitting process. Thank you for your time, and I will now turn it over to Mr. Matthews.
Good morning. Mark Matthews, also of Brownstein, Hyatt, Farber, and Schreck. I appreciate the opportunity to present to you this morning. I will be discussing why it was appropriate for the ECMC to remove Draft Rule 604C from the draft regulations. I will first be discussing why removing the provision was and is consistent with the legislature's intent. I will then discuss why the draft rule really runs counter to the hard-won resolution of setbacks reached in the mission change, and why that framework should remain in place. In removing Draft Rule 604C, the ECMC appropriately followed the legislature's direction. Next slide, please. The legislature demonstrated its distaste for a siting ban on oil and gas activity within a DIC by not passing House Bill 24-1330, which would have created a ban on new oil and gas wells within DICs and ozone non-attainment areas by precluding the issuance of a construction permit. Instead of deciding to ban oil and gas operations in DICs, the legislature took a more measured approach by enacting Senate Bill 24-229, under which, quote, the commission shall administer this Article 60 to minimize adverse impacts that are negatively impacted by oil and gas operations. The mandate to minimize adverse impacts is not equivalent to a ban on development. Prior Draft Rule 604C resembles the failed House bill in that it would ban all oil and gas development in areas in a DIC if an operator is unable to obtain 100% informed consent from residential owners or tenants within 2,000 feet of the proposed development. Now, several parties stakeholders claim that the prior draft rule was consistent with the legislator's intent, but I find their argument unpersuasive. One stakeholder in particular argues that the lack of a legislative siting requirement is meaningless in the Senate bill because it claims the legislature historically has not dictated a specific siting requirement in statute. What the stakeholder fails to mention, however, is that the legislature did consider a specific siting requirement in proposed legislation 24-1330 but rejected it. The legislature had an opportunity to enact a ban, but did not do so. This is very telling. And it's not merely a coincidence that the legislature took actions with the two bills that were different. House Bill 24-1330 died in the House Appropriations Committee at the same time in mid-May of this year that the Senate bill passed through both chambers, was signed by the Speaker of the House and the President of the Senate, and then ultimately signed by Governor Polis. In the coordinated death of the House bill and the passage of the Senate bill, the legislature declared its intent to the ECMC, provide ample protection to residents in DICs without resorting to a location ban on oil and gas operations. Another stakeholder does acknowledge that House Bill 24-1330 failed to achieve passage, but argues that the legislature's rejection of that bill is unpersuasive because that bill was an outright ban, whereas prior draft rule 604C would allow for new oil and gas development if there's 100% informed consent. We can argue about the appropriate label for what prior draft 604C was. But whether we call it a ban, a mandatory siting restriction, or something else, this rule would function as a ban where informed consent is not obtainable, without regard to the Commission's judgment of whether a proposed development will sufficiently avoid or minimize adverse impacts. The point here really is that the prior draft rule switches the ultimate decision maker from the ECMC to a single landowner or tenant located within 2,000 feet of the proposed development. Next slide, please. And as operators who try to secure informed consent will tell you, there are many reasons why informed consent cannot be obtained that have nothing to do with the merits of a proposed project. As Mr. Dean, the oil and gas administrator from Adams County, said on Friday, getting informed consent can often be very difficult, if not impossible, for a bunch of reasons. Residents may simply not focus on giving consent because they have other priorities, including work and family obligations, and are extremely busy. They don't have the bandwidth to participate in the informed consultation process, and they may not live in the community full-time or may not even own the property to begin with. Next slide. Other residents may be nervous about giving informed consent and being seen as publicly supporting the project. The ECMC's informed consent template, which, as you all know, is the preferred form of informed consent accepted by the Commission, tells the individual that, quote, this letter will be included in the application materials and may be made public. Stakeholders may not want to be associated with a project in their neighbor's eyes, even if they have no objection to its merits. And finally, it's very worth pointing out, I think, that the language in the informed consent template can be viewed as alarming. It says in bold caps, you are not obligated to sign this document. You have the right to withhold your consent in the oil and gas development near your home. The letter also requires the recipient to acknowledge in writing, without any context, that, quote, I understand the potential impacts of the development, including but not limited to potential impacts to my health. I think it's easy to see how this language could make some stakeholders suspicious, especially if they have not seen documents like this before. And given these difficulties in getting informed consent, coupled with the fact that 48.8% of the state is in a DIC, prior draft rule 604C, if enacted, could stop future oil and gas development in certain areas in its tracks without any review or say by the ECMC. By contrast, Senate Bill 24-229 allows the ECMC to be the decision maker on whether an applicant will obtain a permit, and also recognizes that not all oil and gas development will have impacts on nearby residents, and instead focuses on avoiding and minimizing the adverse impacts with respect to these projects that do have such impacts. It's also worth emphasizing the protection given to DICs under the current version of the draft rules. As Ms. Trask emphasized in her presentation, these draft rules provide increased local notice and consultation with nearby residents and local governments, including through an expanded pre-application consultation process and formal post-consultation requirements, and requires more information to be submitted as part of the OGDP application, including the operator using the EnviroScreen scores for the proposed location and explaining to the ECMC and to stakeholders how it used these scores to determine its proposed BMPs for the location in order to avoid and minimize impacts to the DIC or CIC community. Draft rules also support the implementation of community liaisons, which we've already heard a lot about, and requires the use of enhanced systems and practices within the ozone non-attainment area, both year-round and between May and the end of September. All of these measures provide added protection, many of which NGOs and citizens groups have been seeking for the past 3 years without resorting to a siting ban based on the location of a proposed oil and gas project. Now, with all of that said, I am authorized to say on behalf of operators, and you will hear this from the individual operators, that they are receptive to discussing with stakeholders over the next week, expanding the distance of some of the procedural provisions in the draft rules. Now, operators will consider making these concessions so long as it is understood that expanding the distances of certain notice and consultation provisions in the draft rules will not impact who is and who is not an affected person in the 500 series, and that this is made explicit either in the rule itself or, at the very least, in the statement of basis and purpose. Finally, on this subject, I'd like to address 2 issues that have come up during this hearing regarding prior draft rule 604. First, several parties have argued that putting prior draft rule 604C back in the rules should not be a big deal because it would have impacted very few applications in the past. And it's certainly true that there has been very limited development in CICs and within 2,000 feet of residences within DICs. But there have been, to my understanding, a few, or at least a couple, select few applications within 2,000 feet of receptors and DICs that were recently approved under the substantial equivalence exception that would have been rejected under the prior draft rule 604. And there are indications from some operators that you will likely see more applications within CICs and within 2,000 feet of DICs in the future. DIC maps are not static and will change, while the underlying geology where their minerals are located will not. Additionally, urban sprawl will generate more residences in DICs, and prior draft rule 604 would, needless to say, have an outsized impact on applications in these areas. And I submit that this is not the directive from the legislature. And finally, and perhaps most importantly, operators will tell you that they spend a lot of time, person power, and resources considering different locations for development and consider many different factors, including the location of residents, but also impacts to wildlife, wetlands, and water bodies, topography, access to utility power, and of course, access to the minerals and infrastructure when considering a site. And based on all of these locations and considerations, sometimes the optimal location for reducing potential impacts while still accessing the mineral resources may be siting development within 2,000 feet of a residence in a DIC, because that site is the least cumulatively impactful. Yet if an operator can't get 100% informed consent from each RBU within 2,000 feet of that location, then that location can't be considered, even if it's the optimal location. For this reason, it's important, as the Commission decided during the mission change rulemaking, to allow the Commission to consider the merits of each application on a case-by-case basis. And the prior rule doesn't allow this. Second, I'd like to address the letter issued by some members of the House and the Senate arguing that prior draft rule should be put back into the draft rules. First of all, the legislature has already demonstrated its intent when it let House Bill 1330 die in the House Appropriations Committee the same week in mid-May this year that the Senate bill was signed into law. The full legislative body took both of these actions only 4.5 months ago. To that end, and with substantial respect to the signatories of the letter, they don't represent a majority of those voting for the Senate bill. There were 7 Senate members that signed the August 21st letter. This represents 7 of the 25 members who voted for the bill in the Senate and 35 members of the total body. And with regard to House members, 17 of the letter signatories sponsored the Senate bill out of a total number of 40 sponsors and 43 members who voted for it. The 17 signatories are also part of a 65-member House. Now, it is for these reasons that, as a legal principle, statements by legislators regarding legislative intent after a bill is passed are given very little weight by courts. In some, courts decline consideration of lawmakers' post hoc statements as to what a statute means because, as numerous courts have said, explanations produced after the fact and after the act by legislatures are not statutory history and can provide little guidance as to what the legislators and the legislature collectively intended. I submit that similarly, they shouldn't be given any weight by this commission. Jim Martin will be saying much more about this legal presentation in the presentation following mine. And finally, on this point, the legislatures who signed the letter misstate the weight of the evidence when they state that, quote, eliminating this setback will undoubtedly lead to an unacceptable increase in harm to these already vulnerable communities. With respect, the legislature has pointed to no evidence in support of this statement, nor, I submit, can they. In fact, air data presented during the mission change rulemaking in 2020 and since then to today demonstrate that the potential impacts to residents from oil and gas development have consistently been overstated. You'll be hearing much more about this during our presentation. Now, finally, I would like to move on to a second reason why prior draft rule 604C should not be put back into the draft rules. In sum, this prior draft rule runs completely counter to the approach taken by the commission in the mission change rulemaking. In that rulemaking, after months of stakeholder presentations and reams of expert and lay testimony and internal deliberation, the commission established a middle position in existing Rule 604B that placed stringent requirements upon oil and gas operations within 2,000 feet of a receptor in a DIC without at the same time resorting to a siting ban based solely on distance between the proposed location and the residence. Next slide, please. Next slide, please, Christy. Nope, back up. Sorry, my eyes, not yours. In the SBP for that rule, the commission, quote, recognized that distance alone does not directly address any specific potential impacts and that protective measures required by other commission rules which are targeted to a specific impact may provide equal or even greater protections than distance. These protective measures other than distance identified in the SBP include considerations of faculty and facility design, adherence to best management practices, requiring the use of specific control technologies, and permit conditions of approval. As the SBP continued, depending on what type of impacts is at issue and the nature of the potential of the receptor that would be adversely impacted, all of these methods to achieve protection may be equally effective or more effective than distance. The Commission also does not intend to create a standard that elevates one method of protection over all other methods. Now, during the mission change rulemaking and in response to a proposed siting ban of 2,000 feet, similar to prior draft rule 604C, COCA presented unrebutted evidence that oil and gas development within 2,000 feet of a receptor did not pose a health risk. Specifically, Koga presented testimony summarizing numerous monitoring studies conducted by CDPHE, local governments, and industry involving over 6,500 air samples of benzene concentrations collected between 2017 and 2020 and measured from between 175 to 5,000 feet from oil and gas wells during different operational phases, including during flowback operations. Next slide, please. Mrs. McMullen and Christy Woodward will have more to say about this data in a minute. I'll simply note Ms. McMullen's conclusion in the mission change rulemaking that based on all available air sampling data, there's no credible evidence supporting the need for a greater setback to protect public health and safety. Now, the mission change rulemaking, of course, concluded in 2020. Since then, regulatory and operational changes are providing enhanced protection and even better results. As you will hear from operators, pre-production practices have improved over the past 4 years. Operators are increasingly using controlled loop systems for containment of drilling, completion, flowback, and produced fluids, and substantially reducing emissions as required by the AQCC. More electric-powered rigs are being used. There are fewer oil or water storage tanks on locations, and operators are, whenever possible, reducing transportation of production by truck, which greatly reduces the footprint and impacts of development. Operator monitoring is reported to CDPHE on a monthly basis, and this has resulted in tens of thousands of additional data points, effectively measuring cumulative air quality in and around the vicinity of oil and gas development. The air emissions data gathered since 2021 demonstrates that monitored benzene levels are well below the CDPHE health guideline value. Again, Christy Woodward and Tammy McMullen will have much more to say about this in our presentation, but I will now step aside for Jim Martin. Thank you.
Good afternoon, Chair Robbins, Commissioners. It's nice to see you again. I'm going to actually hit on several points, but I'm going to start by providing a sort of exclamation point to Mr. Matthews' comments about how we discern what a piece of legislation might mean and what it might not mean. It's probably important to start out by admitting or acknowledging that legislators, like just about anyone else, are entitled to offer public comment on a rulemaking. However, to the extent those public comments are intended or were intended to shed light on legislative intent behind already enacted legislation, then we must urge caution. We must urge caution that the commission, that such post hoc rationalizations are entitled to little weight. There's a plethora of cases on this point, dozens of judicial decisions with a common element. And that common element is that post hoc legislative intent is disfavored. In my research, I actually pulled up, thank you, Christy, I appreciate that. In my research, I actually looked at a large number of cases. I could have printed out and shared with you about 48 pages of cases, judicial decisions, with a consensus that this post hoc legislative intent is disfavored. I decided to spare you and us that burden, but there's a lot of cases out there, and they're in accord. I decided to share with you at least 2 United States Supreme Court decisions on this point. And the first one is up on your screen. It's Weinberger versus Rosie. I hope that I'm pronouncing that name. It could be Rossi. In that case, a congressional committee actually went to the trouble of adopting a congressional report that was intended to provide some insight into the meaning of previously enacted legislation. And in that case, the court made short shrift of the argument that that could be offered as evidence of congressional intent or previously enacted legislation, and concluded such post hoc statements are not entitled to much weight. Christy, if you could go to the next page, please. So I thought we might share at least another United States Supreme Court case. And in this case, I decided to share it partly because you get a sense of the late Justice Scalia's sense of humor. But the court was addressing essentially the same issue. They cited the late Justice Scalia, and he also made short riff to this notion that subsequent legislative history can be used with any reliability to discern what a previously enacted statute might mean. Next page, Christy. So I did decide that rather than sharing 48 pages of decisions with you, I'd at least share a sample of the decisions that I looked at while doing this legal research. And they all show the same thing, that a post hoc statement by legislators those statements are problematic, and they're not the best indicia of what a statute might mean. Happy to share these with your legal counsel, and happy to give them the legal research that I completed in doing this, or at least the URL that will take them to there. But the bottom line is, we respect those legislators. They deserve that respect, but their post hoc views are entitled to little weight. Now I'd like to turn to a different subject, but again, a subject that arose earlier in this proceeding. I believe it was Conservation Colorado that took issue with a particular enhanced system and practice, and in this case, an enhanced system and practice that essentially incorporates, sorry, this reasoning is a bit circular, but essentially incorporates the Air Quality Control Commission use requirements for drill rigs, certain turbines, and certain pumps, all used in hydraulic fracturing and drill rigs. If I understand Conservation Colorado's argument correctly, they suggest this commission should adopt regulations to require electrification of drill rigs unless the operator can present a formal letter from the electric provider stating that electricity is unavailable. Conservation Colorado, as I understand it, happy to be informed differently, but I believe they also would require the electrification of fracking engines unless that is unavailable, or again, the operator can provide a note from the utility that the utility cannot provide that service. So what's the problem with this proposal? Well, Ms. Woodward will explain some practical reasons why that just doesn't work, and I'll defer to her on some of those, but I want to focus briefly on some other reasons why this is impractical. First, and perhaps most fundamentally, it's inconsistent with Regulation 7, and that would create confusion in the field about which regulation the Air Commission's or this agency's rules would apply. But second, there are a lot of other good reasons why this proposal should be rejected. And one of them is that many utilities in Colorado are confronting rapid low growth combined with an overworked electric grid at the same time they're endeavoring to green their resources. For agreeing to connect a drill site to electricity on the electric grid, they have to conduct thorough studies to assess their capacity to do so at the drill site location and in the time frame that works for the operator. That is the case for any new large load, not just a drill rig or a frac engine. That's an expensive and time-consuming process to determine feasibility, and they're not somehow obligated to expedite it for a drill rig. That's part of the reason that negotiations on electrification can be difficult and time-consuming. But beyond that, it's important to remember that electric utilities in Colorado are defined as public utilities under Colorado statute. In fact, they have statutory and even constitutional obligations to serve customers within their franchise areas. It's unreasonable to expect a utility to state in writing, emphasis in writing, that it is waiving service or that it cannot serve a new customer. That sort of thing is just not done. That's not how the system works. What Conservation Colorado suggests is not workable in practice, and moreover, operators are already working hard to electrify whenever that's practicable. Conservation Colorado's proposal is unnecessary and unworkable. Now I'd like to respond to a proposal from some of the other parties to extend the 604B setbacks to 1 mile in disproportionately impacted areas. I have two thoughts about this proposal. First, I'll remind you, as Mr. Matthews said, that DICs make up nearly 50% of the state surface area. Most of Moffat County is a DIC. A large part of the western part of Garfield is a DIC, as is much of Rio Blanco and Huerfano counties. You heard from Mr. Joy just a bit ago that all of Las Animas County is a DIC. There are large DICs spread around the state. Expanding 604B to all RBUs within 1 mile and all DICs is simply not implementable. It's also unreasonable and unnecessary. And the testimony of Ms. Woodward and Dr. McMullen will show there are not health impacts from oil and gas, demonstrating that such setbacks are not needed to protect DICs. Switching yet to another standard, that brings me to the issue of commission review of cumulative impact analyses. The staff draft that proposed Rule 315B sub 3 sets out a set of 10 specific and objective criteria for approval or denial of a cumulative impacts analysis. It would provide a relatively predictable and a certain set of standards to guide all parties, for what an operator must do to compile an acceptable cumulative impact analysis. Conversely, some other parties propose a standard for commissioner decisions or commission decisions of no net negative impacts. The wildlife groups similarly propose a standard of, and this is a tongue twister, no measurable additive cumulative impacts. These standards have one thing in common, or at least one thing in common. They're highly subjective and they provide no predictability for agency action. Beyond that, we have other concerns about how a no net negative impact standard could be implemented. For example, is any noise emanating from an oil and gas site an adverse impact? Or is it an adverse impact only if it is significant? The no net impact standard also ignores the hierarchy of avoid, minimize, and mitigate, and we've heard a lot about that in this proceeding so far. It's clear that oil and gas, like all uses that produce something, all manufacturing, all industrial activities have impacts. A no net impact standard eschews the Oil and Gas Conservation Act as defining minimize adverse impacts to mean to the extent necessary and reasonable to protect public health, safety, and welfare, the environment and wildlife resources in order to avoid adverse impacts from energy and carbon management operations and minimize and mitigate the extent and severity of those impacts that cannot be avoided. With that language, the Act actually acknowledges that some degree of impact is unavoidable. That's why API Colorado urges rejection of the no net impact standard. With that, I'd like to hand the microphone over to Ms. Woodward.
Thank you, Jim. I appreciate it. Good afternoon, commissioners. My name is Christy Woodward, and I'm a regulatory affairs advisor for the Colorado Oil and Gas Association, or COGA. I've been working in regulatory affairs for COGA for the past 6.5 years. I have a bachelor's degree in environmental engineering from Northern Arizona University and a master's degree in the same from Colorado School of Mines. I've been a registered professional engineer in the state of Colorado since 2006, and I have 24 years of collective experience in environmental science, engineering, and policy. I have worked in the private sector, EPA, for the Department of Defense, the home building industry, in mining, and most recently for oil and gas. One of my main focuses over the past 13 years has been in air quality for the oil and gas industry and emission reduction and air quality emissions measurement. We're soon going to find out if that experience extends to more than my simply advancing slides. The purpose of my testimony today is to discuss and summarize the cumulative air monitoring data collected by CDPHE and by operators since the mission change rulemaking in 2020. There's a significant publicly available data and information demonstrating that oil and gas operations are protective of public health, safety, welfare, the environment, and wildlife at close proximity to the well pads. This includes ambient air monitoring data collected in the vicinity of oil and gas facilities, sometimes between several oil and gas facilities. The data are collected during pre-production operations and the first 6 months or more of production. The ambient air monitoring data I'm presenting provides records of total VOC and benzene from the air and is demonstrative of cumulative air quality impacts from these oil and gas emissions and any other sources of these emissions in the vicinity of these operations. This data proves that the initially proposed restrictions in prior draft Rule 604 are unreasonable and unnecessary. Benzene was the main VOC evaluated because risk assessments have identified benzene as the main VOC of potential public health concern. Operators often monitor for total VOC and collect a canister benzene sample to analyze when VOCs are elevated. Some operators also simply continuously monitor for benzene using carbon sorbent tubes as their locations as a matter of practice. As Mark stated, COGA prepared witness testimony and air quality monitoring data prior to September of 2020 for the mission change rulemaking. Since that time, CDPHE has put into practice controls for flowback operations statewide starting May 1st of 2021. At that same date, a requirement to monitor emissions at the fence line of well facilities was put into practice for every new well drilled or modified after May 2nd of 2021. Further, effective July 15th of 2023, CDPHE also requires this new monitoring for new and modified facilities for the entire lifespan of a facility in how they've defined cumulatively impacted communities. To assess the latest data since our September 2020 consolidation for the mission change rulemaking, I undertook 3 tasks. I pulled all publicly available data from the Colorado Air Monitoring Mobile Lab, or CAML, as it's affectionately called at CDPHE, from their publicly available website. I also surveyed COGA members generally about how they're monitoring for Regulation 7 compliance and what their data has demonstrated. I followed that survey up with a 3rd task, which was to ask operators for any sampling results that they've obtained for benzene. We also requested any additional data from CDPHE, and I received 2 additional reports on September 4th. What was sampled and why? The CAML uses sophisticated air monitoring instruments to monitor for a host of constituents, like speciated volatile organic carbon, or VOCs, methane, nitrous oxides, and benzene. Benzene is a VOC and is one of the BTEX gases: benzene, toluene, xylene, and ethylbenzene. Oil and gas health studies often target benzene because it's the only known carcinogen out of the VOCs normally emitted from oil and gas operations. Similarly, EPA's refinery fence line monitoring rule uses benzene as a surrogate for other pollutants. As you will hear following me from Dr. McMullen, the majority of benzene readings in and around these facilities are similar to background measurements. And we saw that the measured benzene concentrations are consistently below its public health guideline value, with the majority of the measurements being well below public health guideline values. Most of the Regulation 7 pre-production monitoring data is for total VOCs, which is most representative of hydrocarbon emissions from oil and gas operations. Some operators measure for TVOC in part to screen for elevated benzene levels and will sample for benzene in the rare instances that they observe elevated levels of TVOC. Other operators, will monitor for both TVOC and benzene continuously or at preset frequencies and have provided me with a wealth of benzene data. The CAML, however, uses sophisticated air quality monitoring equipment to pull near real-time benzene and other constituent measurements at either 30 or 45-minute intervals. The operator data uses sorbent tubes or SUMA canisters and averages that data over a 14-day period. The reason for this is that it's consistent with the Agency for Toxic Substances and Disease Register, or ATSDR, 9 parts per billion public health guideline. For ease of observation and due to this measurement time difference, I graphed the CAML data and the operator benzene data separately. I'll start with this side by presenting CDPHE's CAML data. For the CAML, I analyzed 1,899 sample data points. Of those over 1,800 samples collected since 2020 by CDPHE, not a single benzene reading exceeded the 9 parts per billion health guideline. The average and median by PAD were all well at or well below 0.260 parts per billion, as shown below, and 95% of those samples, just over 1,800 measurements, were below 0.614 parts per billion. This data came from 3 pads located in Longmont, Greeley, and Thornton, and is graphed here representative for you. Now I'll discuss the survey information from COGA members. As I provided in my pre-filed written testimony, I also surveyed COGA members to get some information about their Regulation 7 monitoring campaigns and results. Most of the air monitors used by COGA members pull samples of total VOC as frequently as every minute and average them over a time frame set by the operator. This is done mainly for data management purposes. You can imagine minute-by-minute samples create a tremendous amount of data. If an operator obtains an elevated VOC reading, they typically pull a benzene sample, and some just automatically co-locate benzene sorbent tubes with their Reg 7 monitoring equipment as a matter of practice. The appropriate averaging time for sorbent tube and summa canister samples, as I already mentioned, is 14 days, particularly for comparison to that ATS-DR 9 ppb public health guideline. I received survey feedback, and here are the survey questions on this slide, from 3 major DJ basin operators to small DJ basin operators to Piceance basin operators, and 1 consultant who consolidated small operator information from both basins and along the Eastern Plains. This sampling occurred in Weld, Adams, Garfield, Rio Blanco counties, and along the Eastern Plains counties. Operators use a variety of technology and sampling frequencies. They generally, however, set 3 to 4 summa canisters at cardinal directions around their facilities. Some operators even set up to 12 carbon sorbent tubes. The distance range for summa canister and carbon sorbent tube placement from my survey for all operators was between 100 and 200 feet from the edge surface of the pad facility. It is important to note that per Regulation 7, this data is also reported to CDPHE on a monthly basis. All of the operators surveyed indicated that occurrences of elevated TVOC were infrequent and occurred maybe 1 or 2 times in the course of a year, if at all. As you can see from the graphed benzene data I received, however, of the 8,635 total data points provided, 95% were below 0.499. Again, thousands of samples well below the 9 parts per billion health guideline value. This sampling occurred from May of 2021 to present, and the remaining 5% of samples ranged from 0.499 to a maximum reading of 2.6. You can also see from this graph, I provided you with the 25th, the 50th, and the 75th percentile of those data. As of late Wednesday, September 4th, I became aware of 2 other community investigation reports completed by CDPHE. One report was from a well pad in Brighton dated September of 2022. The others in Aurora dated August of 2024. Both of those investigations had short duration, less than 1 hour, readings above 9 ppb, and singular measurement at each, and were investigated by CDPHE with many additional air samples being collected well below 9 parts per billion. Quotes on these slides are directly from the reports that CDPHE has provided and clearly state that they did not lead to public health impacts. These investigations show that the Regulation 7 air monitoring is working and that the new regulations are protective of public health. I now want to address the health guideline I compared these samples to, the 9 parts per billion. You'll hear this many times, but I want to emphasize again that the 9 parts per billion is a standard that is generated for averaging readings over a 14-day exposure timeframe. So a single reading over 9 ppb over a 30 or 45-minute timeframe is a good reason to conduct a further examination of what may be causing that elevated reading, but not a demonstration of a possible or even plausible impact to public health. These data are measuring the cumulative ambient air within the vicinity and close proximity of these operations. Out of all of this data, you will see that only the 2 most recent available CDPHE reports show a short-term measurement of 9 ppb, and they are of very short duration. Notably, of the nearly 10,000 samples received, over 95% of those samples are below 0.614 parts per billion. This data shows that the protections put into place by this commission and by the Air Quality Control Commission in the past 5 years are effective. Further, data continues to be collected as operators deploy monitoring consistent with CDPHE regulations. Now that significant data has been collected, the Air Quality Control Commission will likely undertake a rulemaking next spring to require more uniformity in data collection and reporting. As the monitoring technology evolves and operators continue to work with state agencies and local governments, we learn more and more and find additional ways to improve our operations and remain protective of public health. The monitoring is continuing, resulting in mounting evidence that these operations are protective of public health and that a distance-based setback based on concerns about cumulative air quality impacts is unreasonable and unnecessary. In addition, this data also shows that additional monitoring is suggested by some parties is unnecessary and is also unfounded. With that, I'll go ahead and turn my presentation and suggestions to Rule 316C4A, Enhanced Systems and Practices. You will have more specific and direct testimony on this from operators later. However, I'd be remiss if I didn't raise this briefly. Not all enhanced systems and practices are practical for adoption as mandatory requirements, and those that you do adopt need additional time for implementation. We've undertaken a tremendous amount of air quality regulation at the Air Quality Control Commission in the past 6 years. The federal government is also implementing new regulations. This leads to long lead times on equipment and supply chain shortages, both in Colorado and nationally. Because of this, additional planning and preparation time is needed, and I would ask that you push the effective date of this provision to January 1st of 2026. We understand and have heard from staff that this will apply only to new oil and gas facilities, and we're grateful for that change. New facilities that go into operation immediately after the rule's effective date have already been planning for and providing equipment and labor, which may not be able to be arranged until January 1st of 2026, again, only for those ESPs that may be practical to adopt as mandatory requirements. When we work on air quality regulations with the Air Pollution Control Division, we spend hundreds of hours discussing the language, then we spend many more hours working with implementation staff on a common understanding of those regulations. This is because each oil and gas facility in each location is appreciably different, and blanket rules are problematic. The oil and gas industry is at its strongest when we are able to innovate and have flexibility in implementation. This is how we got to GHG intensity and NOx intensity. They both allow for innovation and new technologies, and these systems and practices need to reflect this flexibility or will require additional discussion. Specifically, 316C3A 4 and 5 appear to be related to particulate matter of dust and not ozone. This section should be removed or moved to a new section potentially. Regardless of that, there's definitely some confusion about this language and its intent. It's unclear if it applies to sand that is being delivered, clean sand that is being delivered to a site in a sand can or a sand trap that's used at flowback. And those have different protections for different constituents of concern. And so however that gets fixed and repaired, it needs to be fixed and repaired. If the intent is, as it's drafted, to apply to silica dust, I've provided a red line here so that it can be further explained. If that is the case and it pertains to closed loop sand systems, again, that's only one tool in the toolbox and is overly prescriptive. There are other methods such as wet sand to limit particulate emissions that are common practice too, and these also reduce truck traffic. If the commission again chooses to keep these provisions, I've provided a red line here at some suggested language. Other provisions in 316C4A that are unworkable as blanket requirements are for tankless facilities and grid power requirements in DICs and in the non-attainment area. Cumulative considerations of these practices, like the provisions of new on-spec pipelines throughout DICs, may not be the best policy, particularly given that tank emissions are controlled. Tanks are also sometimes temporary, but nearly always required at some point. They stabilize oil and allow for storage for reduced truck traffic by allowing for short-term storage. These are just a few examples. You'll hear much more from operators later. The issue of grid power and power availability is something that has been keeping me up at night for many years. So much so that I actually created a board game as a means to have a dialogue with stakeholders about the complexity of it. We worked with our utility partners at United Power, the Colorado Rural Electric Association, Xcel Energy, to talk through some solutions and some problems and find a way to have a thorough and robust discussion about the complexity of this. I'm showing here just a picture of the board game, not intending to be funny, but to point out that this is a very complicated and complex problem that requires a lot of thoughtful consideration. The cumulative impacts of electrification may also be something that should be considered for disproportionate impacted communities. Running highline power and mandating that for temporary activities or even permanent activities may not be the best thing for community or wildlife. It isn't a silver bullet. It's often outside of the control of an operator, and much additional consideration should be given to this practice before it's mandated. Further, not all equipment on an oil and gas facility can be electrified, which was recognized in final Reg 7 regulations. I'll now turn to Dr. Tammy McMullen, who will address some of the public health studies cited by other parties.
You can reduce inequality, reduce poverty, actually also improve the living standards of ordinary working people, not in poverty, but struggling to get by.
That is not Dr. McMullen, so I'm not sure what that noise is.
Yeah, I think Mr. Martin should mute.
Well, look, I mean, I want to reduce poverty and inequality. I didn't go into poverty.
There we go.
Good afternoon. Can you hear me okay?
You're coming across kind of quiet.
Kind of quiet? Okay. I may be losing my voice a little bit, I'm realizing, but let me turn my Commissioner Robbins, is that better?
Yeah, that's better. Thanks.
Okay. Thank you. Christy, would you move to my first slide, please? Thank you. So my name is Dr. Tammy McMullen. I was a previous toxicologist for CDPHE. I was actually brought on to CDPHE during the time when there were discussions about concerns about public health risks in oil and gas development back in 2015. And I had the fortune of being able to be a part of the teams across CDPHE to evaluate the existing scientific information regarding public health risks, along with overseeing many of the studies that were used in 2020 for the initial mission change rulemaking. In addition to that, over the past 10 years, as a public health scientist, I've also conducted thousands of hours of studies across oil and gas well pads in Colorado and other states. And I hope that today I bring some value to the commission in providing my perspective from a public health expertise to you as we talk about the concerns regarding setbacks. So commissioners, I realize that I'm telling you, you have a Herculean public health mandate to achieve in this rulemaking. And I understand that developing effective regulations to address cumulative impacts is much broader in scope than just selecting some arbitrary one-size-fits-all setback distance. Cumulative impacts is something we as public health scientists don't even exactly know what to do with. There's frameworks available, but it's very, very challenging, and that's been challenging for decades across our field. And so I appreciate that you're taking the time to deliberate all of these ideas. Today, I will specifically be limiting my testimony to the specific scope of evaluating the adequacy of current ECMC setback regulations. I only wish that selecting a single setback would be sufficient to address cumulative impacts, but we all know that that doesn't seem to make any sense. As a public health advocate, we always have to keep in mind that these policies also address real concerns and real people in our Colorado communities, and I can't lose sight of those valid concerns. But it's critical that we are providing accurate communication of the data of cumulative exposures and health risks. So with that said, in the next few minutes, what I want to do is provide you with three main points. First, I'm going to step back and explain how this issue of setbacks has come to be a part of the discussion and in context of cumulative impacts from air emissions. Second, using kind of my first person experience of generating a lot of the data that were used to inform the 2020 decision-making, I will provide you with an overview of what we knew at that time and what those 2,000-foot setbacks meant. And third, I'll show you what data we have as of today, 4 years later, using quantitative analysis frameworks that we use to evaluate the adequacy of existing regulations to protect public health. Next slide, please. With this first slide, I want to start with the first question that we as public health experts ask that I haven't really heard yet in these hearings is when we're considering the idea that additional regulations need to be put in place, you're making the assumption that there has been an identified risk that needs to be mitigated with further setbacks. In order to take additional action, you first need to identify what risk that is and under what conditions that you need to manage further. And if identified, then we as public health assessors say, what are the most effective mitigations to manage that risk? So in this slide, what I'm showing you is that there's really multiple levels at which EPA and state agencies manage public health risks of airborne chemicals. These are methods outlined by the Clean Air Act. These range from a micro level within a few feet from an operation to a national level. And why this matters is because when it comes to cumulative impacts rulemaking, my observation is that these discussions have been a little bit all over the spectrum here without very clear understanding of the scope of the answer that we're trying to mitigate or achieve. So with respect to cumulative impacts, it's really important from my perspective to be precise and accurate on what we mean by cumulative impacts across these various spatial scales. Pertinent to my testimony, I'll focus on the discussion regarding setbacks. Setbacks can be one, but by far not the only way to protect people living close to a facility that emit volatile compounds. And the reason is because these compounds are most concentrated at a very local level. Setbacks are only one of many several tools that regulators use to mitigate identified unacceptable risks of public health. Setbacks are typically used by local governments, not generally at the state level in my experience, because it's through their land use and siting authority. As I show here, further setback distance would not be an effective regulation to manage health risks for pollutants such as ozone that are managed at a regional level. Next slide. I've repeatedly heard incorrect information that a specific setback distance is the only way to protect public health. So here I want to clarify that and help you understand the more standard risk-based approach that regulators use to protect public health from source emissions, specifically to oil and gas development in Colorado as it pertains to this rulemaking. So the standard way state and federal air quality agencies identify and mitigate risk is generally through a risk-based approach. What do I mean by that? EPA and state agencies develop regulations to mitigate emissions at the source, like technology-based emission controls. These agencies then use multiple tools to evaluate the effectiveness of these regulations to minimize exposures to people that live near these operations, and now therefore ensuring that public health risks are sufficiently minimized. With respect to Colorado oil and gas development and production, CDPHE has implemented regulations on top of federal regulations, along with requiring air monitoring at multiple geographic scales, from fence line, as I show here, through Reg 7 to regional, and there's national air quality monitoring networks. So when I say that regulators use a risk-based approach, what I mean is that they use the data like these air monitoring data sets to quantitatively evaluate the efficacy of the technology-based regulations to protect public health. And actually, they're looking at it to protect public health with an adequate margin of safety so that we prevent public health effects from occurring under current regulations. So additional regulations enacted at the micro or neighborhood level for all sectors would include, for example, even the new regulations such as HB 1244. Next slide. Although I just said that setbacks are not the only way to manage risk, SB 181 mandated that COGCC at that time evaluate regulations from a public health perspective. The commission at that time were presented with a bunch of data from which to determine a new setback distance to ensure public health protection. As a state toxicologist, informing it during that time and overseeing the oil and gas health program for the 3 years leading up to the rulemaking, I want to give you some background context so that you understand where that 2,000-foot setback came from. My goal is to provide you with this context over the next couple of slides. So one of our questions at that time was, are current OGD operations with regulatory emission requirements at the time adequately minimizing emissions and resulting in negligible public health risks? The question was, it was at 500 feet at that time, and there was an evaluation of looking at it at different distances. There are generally two methods that we apply to answer these types of questions. The first is computer modeling, and it can estimate concentrations of compounds at different distances from different sources. And the computer model is used to calculate estimates about the pollutants, weather, terrain, all of those things that affect it. It's helpful because you can run a whole bunch of hypothetical scenarios that you could never just do with monitoring. And in fact, Dr. Collette's team from Colorado State University were critical in generating these data at that time. The second way we estimate exposures to look at health risks is go out and collect air data in areas where people live, work, or go to school, next to oil and gas well pads. Well, because CDPHE had an oil and gas health program, they went out and began to collect quite a bit of data. Now, the important piece of understanding as we move forward with measuring what's in the air is that when you're measuring what is in the air, you are essentially measuring a cumulative risk of those chemicals from not only all the well pads in that area, but from other sources. It's what somebody breathes. It's irrespective of what source it came from. So both modeling and air monitoring were presented to the COGCC in that rulemaking for setbacks. So in 2020, I presented and testified on several analyses of exposure data that CDPHE collected in community investigations when they received concerns. Collectively, that represented over 10,000 data points. It didn't show us that there was incremental increases in cumulative risk at distances closer than 2,000 feet. However, the 2,000-foot setback was primarily driven by modeling results, and I'll show these to you here. Excuse me. These modeling results were conducted by a third-party expert and overseen by CDPHE. The data were actually field data where Colorado State University experts under Dr. Colette's team collected a whole bunch of different emission data that really represented operations between 2013 to 2016. So now that's over a decade ago from its relevance. It used meteorological data and other types of information to enter into a computer model, and it simulated dispersion of these chemicals, over 40 chemicals that we know to be released from oil and gas operations. And then they identified the highest exposures to the receptors at different distances. They estimated these exposures and they identified health risks. They looked at acute and chronic cumulative risk from multiple VOCs. This also included health protective factors for susceptible populations. In contrast to what you have heard from other parties, the scientists did evaluate cumulative risks from breathing air that contained the highest estimates of all VOCs. The authors also used multiple health protective assumptions, as I just stated earlier. So what did the modeling data show us at that time? It showed us, what I'm showing you here is an excerpt straight from that report, and it's a summary regarding the evaluation of the maximum acute or very short-term exposures, which are part of the regulations, the ECMC regulations, is to evaluate the acute exposures. This looked at over 40 VOCs and calculated the health risks. Risk assessors generally evaluate these health risks from individual VOCs as a metric, as you see on the left-hand side, called a hazard quotient. In general, what we look at is if a hazard quotient is below a 1, it indicates that the estimated exposures would not be expected to cause some kind of non-cancer health effect. A value of 1 or above, however, isn't interpreted as a bright line that where there's health effects that would occur because there's multiple health protective factors that are included. But it does tell us this is a priority. We should really look further. As you can see here, what they found on the right-hand column at 2,000 feet is that 2 compounds were of primary concern out of the 40, benzene and 2-ethyltoluene. These were under situations where there was a hypothetical receptor downwind the entire time during conditions of flowback at that time. As the author stated, the higher acute exposures resulted very narrow subsets of potentially exposed populations during very rare exposure scenarios. And these, when you look at the data, the source data that were provided to give these modeling results, it shows us that this was actually during open tank liquid unloading, which we all know does not represent 2020 or even current operations. However, it was very informative at the time to establish the 2,000-foot setback. Next. So what do we know about long-term health risks when we hear about concerns about cancer? Benzene is our primary driver of cancer when it comes to oil and gas emissions. This is also taken out of their report. At 2,000 feet, there were, under all types of hypothetical conditions, there was not one single compound, including benzene, that went over our hazard quotient of 1. These chronic exposures, say the authors, during production were below the exposure guideline values, even at 500 feet in all scenarios. Also, they say at 500 feet, incremental lifetime cancer risks due to benzene were below 1 in a million before the 2,000-foot setback. Next slide, please, Christy. All right, so that's what we knew then. What do we know now? So the data in 2020 showed us that at the setback distance of 2,000, really the commission at that time was taking a precautionary principle approach to managing adverse health risks, because the environmental data that we had collected with relevant operations at that time were not demonstrating that there were adverse health risks. The actual air monitoring data weren't demonstrating it. So this was likely taking a protective approach based on the modeling data. The COGCC wisely included flexibility for local governments and operators to consider approval of permits to vary from that 2,000 foot if a variety of criteria are met. What's really important is that it includes criteria such that they need to consult public health experts at CDPHE and make site-specific plans to adequately minimize adverse impacts. In addition to this setback, since then, we've now had Reg 7 that requires air monitoring to evaluate the effectiveness of these regulations, along with ongoing ability of the public to call CDPHE, report their concerns, and CDPHE continues to have even more technology to go out and collect air monitoring data to address any concerns. So what do we know after 4 more years of collecting data? Next slide, please. Well, the first study I want to point out, and that Dr. Collette spoke about on Friday, is that I want to spend a little bit of time on the Broomfield air monitoring study. And why is that? Because this study was commissioned by the City and County of Broomfield, conducted by Ajax Analytics and Dr. Collette's team at Colorado State. It represented several years of current well pad development and production, and there's several key valuable takeaways that we glean from this study. In particular, the study provides examples of how local government addressed the specific needs of the community while working in collaboration with the operator through an operator agreement. Second, the study used multiple types of methods to collect data that helped us inform the uncertainties that we had in 2019. Third, the data are relevant and specific to today's operations. And fourth, the data are very useful in estimating cumulative exposures at different distances under the conditions of multiple active well pads that are happening with different operational phases simultaneously. In this slide, what I'm showing you here is a figure from the publication. The authors here concluded that all weekly average benzene mixing ratios, or what we call in public health language is air concentrations, even at near pad monitoring sites, all of it remained below this chronic 3 ppb chronic duration inhalation level. Although the authors conducted a very high quality air study, I do want to point out that the authors inaccurately applied public health exposure and risk methods in this analysis. And perhaps unknowingly, they were making some assumptions that the measured air concentrations, even collected near the well pads, actually represents an exposure or even a future exposure at those locations, which is unrealistic since we have a 2,000-foot setback. But still, despite these unrealistic exposure assumptions, these air samples are still very valuable to evaluate benzene, which we know drives over 90% of the risk. And they were well below public health protective guidelines, even at near source. Next, please. Second, I want to point out, because I've been hearing this throughout this rulemaking and in my review of the pre-hearing statements, the authors of this study also collected extremely short-term air samples, sometimes as short as 15 seconds. The authors concluded that the concentrations of these individual VOCs in these plumes were several orders of magnitude higher than in background air. This conclusion by itself, I think, actually provides some pretty valuable information to us as public health experts, because it identifies potentially some specific operational activities that are resulting in the greatest changes of VOCs near a source. In fact, these findings actually corroborate with those findings that we found back in 2019 in the CDPHE study that Dr. Collette was a part of. But here is where I want to make some very important clarifying points to the commission, as several parties are drawing highly inappropriate conclusions about harm to public health based on these data. First of all, these data cannot be taken out of context and extrapolated to assume it represents an exposure. Doing so neglects fundamental definitions of exposure and health risk and goes against standard regulatory exposure methods used across all regulatory agencies. This is fundamentally flawed and I believe generates unnecessary and unfounded fear in communities living near these oil and gas developments. But let me remind you, it's so important to understand that fear by itself is a non-chemical stressor in the world of cumulative impacts to public health. So it's imperative that we really ensure that we are minimizing fear by using accurate terminology when we convey scientific information about public health risks, in addition to using standardized methods that we use when we collect information to develop policy decisions. Next, please. So the data were provided and publicly available. And so we've taken here the data that are provided from that study. And what you see here is the blue bars represent the average benzene that were measured in that study, organized by different distances from left to right at about 350 feet from the well pads to 16,000 feet, or about 3 miles. As I've said before, these air samples represent cumulative exposures from all oil and gas operations in the area, along with non-oil and gas development, like highways, et cetera, in this area. So there's two main ways we look at ambient air data. And when we want to answer the question about, are there incremental adverse health risks posed by an emission source? One way is that we look at the data in relationship to background levels of benzene, which could be used as what has been, I've heard, baseline levels. Benzene's emitted from a lot of sources. So what we can do is take a look at what do the averages look like, those blue bars, compared to averages across Colorado and across the US where there isn't oil and gas operations. And as I'm showing you here, these horizontal lines, the green line are the Colorado averages, and the blue line are the average background of benzene across the US. What you see here is that there's no significant incremental increase in benzene at distances as close as about 300 feet out to about 3 miles from those operations relative to background measurements or baseline measurements of benzene across Colorado and the US. The other thing we look at is, are the BMPs effectively managing risk below levels of concern? So the horizontal yellow dotted line that I show you up above is actually a relatively conservative target cancer risk level if people were assumed to be exposed to these concentrations of benzene over a lifetime. These average benzene exposures even at 2,000 feet are over 10 times lower than the cancer risk management thresholds that we use. Next slide, please. I think, is that a duplicate? I think, Christy, I think I have a duplicate, so you can move to the next one. Lastly, I just want to show you that not one study is important, and I spent time on that study because it's kind of one of the best studies we've got with really comprehensive air data. But it's also important to use a total weight of evidence when you're merely making some evidence-based policy decisions. So what I've done here is just a quick estimate that's compiled both what Ms. Woodward testified on using CDPHE's CAMEL data since 2020, along with what she demonstrated to you on all the operator data aggregated together and the averages of those. In addition to the 3 bars to the very right are the data I just showed you averaged from the Broomfield study, averaged at different distances. Again, like the other data that I just showed you, is the average benzene measurements, like I said, are useful estimates of total exposure for cumulative risks. And from here, what we see is that there's no incremental increase, even with some of these other data that are collected very close in, like some of the operator data per Reg 7 that are required to be right pretty much there at the perimeter of the well pad. From pretty much at Colorado and US background levels of benzene, and that the average benzene exposures continue to be at 2,000-foot setback, continue to appear to be health protective for even the most conservative cancer risk values. So lastly, go ahead, Christy, to the last slide, please. Lastly, I provided you with evidence that demonstrates that the current 2,000-foot setbacks are adequately minimizing cumulative health risks from the hazardous air pollutants. In 2020, COGCC took a precautionary principle when establishing that 2,000-foot setback. We do see, based on some of the data collected by CDPHE, continuing along with the COOS study, that some operational activities do result in intermittent increases in certain hazardous air pollutants very close to the well pad, but they have not represented exposures, nor have they been at levels known to cause acute adverse health effects where people live. Relevant exposure data continue to show that the cumulative impacts during both development and production are below levels that pose risks at the existing setback, and that current regulations are not resulting in HAPs at levels of concern and do not identify that there's a health risk at the current setback. So based on all of these, it was a health protective decision in 2020, and it appears to be continuing to indicate that it is a health protective setback and that the regulations are adequately protecting while allowing for the flexibility of local governments and their constituents and operators to navigate very site-specific plans. Thank you very much for your time.
Good afternoon, Commissioners. I am Chris Colclazier of Beatty & Wozniak. I'm an air quality attorney representing COGA and appreciate the chance to speak with you today about the NOx intensity provisions of Rule 316. Next slide, please. COGA has three main concerns with the remainder of Rule 316. First, decisions about NOx intensity should be based on final emissions and production data from annual on-GAIR reports. That's the Oil and Natural Gas Annual Emissions Inventory Report. The interim reports should have only a limited role. Second, duplicative provisions in the reg should be eliminated by striking Rule 316A, and the Commission should adopt Oxy's proposal to streamline Rule 316B and the Form 2D review process. Third, we ask you to reject party's proposal for a cumulative NOx budget. This clashes with Air Commission Reg 7, forces this commission to pick winners and losers, and is not necessary to meet NOx reduction targets. Next slide, please. It's not a good idea to base regulatory decisions on the interim NOx intensity reports. They're preliminary. There's little time for internal review before submittal, so emissions will be refined prior to the annual on-GAIR report. The interim reports use production data from October of the prior year through September of the current year, but the intensity is a calendar year metric, and so the final intensity calculation will be different from the interim report. The final intensity number will substitute in the production data for the last 3 months of the current year once that data is reported in on-GAIR. And this can make a difference between reporting compliance or reporting an exceedance, especially for small operators whose production might be much higher if they have drilled a well during the current year. They need to have the current year, October through December production data factored in to capture that. And this is why the Air Commission made the interim reports strictly informational. Their SBAP, Statement of Basis and Purpose, says that the interim reports are intended, quote, for the division to use to evaluate progress towards the NOx intensity targets, unquote. And in the Air Commission rulemaking, the division said that, quote, interim reports will be used to assess the efficacy of the NOx intensity rule, unquote, and the compliance would be based on final on-GAIR data. So the interim reports were never intended as a regulatory tool. They were meant to help the NOx Steering Committee with planning efforts. Also, whenever the Air Commission adopts a new emissions inventory reporting requirement, there are inevitably kinks to work out. It takes 1 or 2 reporting cycles for the division to get the reports standardized with common data elements and data sources, and you should expect the same to happen here. I get the desire to make adjustments from one ozone season to the next, but you should work from complete data wherever that's possible, which means using the on-gear reports instead of the interim reports, with some limited exceptions as described in Oxy's proposal. Next slide, please. COGA now supports Oxy's proposal to strike Rule 316A to remove duplicative NOx reviews and to streamline Rule 316B and the Form 2D process. This is a change from COGA's responsive pre-hearing statement, where COGA proposed to keep 316A, which tells the director to consider NOx intensity when making recommendations on OGDPs, and to strike 316B. Oxy had proposed the flip side. They would strike 316A and keep the 316B Form 2D process. We are now aligning with Oxy. We are asking you to keep the Form 2Ds, but streamline the submittal and review process, and recognize that it will require a very quick turnaround. This process must be objective and clearly defined to stay on track, and it must also respect CDPHE's jurisdiction. Next slide, please. So when I first read Rule 316B, and I'm speaking as someone who used to write regulations for the Air Division and present them to the Air Commission, I put my regulator hat back on and I asked how this rule would work from an agency perspective. The August 2nd proposal will be challenging for the agency to implement. It is improved on the June draft, but it will be hard to process the Form 2Ds accurately and timely because this is a novel program. This is being implemented very quickly. The interim reports are brand new. The division has not yet finalized the reporting form. The Form 2D deadline is just 5 months from today, and this form has not been finalized or published either. The ozone season will start just 10 weeks after those forms are submitted. They're due February 15th, but really the director will need to process the Form 2Ds in about 4 weeks or less in order to give operators time to implement any new NOx actions. Also, the concept of a pre-season review, pre-ozone season review, is new, and it has several legal concerns. As API Colorado mentioned in its pre-hearing statement, the State Administrative Procedure Act prevents limiting or modifying a license or a permit without a hearing, and any compliance determinations or additional NOx actions must also recognize CDPHE's jurisdiction. Next slide, please. And while the regulatory risks are high, the benefits are limited and unquantified. Rules are normally enforced retroactively with penalties for violations. 316B is prospective and can result in new mandates for the upcoming ozone season. We don't yet know if this prospective review will be more effective than traditional retroactive enforcement. And if it is, we don't know the amount of any additional NOx reductions. So to improve the chances of successfully implementing this new program, we encourage you to rely on your sister agency's expertise. If an operator is in compliance with the division's NOx intensity rules, that operator should have a clear and certain pathway to ECMC approval of its ozone season pre-production operations. And if it's unclear whether the operator has met its intensity target, there should be meaningful consultation with APCD. So what would that look like? Next slide, please. Oxy's proposal helps to reduce the regulatory risks to better align with the potential benefits of this new proposal. Oxy's changes would make the Form 2D process more objective and clear. It uses the final NOx data from ONGAIR with a limited role for interim reports. Their proposal includes meaningful CDPHE consultation as required by Senate Bill 229. It allows the director to take necessary actions to ensure each operator complies with its NOx intensity target, and it includes a hearing in limited circumstances. Our one requested change to the proposal from Oxy is to require the director to act on Form 2Ds by March 15th. This saves time for the operators to request a hearing if they disagree with the decision, and it gives them time to implement any additional NOx measures or adjust their drilling plans. Next slide, please. Finally, we do not believe a cumulative NOx budget is appropriate or should be adopted. Conservation Colorado has proposed a cumulative NOx budget, but the General Assembly did not authorize this commission to establish one. SB 229 recognized the Air Commission's NOx intensity rule, and that bill directed the Air Division to propose air quality rules designed to cut ozone area NOx emissions 50% by 2030. SB 229 authorized the ECMC, after consultation, to require operators to reduce ozone season NOx, quote, to assure compliance with NOx intensity targets, end of quote, and to ensure compliance with other Air Commission rules. But the NOx intensity targets apply to individual operators for 2024, 25, and 26. The Air Commission has not adopted a sector-wide NOx intensity rule, nor has it adopted a cumulative NOx budget. The legislation did not give this commission the authority to promulgate independent rules setting a cumulative NOx budget. It only authorized you to assure compliance with AQCC rules after consultation with CDPHE. And the current Air Commission rules are intended to hit the initial 30% reduction target. They have not yet acted on the target of 50% reductions by 2030. And the NOx Steering Committee will evaluate how to achieve that. So for these reasons, we don't believe it is appropriate or within your authority to adopt and enforce a cumulative NOx budget. Next slide, please. And at this point, I will turn it over to, I believe, Jim Martin for our closing remarks.
Commissioners, there is light at the end of the tunnel. I'm going to very briefly review our conclusions, walk through our presentations again very briefly, and then we'll look forward to your questions. Excuse me. So the first one is the first conclusion. What we refer to you is that oil and gas operations at 2,000 feet or less of receptors have been demonstrated not to present adverse health impacts. And Dr. Collette's testimony doesn't contradict that conclusion. We also pointed out early on that the legislative history demonstrates that modifications to siting were not intended by the legislature or to be pursued in this rulemaking. And in addition, that the post hoc statements of legislators are of little weight in trying to identify the intention of the legislature in adopting Senate Bill 229. A presumptive 1 mile impact area is workable, we believe. It's comprehensive and consistent with CIDR, but we don't want to minimize the challenges of making even a presumptive 1 mile impact area the scope of a cumulative impact analysis. Next page, Christy. Chris just very elegantly summarized that application of a cumulative NOx budget should be rejected, partly because it's inconsistent with AQCC Regulation 7, partly because it forces the commission to pick winners and losers, and partly because it doesn't really advance meeting the NOx reduction targets themselves. Next to last, the Form we also recommend, consistent with Oxy's proposal, that the Form 2D process should be streamlined, and ECMC's decision about NOx intensity should be based on final emissions and production data, and Chris very thoroughly covered that subject just a few moments ago. And I believe last but not least, the enhanced systems and practices, or at least some of them, need additional time for implementation and should not be adopted as blanket mandates for tankless facilities or electrification. Clarity of the closed loop sand systems provision is also needed. And with that, I believe, Christy, is that the end of our conclusions? Great.
Yes, it is.
Great. Commissioners, you've been incredibly patient with us. I want to thank you one and all for walking through this presentation with us. We look forward to your questions. And with that, as Ms. Ryan stated, we reserve the balance of our time for rebuttal.
Okay, great. Thank you very much. Before we go into questions, I'm sure there are going to be some. Let's take a break. We've been going for almost 2 hours. It's 10:15. Let's return at 10:20, or it's 2:15. Let's return at 2:25. And we are working on cumulative impacts rulemaking. We have a large panel before us of 2 hours worth of testimony, and we now have questions. Who has questions for the panel? Commissioner Ackerman?
Thanks, Mr. Chair. I'll kick it off. I just have a few and appreciate the presentations, and thank you for the expertise that you provided here today. My first question, Ms. Woodward, is probably for you, and kind of admittedly requires maybe some speculation, and so take that as you will and speculate or not as you will. And you mentioned that a number of suggestions are unworkable. So for example, requirement of tankless facilities across the board or electrification across the board and a couple of others. And I think Mr. Martin talked about industry working in these directions, but still needs additional time to be able to be more ubiquitous. And so you focused on kind of why you believe they're unworkable in the current time. Other presenters have encouraged us to go that route, and they think that with enough planning and time and effort and or money on a case-by-case basis, that some of these goals could be achieved. So if these things or some of them were implemented in regulation right now, can you discuss your idea of what you think the industry response might be and how industry might cope with or deal with those regulations should they be placed on the books at this time?
Yeah, absolutely. Thank you for the question, Commissioner Ackerman. I think, as it pertains to pipeline, there just will simply be operators who can't get pipeline that is in time, that can meet a temperature and pressure to have a tankless facility, for example. It's important that those pipelines and contracts be put in place well in advance of being able to do so. It also might not ever be cost effective. They may be too far away. They may have landowners who don't want a pipeline connected to that facility. The impacts of connecting that pipeline might be far greater disturbance than the pad itself or not doing a pipeline. And so I think that the impacts of that are simply going to be choosing winners and losers. I think electrification can often be the same. I think there are places where that's available and a great idea. And I think we always strive to do that where we can. But there are remote areas in DICs, as you heard from folks on the Western Slope, where that's not a great mandate for those folks for lots of reasons, including wildlife impacts. And so I think it's not that it can't be done, it's that a blanket mandate requiring it everywhere is not reasonable or necessary. I'm sorry, you're on mute, Commissioner.
Excuse me, thank you. Yes, and thanks for your response. And stepping back just a little bit from that, we've had others testify that have stated that we should require electrification in most cases, but allow for some caveat when it's either not prudent because it would be single use or simply not available. Do you have any response to that stepped down solution a little bit?
I think it also is difficult to implement. I think it's something that needs to be looked at on a site-specific basis for a facility. I know anecdotally from lots of conversations we've had with utilities, with operators, often we can even make that commitment. And by the time you get a transformer, for example, which has a 3-year lead time, that power might be mandated under the charter of a public utility to go to residents nearby, and it's just no longer available. So there's a lot of things that can happen throughout that time frame that tell you whether you're able to do that or not. There's also just equipment that just isn't commercially available to be electrified right now. And so I just think specifically that blanket mandate is a problem. I think it's hard to say 25% should do it. It's hard to say 100% should do it. I think it really needs to be something that an operator and a utility can look at together and choose what they're able to do or not able to do. And I think it's important that this commission also look at the effects and impacts of that. Again, I want to go back to my testimony. I think running highline power and mandating enforcing that through 48.8% of the state as it's desperately mapped out is not the best thing for Colorado's energy policy either.
Thank you for your response. I appreciate that. Dr. McMullen, I think this next one is likely for you. And first, I wanted to say thank you for providing your expertise here today and for your time serving as the state toxicologist. You mentioned that air particulate data collected near wells don't necessarily represent exposures or even potential exposures. And we often hear that air pollutants can disperse more broadly. And even to the layperson, it seems that the air moves about somewhat broadly, carrying those particulates with it. Can you talk a bit more about expected dispersion of hazardous air pollutants commonly monitored at well sites? And keeping in mind in my question that you mentioned that benzene levels documented in the Broomfield study are generally 10 times below those used for health protective thresholds. But to help me understand a little bit more movement of HAPs that may be emitted by operations more broadly in airstreams and the air in general. Can you talk a little bit more about that? Does that question make sense to you?
It does. Yes, it does make sense. And I'm not going to say that I'm an expert when it comes to the movement of air in those pieces from an atmospheric science perspective, like Dr. Collette was speaking to. But I will say, so you brought up 2 points. There's this kind of why I showed that spectrum of the scales by which we evaluate and regulate air quality in the different compounds. So when it comes to HAPs is hazardous air pollutants as defined by the Clean Air Act and EPA. That does not include particulate matter. So particulate matter is what you're alluding to, I believe, what you mentioned about particles. Particles can move greater distances. They can be from multiple sources. And particles generally are evaluated at a much regional level, just like ozone, for example, because ozone is secondarily formed and requires a bunch of other chemical reactions. Hazardous air pollutants, however, like benzene, we focus more on that micro to community scale because we do know that hazardous air pollutants quickly disperse due to their volatility and have a very strong concentration gradient over short distances. And so it really is important when we're looking at the different types of air pollutants, criteria pollutants versus hazardous air pollutants at a very local level, how we collect the data, what types of health risks we're evaluating. Does that make sense?
Yeah, it does, and that's very helpful. Thank you. I appreciate the
Sure.
additional thoughts there.
Yes.
One final question. And this one I think I'm just throwing out to the panel here, but it doesn't have as much to do with your presentation, but another party raised the suggestion of requiring operators to actually demonstrate substantial equivalency under our regulations more technically, i.e. saying, here's how we specifically are either damaging or not damaging in an equivalent manner, as opposed to just citing their specific BMPs that they believe are applicable to a substantial equivalency argument. Do you have any, and this is, I understand, off the cuff, but do you have any thoughts on whether that would be a possible avenue of pursuit and what it might look like, at least preliminarily?
Commissioner Ackerman, can I start off by giving some additional info on your question about the dispersion of hazardous air pollutants?
Thank you, Mr. Colclasher.
Yeah, thank you. And this is Chris Colclasher with Beatty and Wozniak. I just want to emphasize that the timing also matters. It's not just the location of where they disperse, but it's important to look at the duration of the exposure and the duration of concentration. So the COO report, for example, talked about concentrations in plumes with sub-minute data, but it's important to make sure that you're comparing that to the right reference frame. So we see both acute and chronic standards, and any sort of very short concentration should not be compared to a chronic standard or even a 14-day standard for benzene.
That's helpful. Thanks for the additional information there. Does anyone want to take a crack at my last question?
Commissioner, it might be best directed to the operators that are coming up next and who are dealing with the need to, in some cases, demonstrate substantial equivalency. We might defer to them if that's appropriate.
Thank you, Mr. Martin. I think it certainly is. And for those listening, you may get that question. Thanks.
I will offer one comment, if I may, please. The way I understood that proposal was they were wanting something equal to a distance of 2,000 feet. That was something that the commission expressly rejected in the SVP in determining what substantially equivalent means. On page 227 of the statement of basis and purpose, the commission decided, quote, by setting the substantially equivalent standard, the commission did not intend to set a standard that requires the commission to compare potential impacts of a proposed oil and gas location to an identical oil and gas location 2,000 feet from residences. So my understanding of the proposal is that it almost sets you up for failure because you're not looking to a one-to-one match. Instead, you're supposed to use the existing criteria, which I believe the commission has employed very successfully to make prudent decisions, looking at things on a site-specific basis, looking at BMPs, topography, and a number of other issues.
Thank you, Ms. Ryan. I appreciate your thoughts on that.
Could I add just one more? I think if this commission is looking for qualitative data and information that supports the selection of best management practices, there is no better qualitative data than the tens of thousands of data points that we're pointing you to, at least from an air quality perspective, as to how protective these best management practices are. So I would just point to the fact that there is a tremendous amount of data. It's hard to prove that in the negative ahead of time, but there is a lot of information out there.
Thank you, Ms. Woodward. I understand that. And based on that comment, do you think that there is an avenue to analyze and provide that data in a way that could somehow build a case for substantial equivalency?
I think that would be possible. I think it would be a tremendous amount of work and a tremendous amount of effort. But I think that also is just pertaining to air quality, right? Substantial equivalency applies to lots of other constituents. But I do think direct measurement is the best evidence that you have of the efficacy of your protections.
Understood. Thank you. That's all, Mr. Chair. Thanks.
Thanks, Commissioner Ackerman. One quick follow-up, and then I'll call upon Commissioner Oath. Ms. Woodward, you had put out a lot of different data in your testimony from industry. And you just referenced it in the answer to that last question. There are some stakeholders before us that would question the efficacy of data generated by industry. Can you speak to the data, how industry collects it, and or sort of establish how it is, can be deemed to be accurate?
Sure. I think that the data collection methods are based on EPA methods that are very standard. They're based on equipment that is very standard for the industry. They also go to laboratory for benzene, for example, for analysis. I understand that some stakeholders may not want to believe that information, but it's not just operators generating information randomly or ad hoc. It's also reported to CDPHE on a monthly basis, where it's assessed and looked at to see if additional investigation needs to occur. And there is reporting that happens immediately if additional investigation does occur, at which point CDPHE and ECMC in some instances can deploy equipment to go out and verify, look at the site, understand what's happening. And so I think that information is very much a find and fix and a learning opportunity for everyone involved. But I think the data that's available shows that that process is working, and it's everyone working in conjunction. And I would argue the local governments are also providing a wealth of data and information for us to understand how this is working. And so I think it's telling a real success story. It's going to continue. It's part of Regulation 7. It's going to get better as technology improves. But it isn't just operators saying, trust me, here's my information. It's well understood science, and definitely monitored and provided information from other people as well.
I'd also like to say, please, that, excuse me, a lot of the data, it was presented by industry, but it wasn't industry's data. Ms. Woodward also provided a lot of slides regarding CDPHE's CAMEL data. And our slides will, of course, be available to commissioners and to all of the other stakeholders in this rulemaking. They can go on CDPHE's website, they can review this CAMEL data, and they can self-verify that it's as we represent it.
Mr. Koch-Klescher, did you want to provide additional perspective?
I did. I think Ms. Ryan generally covered my points, but I would say as a practitioner who's worked with industry data for a number of years now, we frequently hear skepticism of data that is provided by industry, and I think that's healthy. In this case, Ms. Woodward provided the questions that she asked the operators, was very transparent about the information that was provided. I would just encourage you to exercise that same degree of healthy skepticism when you hear data from other parties as well. So that it's not just industry who may have sort of an interest in presenting data, but other parties who also present data or studies to you have their own interests that they are trying to advance. So I would encourage you to apply the same degree of skepticism to both sides. But again, as Ms. Ryan noted, There is third-party data such as the coup report, such as the CAMEL, that also shows that the risks are very low. And even if you do question the methodology of industry, there was some discussion on Friday about whether, industry was perhaps sampling at the right places at the right times. You would expect, and I say this as a lawyer, not a scientist, you would expect that after tens or hundreds of thousands of data points, if there were a problem, you would see exceedances of benzene, and we're just not seeing that.
Thank you for those answers. Commissioner Oath?
All right, thank you for that. And thanks for covering a number of points from your written testimony as well. I have a handful of questions that I'd love to walk through with you all. So one of the first points that you talked about were proposed changes to the definitions. And so with respect to industrial facility, I want to get a better understanding of what you have in mind, because what you've proposed, I think, is similarly broad and potentially ambiguous. So a proposal that, industrial facility means anything that requires an emissions or water permit that's required by a state agency. So I get, for example, like water permit, are you talking about a water rights permit, a water quality discharge permit? And I'm assuming you mean probably just the discharge permit, but that's not specified. And then even if it's that, knowing that there are requirements for water quality discharge permits for industrial facilities, but there are also water permits required for lots of facilities. So just saying if it requires a water permit, then it's an industrial facility, I think doesn't totally square up for me. So can you maybe talk a little bit more about what you mean there, and maybe take another look at being, if you're intending to be more precise, what that would actually look like? And on the other hand, the emissions part may have some of the same. I just kind of focused on the water part of your proposal.
Thank you for the question. That may be an area where we could refine prior to rebuttal, because I think you raise a good point. Initially, in the previous cumulative impacts docket, COGA had proposed a definition that would have been limited to emissions permits. But in response to stakeholders and trying to be as responsive as possible to the intent behind cumulative impacts, we opened it to water permits as well. And my understanding is that we did generally have in mind water discharge permits, but that would be an area of potential refinement on rebuttal.
Okay, that'd be helpful, because water discharge permits are required for pesticides and reclaimed water and pretreatment and now dredge and fill activities. So I'm not sure that's really what you mean. Okay, thank you for that. On the electrification of drill rigs, and thank you, Commissioner Ackerman, for getting some clarity around this already. In the testimony, you all focused on kind of Conservation Colorado's proposal and the letter from the utility component of this. My understanding of that proposal was that that would be one example of demonstrating where practicable. And so just kind of curious if you all, and I think this was where Commissioner Ackerman was going also, and you, I think, indicated, Ms. Woodward, that there, maybe we can work a bit on how do we implement the where practicable, right? A little bit more direction on some ways in which that would be evaluated in order to implement that. So if you have any additional thoughts on that, I wanted to give you a chance to expand.
I appreciate that. And I don't want to opine. I have lots of thoughts, but I want to collect them and maybe bring them back to you on rebuttal. But I do think that the where practicable piece is the most important piece, and how that's demonstrated, I think we can have some additional discussion around for sure.
Okay, thank you. With respect to setbacks, and I appreciate the testimony acknowledging that there was a lot of information on the record about the small number of applications in the past couple of years that would meet the criteria of being within 2,000 feet of an RVU, et cetera, and within a DIC, but acknowledging that while that has been the case in the past, that I think part of industry's concern is not about that is assuming that there are likely to be more of these in the future. So as the associations representing the industry, I'm wondering if you have a sense of how many we're looking at and what to anticipate in the coming years.
Thank you for the question, Commissioner Oath. I don't. This is anecdotal information. It's probably information better asked of operators. But with due respect, I think the larger point is whether there are only a few or more than a few that come up in the next 5 years. A location ban without informed consent is just the wrong way to go about regulating oil and gas in those areas for the reasons, and I won't repeat the reasons that I articulated. I mean, operators will tell you that sometimes the best location is within 2,000 feet to minimize adverse impacts. And you don't want a location ban taking that decision out of the commission's hands and putting it in a single landlord or tenant. So I don't have the specific number, but to some extent, the specific number to me is less important than sort of the methodology and what the best way of handling those kinds of applications are.
Yeah, thanks, Mr. Matthews.
But I think operators will
I
have a much
understand your
better
opinion
sense.
on this. I understand your opinion on the matter. I was looking for some
Yeah.
statistics to help us understand the context of what we can be expecting when we look at this and the potential impacts. Okay, Dr. McMullen, kind of switching to you, if I may, on this issue of and really appreciate your testimony and going back through kind of the initial study and the conversation around this. However, I think in my understanding of the study itself and in your testimony, I'm still, I think, struggling with whether or not so sorry, I'm not sure how to articulate my question. It seemed like all of this was based on, and I know that you mentioned cumulative impacts and talked about cumulative impacts of VOCs, for example, but that to me is quite different than what we're faced with now, which is a much broader viewpoint of cumulative impacts. And so stressors on people who are dealing with cumulative impact, not just from cumulative VOCs, but also other air things, but also water quality, water quantity, access to healthcare, et cetera, all of the things that are in the statutory directive and definition of cumulative impact. So I guess I'm interested in your thoughts on how to think about the current study, but more specifically, are you aware of other studies that would help us understand proximity and exposure from cumulative impacts more generally?
Sure, it's a really good question. And I mean, we struggle as public health scientists to even cohesively define or precisely define cumulative impacts. And it's because many people are using many different terms. So I was attempting to be, first off, precise in talking about the scope of what I shared with you today is only one facet of cumulative impacts, and that's the air quality exposure to chemical stressors. Cumulative impacts based on EPA's definition of cumulative impacts includes both chemical and non-chemical stressors, which are important, both important pieces from a public health perspective. Those could be light, noise, et cetera, right? So today, what I shared with you was just the evidence related to cumulative impacts of chemical exposures, in particular, the volatile organic compounds of hazardous air pollutants that we measure coming from oil and gas. That's where most of the targeted air quality data related to characterizing exposures has been because of the prioritization of that, of understanding that that is the greatest potential for risk based on the operations. With that said, that's where I shared ozone, particulate matter, other aspects that are affected by multiple atmospheric conditions or, multiple sources are, as you know, handled in multiple different ways by the CDPHE and EPA at a regional level. So with that, when I talk about air cumulative exposures from hazardous air pollutants, like I showed you today, I use a very particular term as defined by EPA, and that's called cumulative risk of all like hazardous air pollutants together. Does that make sense? So you have to think about, people also will say, well, there's cumulative risk could mean from multiple sources, from non-oil and gas plus oil and gas sources. So you have to be very precise in how we define that. That's where air data are in particularly a good metric rather than just the model data, because model data are just modeling a well pad. Air data, like I said, are really aggregating, say, for example, benzene from every kind of source that's out there. And it really, at the end of the day, what are people breathing? And is that at safe levels or not? There are some frameworks of assessing cumulative impacts. EPA's put out more recent documents around that. I think the EJ screening tools that are already being used also help with assessing that. For example, the factors that go into that EJ number to define a DIC include already data on ozone, particulate matter, other compounds that EPA and CDPHE believe are concerns from an air toxics perspective at a regional level. And so it's important to understand that some of those factors are already being evaluated if the operator is, if it's identified that this is going to be in a disproportionately impacted community. Those would be things that would be brought up in conversation with CDPHE, I would presume.
Okay, thanks, Dr. McMullen. That's
Yeah.
helpful.
I don't have a clear, EPA's got some definitions. There's working definitions by different states, et cetera, but it's not an easy thing to solve. You kind of have to look at a lot of these of mitigating them either, the chemicals and the non-chemical stressors, and, like your current regulations have mitigation of these measures of many of the non-chemical stressors, light, noise, et cetera, right? So you generally manage those at an individual level, if that helps.
Yeah, no, I appreciate that. And I think that's kind of what I'm getting at is that I feel like since, in the last few years, I'm tempted to say we've learned a lot more, but mostly we've learned a lot more questions about about what we don't know about the cross-media synergistic effects, right? So maybe they're within a media of water, or within the media of air, we have gotten a better understanding of kind of cumulative impacts, but it's sort of that conglomeration of it that I think we have generated a lot more questions than necessarily answers or understanding.
Mm-hmm. Yes. From my perspective in toxicology and exposure, there are very standardized methods to look at aggregate risk. What you're talking about, cumulative, can be from multiple sources in multiple exposure pathways is what you're talking about. Yeah. We have generally pretty robust scientific information to understand how chemicals interact in the body, which ones we should be concerned about that could cause cancer, for example, or respiratory effects. And in general, when we do risk evaluations, we connect those together. So we're not just looking at chemical by chemical basis. I could have further conversations around the scientific evidence of those statements around synergistic effects. But in general, the majority of the scientific community, you don't necessarily see that if the mechanism by which it operates in the body is different. So it depends on a lot of different things in the body, but we do look at those as toxicologists when we're studying these chemicals, if that helps. And the health guideline values, Ms. Oak, that we use that toxicology like EPA have created, those health guideline values are evaluating all of that when they decide how to be health protective of these types of effects.
That's very helpful. Thank you.
Okay, good.
Okay, my next question is switching to NOx intensity. So Mr. Colclasure, I'm guessing this is probably for you. And so I want to understand kind of where you are with the shift since the responsive. So thanks for going through that. So I guess one point I want to understand is in the event that an operator has not been in compliance with their intensity target in the past, how do you see that fitting into this framework if with your position that 316A should be deleted and 316B modified per Oxy's proposal? So I guess specifically to that point, like, what do you all see as what the outcome should be if an operator has not complied with their NOx intensity target?
So under Oxy's proposal, there are a couple of steps. The first one would be to look at your final annual report based on ONGAIR, and that is data from 2 years prior. But if that shows that you attained the intensity target, then you would be granted approval. If it did not, then you could look at the interim report for 1 year prior and see if the operator has since come into compliance. Again, this is based on the interim report, but if that is showing attainment of the intensity target, then you would be granted approval. And if not, then there would be a more substantive or more detailed consultation with the Air Division to look at the reasons for exceeding the target and look at what any appropriate steps would be.
Okay, but just to make sure I understand, because if I'm misrepresenting your previous position, I apologize. But I thought I had understood previously that your position was that ECMC should not deny a permit, should not have the ability to recommend denial or deny a permit based on their compliance with intensity target.
I guess I would say that Oxy has a good flow chart about how that would work. I think it's worth looking at that. I might defer to them in terms of spelling out the specifics of the steps that they have in their proposal. But if there is, if it looks like the operator may be exceeding the target, we think that it should go to consultation with CDPHE.
And potentially could result in denial of a permit.
I think it could result in additional actions.
Okay. I appreciate that. Thank you. Okay. A number of parts. So for a number of items. So for notice, who should be involved in kind of pre-consultation meetings, and I think one other piece that I'm not remembering exactly now. Some other parties have proposed that the radius for that, rather than the proposed 2,000 feet, should be expanded to the entire scope of the impact area. So if it's 1 mile, up to 1 mile, that operators would need to provide notice to residents within a mile. Do you all have a position or have thoughts on the implementability, feasibility concerns with that proposal?
Thank you for the question, Commissioner Oath. Those are the areas, precisely where operators intend to use sometime this next week to talk to other stakeholders about potentially expanding the radius of some of those notice and consultation protections. I would venture to say that 1 mile in the DJ Basin area for notice, and certainly for some of the consultation provisions, will be extremely difficult to comply with. Just because there will be so many folks involved. That said, and this is a question for operators, the operators who will be following our presentation to a company do an extraordinary job at notice and at community events prior to the OGDP being submitted and during the process. You should ask them the mile question and see what they say, because a lot of their efforts are quite expanded already beyond the 2,000 feet.
Okay, thank you.
All of which is to say, to be continued. You know, I think that's precisely one of the areas that we're planning on discussing with Green Latinos and other NGOs about how far out notice and consultation provisions should go in DIC and CIC areas.
Okay, thank you. I appreciate that. I'm glad to hear that you plan to have more conversation, and definitely will be interested in hearing the operators who are coming up, their thoughts. But just one quick clarification. You said on the western slope, it would be so many people, which I think
no, it's the DJ Basin Commission.
Okay. All right,
Yeah.
thanks. That was my last question, Mr. Chair.
Commissioner Messner?
Thank you for the presentation, the information, lots of information provided, and appreciate you all being here and engaging. Just a couple of questions, but I'll start just with a statement for Mr. Kolkischer. Have no fear about healthy skepticism. I have healthy skepticism about everything, and so I appreciate that point, though. So, Ms. Woodward, just one question about the electrification piece and kind of the additional refinement of, you know, how to determine as practicable in the local government permitting processes. There's lots of applications that require letters from electricity or utility providers that are will-serve letters. And it's a pretty standard process for almost every local government that I'm familiar with. And so I guess I'm struggling with your concerns about the ability to obtain such a letter for operators, but developers in the local government scheme get them on a regular basis.
I'll defer to Mr. Martin. That was his comment, but I can say what I do know, which is that there are three types of utilities in the state. There are municipal utilities, there are public utilities, and then there are small rural electric cooperatives. They all have different obligations for any type of land development than they do for industrial development. Excel, for example, it's my understanding their charter would mandate you provide electricity for residences before you would provide electricity for the oil and gas industry for an industrial activity, for example. And the only time that applies is for oil and gas and for mining. And so they have different criteria for those types of development, which I think would prohibit their ability to be able to say that they could do that. They will always tell you that they can do that. The question is, how fast, how much is it going to cost, and will it get there in time and be reliable, quite frankly. But I'll defer to you, Jim. Sorry.
Commissioner, I think Ms. Woodward actually provided a brilliant response. There are different kinds of utilities. They have different protocols for handling these kinds of things. Sometimes drill sites are proposed within two different franchise areas. One, it might be an REA, one might be a utility like Piesco, Excel. But of course, they'll provide will-serve letters. Question is whether they'll provide you a letter that they won't serve you. And that raises technical and legal issues for the utility. But there are a host of issues go into deciding whether or not it's possible to extend electrification with a high line from the nearest substation to the drill site, and whether that substation can handle it, and what the timeline is for getting things like transformers. And Ms. Woodward mentioned that the supply chain is 2 to 3 years for a transformer. The supply chain for a wooden pole can be a year to 18 months. So it is a moving target for an operator trying to figure out whether or not 2 years down the road, they'll be able to assure there's electrification at the site for drilling, and then hydraulic fracturing is an entirely different matter as well.
Thanks for the response. I think the question though is, understanding that, at least in my experience reading a number of will serve letters, they actually talk about all those things. And so the will serve letter talks about the availability, the timelines, the challenges. And I'm not acknowledging the challenges with some areas. And I think local governments deal with multiple utility providers, both co-ops, rural areas, as well as municipal electricity providers. I think the thing that's being contemplated by some stakeholders is that documentation that determines the discussion and highlights the challenges or lack of challenges of electrification of any particular site to help inform this concept of if practicable. And so I guess I'm struggling a little bit trying to understand what the pushback is, because it seems to go hand in hand with an argument of practicability. But maybe I'm misunderstanding.
I'm not sure we're disagreeing, Commissioner. I think it comes down, perhaps it was Commissioner Oath, but it comes down to how you define practicability and what goes into deciding whether or not it's practicable or not. But I don't think we're disagreeing.
Okay.
I think also timing is really important, right? Like if you're planning a project, the planning people I've been working with at Excel, for example, describe this as like they're the Titanic and the oil and gas industry is a bunch of speedboats moving around them. And they're trying really hard to gauge and understand what that looks like. But, these are short-term activities that can last up to 3 months. They require a tremendous amount of power. Again, I question like the policy, the electrification policy for the state as to whether providing this much highline power for temporary activities is the right answer or not. And I think the utilities struggle with that in the same way. And then when we're planning a project that is short duration versus a long-term development that's going to be there for a long time, that parameter that we're talking about and that metric for what's, available is very different.
Yeah, I think these are all fair arguments, right? I was just trying to sort out the demonstration of practicability. And I think the appropriateness of high lines in certain areas is an issue. I hear you with the timing and the short-term duration. I understand the challenges, and I think you've articulated those well, but I think I'm also trying to just, with healthy skepticism, look at all the different proposals and make sure that I'm understanding the arguments that are being made. So, but thanks, it's good information.
Could I add one final point to that, Commissioner Messner? So the proposal about requiring operators to get a letter from utilities saying that they are not able to serve it. I hear what you're saying, that a will serve letter could address some of those challenges or the timing of bringing in power lines, but those letters are written from the assumption that the customer, the operator, is going to pay the cost of bringing in the power line, and that is not going to be captured, and it is a necessary factor. Also, if you're expending very high amounts to save a small amount of emissions, it may not be worthwhile.
Thanks for that point of view. And then my other one is trying to understand the opposite. I mean, I've heard a lot of data about, air quality monitoring. I think it's great. I think Ms. Woodward, you talked about 8 or 10,000 data points, and I mean, this is good. I also hear pushback for baseline monitoring to, again, kind of help establish baselines to help, I think, make arguments that there are or are not cumulative impacts associated with any particular thing. So maybe help me better understand kind of the pushback against some expectation for baseline monitoring at locations if data is good and it helps ultimately make arguments like you're making today.
Yeah, and I'll ask for some support from Dr. McMullen here, but I think, the data that you're seeing is indicative of what I think baseline data shows across the state of Colorado and nationally. And so having that wealth of data. And, we're presenting 10,000 data points today, or just shy of that. We presented 6,500 historically. It's important to note that that's not all of the data that's out there, right? That's just a subset, but a healthy one. And so I think when you're seeing that healthy subset of data showing you that the readings during these activities are consistent with the baseline that you're seeing either outside of these activities or not present during these activities, then what's the justification for collecting additional data except for the sake of collecting additional data? I mean, I don't know that we'd be necessarily opposed to it. I just don't see that it's warranted given the volume of information that's available. Tammy, would you add to that? And please correct me if I got anything wrong, but.
It's a really good question. And I'm actually questioning that too with respect to the current draft regulations. Commissioner Mesner, is what if you have to look at an incremental increase, what does that mean? How do you define that? You need something to measure what incremental is. If we're concerned about public health risks, then we have defined thresholds at which we evaluate operational changes further, that we would say, hey, there may be something we need to look at further. We don't want, we want to be protective of public health. If we're meaning in any incremental change, but yet could still be significant from a public health exposure and risk perspective, that's very different. Kind of like I showed today, one way to look at incremental changes is to look at baseline regional air quality in areas where and there's plenty of data from CDPHE. CDPHE collects it as part of their national ambient air quality monitoring systems. And I use that on a regular basis to evaluate what is kind of normal range of these chemicals that come from multiple sources. That can be one effective way. It's also a standardized method by which EPA recommends when you're looking at site-specific contributions from a source when it comes to air quality. Does that answer a little bit of your question? I think there's.
Yeah, I think it. I appreciate your responses. And understanding that there's existing data for regional baseline, I think, is what you're testifying to. And this is not my area of expertise, so
I get it now.
Maybe talk a little bit about the benefits of having more localized baseline monitoring, or not monitoring, but a baseline standard. If there's a presumptive 1 mile impact area, and regional, at least my interpretive regional, is bigger than that. Is there benefits to the baseline, the development of a baseline to determine incremental increases or other things that may be expected of operators?
Yeah, I think there's potential for that. I do know that some cities have actually developed local air quality monitoring programs. And it could be, it's useful for a city to do that beyond the scope of just oil and gas development, because, there's, car emissions are one of the highest particulate matter, emission, mobile sources, right? We know that that's very clear. So if local governments are concerned about air quality, what somebody's breathing, it shouldn't just be hyper-focused on oil and gas development, but they can put a regional, or a localized air quality monitoring network. And many of these cities have done that. Denver, I believe Aurora did at one point, Broomfield, et cetera. So that is one option, and that provides understanding of just local air quality that can also then be partnered with data that's more site-specific when these operations occur. The biggest piece is really in the design of that. You need to understand where, meteorology, for example, right? Because just putting stations out there, and because these compounds come from so many sources, my experience is in any kind of urban area, you're just going to see spikes of stuff all the time from, it could be, if you put it near a school, we see spikes when the parents drop off the kids at 8 a.m. It's very consistent. If you want to see some high benzene spikes, just put it right there where kids are dropped off because of emissions from the cars. So all those things are really important to think about. But yet it could absolutely add to the database, Commissioner Mesner, to help understand changes that could be impactful. Yeah.
It's also worth noting that Reg 7 does have a requirement for 10 days of baseline monitoring before commencing pre-production operations. So there is some on-site data that will be gathered to give you, a reference point to look at how emissions are changing over time.
And may
Right.
I add
That-
one
That's
additional?
limited to benzene though, is that right?
The Reg 7 requirement does not specify which pollutant you would monitor for. It just requires 10 days of baseline and 6 months of early production monitoring. Yeah, the operator submits a plan to APCD for approval as to where and how they would monitor.
It does give you options, though. I think there's 4 or 5, right? There's a specific, it's total BOC, methane. There's a couple of things that are choices.
Okay. Thank you. I don't have any further questions.
Further questions for the panel, Commissioner Cross?
Thank you, and I apologize. My microphone still seems to be having problems, so I'll try and be slow and loud. I also want to thank my fellow commissioners because several of my questions were answered, and I'll try and go through mostly the same order of your presentation. So Ms. Ryan, I have a couple questions for you. The first is talking about the cumulative impact definition and how it affects the impact. And the first thing I want to talk about is the would versus might argument that you made. Because I know that often comes up in NEPA litigation a lot of times about making sure it's something that can be specifically tied to. It's not speculative, and it's really tied to it. So if you could go into a little more detail on the would versus might, and also explain how we can properly evaluate, aside from addressing evaluate, if we're only looking at known.
Sure. Thank you for the question. I think with the would, you have to look at things that are known and then things that are, I hate to use this phrase, but reasonably foreseeable. Because if you are looking at some of those more speculative impacts, that won't be helpful in your analysis because it will always overstate the impacts and it won't give you, the commissioner or staff, a real sense of what is being proposed. So I think some of it is an art, not a science, and it'll depend on staff's expertise and also operators' experiences. But I would say it's been working well in the existing CIDR process and the Form 2Bs when operators already have to explain what they think is going to be an impact. And I think even by thinking of the definition of reasonably foreseeable future development, it kind of captures that concept that when we're looking at cumulative impacts, we want to think of things that are likely, more likely than not.
And I guess just to build on that a little bit, we're seeing the arguments kind of both ways. The standard 1 mile, it should be bigger than a mile because impacts can occur beyond a mile. And we're also getting some operators from the West Slope saying it might even be limited to less than a mile because of things like topography, et cetera. And so I'm curious if you're looking at wood and as you said, kind of more of art than, we're trying to look at things the best we can. Does it make sense then to keep it at a mile, or does it make sense to say, really, we have to look at those different categories of issues that could really define how far an impact might go, whether it's topography or weather or
Well, I think it does make sense to keep it at a mile because it is more implementable, as staff found when it revised the SVP that it put out on August 29th. And then when there are specific circumstances that deserve a closer look, or in this case, I guess a further look, about a specific impact, then that will be dealt with at the pre-application consultation. So the mechanism is built in so that that safety valve is already there. But because operators spend so much time, resources, manpower, even getting to a pre-application phase, they have to have some sense of the universe that they might eventually be able be asked to analyze. And so starting with some place, at least that gives them a springboard to know where they need their consultants to look, where they need to start drawing maps, how are they going to choose a location. So they just need a starting point.
And that's very helpful. And then the second question I have related to the impact area is, I think there's been a lot of discussion of, even if you want to look at a mile and look at something more standardized, should it be from the working pad surface or should it be something broad? And so, for example, we heard even earlier today, people talking about locations where there's going to be disturbances. And so what is your response to the idea of having the impact area be maybe still at a mile, but should it be a mile from not just the working pad surface, but also from where the access road is?
This is not a question I've necessarily discussed with members, but I think working pad surface still is a great starting point, again, because of the consistency and predictability. It also makes it consistent with other rules. And I think, again, there are protections in the existing rules and the rules as drafted to where, as needed, you can ask it more information about those traffic patterns. For example, CPW regular in its consultations will ask about traffic plans, and the rules do require a traffic plan. So it's something that you can look at without needing a blanket rule for it, because if something about the application leads staff to have a question about the traffic, they can do that already. But again, so the operator can just start with an idea, start their planning. They just need something to hold on to, and a working pad surface makes it consistent.
Thank you. And then I don't know if this next set of questioning is maybe best geared towards Ms. Woodward, but I want to talk about the electrification again. And I say maybe towards Ms. Woodward because I know you talked about it some, but others did as well. And I want to build a little bit on what Commissioner Messner was talking about. We have obviously heard some proposals that the requirement for electrification be prescriptive in our rules. And at least I personally think that as commissioners, we maybe don't have it be prescriptive, but we already try and encourage that. CDPHE in their consultations looks for that. But what are your thoughts on the need for electrification to be prescriptive? And given that it is already something that I know operators look at, it is already something that commissioners are looking for, that CDPHE is considering in its consultation, do you have a problem with it being prescriptive?
A quick clarifying question: for drilling or for facility or for both?
Well, I'd say for drilling and for facility both. I think less at this point in time on fracking, because that's still a work in progress, I think, technology wise, but I think for either.
Yeah, I think that there are instances where we can, and we're going to explore this more, I think, in rebuttal based on an earlier question, but I think there are instances where it might be able to be prescriptive, depending on your distance to highline power, what equipment on the facility can be electrified, what that looks like. It's something we explored in great depth in Regulation 7 when we looked at NOx intensity. And there is a very good reason that that rule came out the way that it did. There are prescriptive best management practices for drilling, and there are prescriptive requirements in that regulation for even facility electrification. And yet we still have a NOx intensity, so that we have the ability where we do not have highline power, or it doesn't make sense from an emissions perspective to get things like tier 4 gen sets to run drill rigs, et cetera, et cetera. And so, Chris can speak to it too, but we spent a tremendous amount of time. That's why I developed a board game, honestly, to be able to talk about it, and why that rule has both prescriptive BMPs and flexibility. And I would encourage this commission to defer to the work done there versus being overly prescriptive here. Or we're going to need to have a lot more descriptive conversations and a lot more stakeholdering probably to get to that prescription that you're looking for.
And then I think somewhat related to that, and again, going back to some of the questions that Commissioner Metzner was asking, there was talk about the will serve letter, the availability of the will serve letter. And I think one of the things that we as a commission struggle with already is when we get the as practicable. And sometimes you get people that say, listen, we already talked to them, we already put some payments forward, we're still not 100% sure on the time, but some people have a lot more information, and others say, we talked to them and they said it wasn't going to be possible in that time frame. Do you have suggestions, again, looking at things that this is already aspirational goals? Do you have any suggestions about how, if not a will serve letter, some ways that you could have that demonstration of available to the commission to say, yes, we did put our best foot forward on trying to do this. We did everything we could, but it's not practical.
Yeah, I really want to take that back. I want to give it some more thought. I want to talk to some of our utility partners and understand in different regions where that would work and what that could look like. Because I'm not sure. I know, for example, in some parts of the state, an operator will have to go and pay a utility to do an assessment that could take 6 to 8 months, could be several $100,000 for them to just determine whether they can electrify your facility or not. Other areas, they're more willing to look at a regional approach and say yes or no, maybe this is feasible, that isn't. And so I guess the answer is every utility is different, and so it's difficult, but I'd love to take that back and bring it back to you.
Okay. And then I think, Mr. Matthews, I think I'll have 2 questions for you. And I think one right away is, you talked about pushing back the enhanced systems and procedures until 2026 for the new activities. And I'm curious if you could provide a little more detail as to why until 2026, why not in the spring of 2025 or even the ozone season of 2025.
And before you answer that, Mr. Matthews, I was going to piggyback. I had a question in the same regard. Is the proposal to push back implementation of all enhanced systems and practices, or is it that some can be done now, some could be done later? So that was kind of my follow-up question to Commissioner Cross's question.
Yeah, so actually, gentlemen, this is not an issue I addressed, the enhanced systems and practices. Christy, I don't know if you want to handle this.
Yeah, I think that's another one that is a better question for operators. But I do know, anecdotally, we talk about this again when we do air regulations, and often there is a lead time by which that rule needs to be implemented on a blanket basis. And again, we had those ESPs that we did not support, tankless facilities, pipeline requirements, and electrification. But for the others, I think there is just a need for longer lead times and more flexibility in the BMPs. So I could get more specifics for you, but I think you'll get a better answer and a better understanding from operators who are dealing with that every day. But it's rare that you can effective 15 days later implement something like that without having planned, purchased equipment, had staff, understood what you needed to do, how you report it. But there's always some kind of effective date at a later time for air requirements that are blanket.
Oh, thank you. And I think, Mr. Matthews, my other question for you is, and I appreciate you responding to some of the requests that we've had going into this rulemaking, and listening to some of the parties' proposals as well, and saying we're willing to talk with the other, we'll call it the other side, even though I don't think there's really sides here, but about potential resolution of ideas and things like notice. Again, understanding you're not talking about standing, but notice, provide whether it be distances, times, that kind of stuff. But I was curious if you had any thoughts as well. Another one that jumped out to me was the community engagement, because as it stands now, the community engagement would be something that only occurs if within 2,000 feet in a disproportionately impacted community. I'm wondering if you know if operators have a thought about that applying within 2,000 feet, regardless of it being disproportionately impacted.
Yes, that I can't take a crack at. Operators are certainly thinking an awful lot about community engagement in discussing some of the proposals by Green Latinos and others. I heard a fair amount from operators about their community engagement programs, and they're pretty darned impressive. So, Commissioner Cross, whether they extend beyond 2,000 feet or not, I suspect they do, but I think I will let them answer for themselves as to what they currently do for community engagement and what they could do in DICs and CICs as part of our ongoing discussions this following week. But thank you for the question.
And I appreciate that. I assumed that might be what your answer would be, but I figured I'd see if you had any kind of feedback thus far from constituents. And then I think moving on to Dr. McMullen, again, building on a couple of the questions that were already asked by my fellow commissioners. One is you explained in some of the responses to Commissioner Oath about looking at particulate matter versus looking at the VOCs and how it's more of a greater distance. The dispersion is really what's taken into account a lot of that. And I'm curious, one, what are some of the health risks from the particulate matter, as you talked a lot about the VOCs and that?
Yeah, sure. Let me also just first preface that when we're talking about, say, for example, ozone, there's also, CDPHE and air quality scientists also look at some of these hazardous air pollutants because they are precursors to ozone. So I wish it could just be very, very clear, but the chemistry, and I am not a chemistry expert when it comes to atmospheric chemistry, but Dr. Collette and others could probably speak to that. But it's why we have to look at it at these multiple scales, right? And why Air Pollution Control Division and EPA evaluate that. So let me preface by also saying that when we talk about particulate matter, for example, or any compound, and you asked what the health risks are, you have to make that that's very different than what we know at any concentration under any exposure condition, what the plausible health effects can be of something like particulate matter. So as you think about it, or when you hear concerns that it can cause X, Y, and Z, such, for example, particulate matter can cause respiratory effects under certain exposure conditions, there's also associations with birth outcomes under specific conditions, specifically mainly diesel particulate matter, which is also primarily driven by vehicle traffic. So what matters when we talk about exposure is it's not just what's in the air, it's how much, how long somebody would be breathing that in the air, and under what types of conditions, how frequently. Those are some of the key factors that we look at as toxicologists when looking at exposure. So that defines the risk. So there's the toxicity of that chemical, under any condition, its inherent properties causing it, and then that big piece of exposure, which is why I share so much data around what do we measure in the air, and are those measurements at levels that we as regulators look at compared to those protective health guidelines.
And that's very helpful because that segued well into my next set of questions.
Okay.
And that was, there was a lot of talk about VTEC, specifically benzene and the cancer risks associated with benzene. And understanding, again, because of the dispersion, you're looking at more of the direct impacts, and you're putting it in reference to the proposed setback. And so I'm curious, because we also do hear people not just talk about benzene and cancer risks, but as you mentioned, respiratory issues like asthma and birth defects. And so I'm curious, especially as you labeled this as levels of protections kind of with identified risks, how or whether, and if so, how a setback may or may not help with the risks beyond the BTEX, the particulate matter, some of the additional things like that? Is it simply because it disperses so much, it can't really be looked at as a setback, or I guess explain that?
Yeah. So particulate matter we care about that at a local level too, right? So if it's high enough under certain conditions and operations, there is the potential to cause health effects too. So that's different than the way maybe ozone is, that means some transport, chemical reactions, et cetera, secondary formation. So I don't want to minimize that particulate matter is also something that we evaluate from many types of sources. It primarily will come from combustion sources if we're talking about diesel particulate matter. Again, I go back to thinking about this from the framework of source of what are the controls, what are the best management practices that are in place today to minimize emissions, to minimize combustion, and emissions of combustion products already at the source. And does that translate to something someone's going to be breathing somewhere else, right? So we do want to look at particulate matter, benzene, BTEX. They all can cause different types of health effects. Some of them all depend on how much and how long. When we do an evaluation of cumulative risk, Commissioner Cross, as the modeling that I had shown you, but I simplified it a lot, or even when we've gone out and collected data, like our team has, and a lot of data I shared in 2020, I'm not just looking at one chemical. We look at all the compounds that we believe could be emitted from both combustion and non-combustion, like just emitted hydrocarbons. And then EPA's method for looking at could multiple compounds that cause respiratory effects or multiple compounds that could cause cancer, you add those together and you come up with something that's like a cumulative number called a hazard index or cancer risk number of total cancer risk. So we do look at those. The reason, for simplicity's sake, we often now have targeted in on benzene is it's kind of like a sentinel for us. Like there's so much data now to know that, first of all, particulate matter, diesel particulate matter is so minimal because of Tier 4 engines, all of these other best management practices, that it's pretty negligible from an emissions standpoint. But what really drives risk is benzene. And we know it because it's pretty toxic at relatively low concentrations. And while it may not cause respiratory effects, we do care about it from a lower concentration over longer periods of time. So that seems to be, so when we look at those guideline numbers, it's one of the lowest ones. So it's almost like if that one, it's always triggered before pretty much anything else. But did I answer? Does that help?
I think so, yeah.
A little bit. I mean,
and I don't know if it was the best question, but I do think that's helpful in trying to understand, because obviously we talked a lot about avoid, then minimize and mitigate if you can.
Yeah.
And so trying to understand in terms of, as you testified to, trying to put this in relation to a proposed setback. Is it necessary to have that setback? What kind of thing? And so understanding that the reductions in emissions and things like that is also a trigger is helpful.
Yeah, absolutely. And that's kind of why I showed you where I compared, for example, benzene data to background levels. I mean, I'm not sure how much more at distances of 2,000 feet, essentially, where we are at a setback, you can reduce it beyond background from every other source. And it's one way of looking at it. I also showed, for example, the Broomfield data by distance. You could, if theoretically you saw some type of gradient, and you could say that's a reduction here versus here, but the data are not necessarily showing that at the existing setback. And therefore, someone like myself that does risk assessment to inform management of risk there's not an identified risk at 2,000 feet to manage further, in my opinion.
That is very helpful. Thank you.
Okay.
And then I think my last question is for Mr. Koflischer. And that is, and again, I fully anticipate we'll hear more about Oxy's proposal when they give their presentation. But looking beyond what Oxy was proposing, you had some discussion about the problems identified by APCD and AQCC with respect to the interim data. And so understanding those inherent difficulties with that data, I'm also curious how you respond to the issue of, if you only look at the ONGARE data, as you said, you're looking back 2 years prior. So how can you look at more recent data if not relying on the interim reports?
I think those are two competing goals, right? You want to use the most recent available data, and you also want to be accurate. In my view, the interim reports are not usable for regulatory purposes because they don't have the full calendar year production data for the most part, with some limited exceptions. So the way that it's spelled out, and again, I think Oxy's flowchart is a good resource. You'd start by looking at the ONGARE data for 2 years prior. And if that shows some concerns, then you could look at the interim reports for the 1 year prior. But you recognize there that you're working with less than complete data. And so that's where the consultation really becomes more important, to look at any additional information the Air Division can provide.
Okay. And I think that's all my questions. Thank you very much for the detailed presentation.
Further questions for the panel? Ms. Shea, Commissioner Shea?
Yeah, thank you. And I make this brief because I know folks probably need a break. So I only have a couple questions, as most things were, I think, discussed already. My question is for Ms. Woodward. And you mentioned in your slides, and I apologize if you mentioned this and I missed it, but for all that, the benzene air monitoring data that you presented on, do you have details on the distance from the emission sources? I know you said that these were Reg 7 required monitoring data sets, but was just curious if your analysis looked at distances as well.
Yeah, thank you for that question. The operators told me in the survey that they pulled most of those samples from between 100 and 200 feet. So some were 100, 150, 175, no more than 200 feet. I could ask for the benzene data specifically and get clarity to make sure that that's still true, but that's what the survey told me associated with the data when I asked for it the second time.
Okay. And then I was just curious, and maybe you don't have data on this, but how your analysis handled background concentrations?
It does not. It just is the straight data that was pulled from those sites.
Okay, that's helpful. Thank you. And my last two-part question kind of builds off what Commissioner Cross had asked Mr. Colclasure. You had mentioned that the NOx interim report data could be incomplete or preliminary. I was just curious if you had specific concerns and maybe examples of why some of that data might be incomplete. And was it just, sounds like production data is probably one of those concerns. But if there was other information that you felt like could have that chance of being, incomplete, preliminary.
Yeah, the production data is the most important one, because the time period of production data in the interim report doesn't match up with the time period that's used to determine attainment of the calendar year NOx intensity standard. So the interim reports are going to have a rolling 12 month data report on production. So it stops in September of the current year, and you miss October, November, December. And that might not have as big an effect on a large operator where they are drilling and completing some wells every summer. But if you're a small operator who maybe did not drill and complete any wells in 2024, but then you do in 2025, your production will be much higher in the fourth quarter of 25 than it was in 24. If one of just a limited number of wells has come online and you're at the peak of the production rate before that well starts to decline, that could make a very big difference in either attaining or exceeding the intensity target, because you need that production, that volume in your denominator to attain. So that's my biggest concern. And then the second one is just the company's ability to collect the emissions data between May and September, review that internally, make sure that it's accurate, and get it submitted by November 30th. They will clearly do their best to get that complete and accurate, but it does take time to run these numbers down, and there could be additional revisions before the on-GARE report is filed the following June.
Okay, thanks. That's helpful. And then I guess just to build on that a little bit, like what are your thoughts on, if NOx intensity is just one of the many, data points and tools used to determine approval or denial? Are you still like, how do you feel about using the interim reports, or what's your position on that?
I think it makes more sense to use the final data when it's available rather than sort of jumping the gun with interim reports.
Okay, thanks.
Other questions from commissioners? All right, I think you've exhausted us. Thank you very much for the presentation. Let's take a 10-minute break before our next scheduled case in chief. We will return at 3:56. All right, commissioners, we are going to alter the order of the next presentation, and we're going to take up Civitas Resources this afternoon, and then Prairie Operating will start out tomorrow morning. We've got about an hour left in the day, given some commissioners' commitments this evening. So with that, I would recognize Ms. Ryan.
Right, thank you. One moment, please, to share my screen. All right. Did everyone see that?
Yes, we can see it now.
Great, thank you. So good afternoon, commissioners. Long time no see. My name is still Julia Ryan, shareholder at Brownstein, appearing on behalf of Civitas Resources. Civitas thanks the parties who have preceded it for their thoughtful participation, and the commission and its staff for their efforts so far in this challenging rulemaking. Our presentation will cover certain enhanced systems and practices in the August rules that the ECMC should not adopt as mandatory requirements, a vagueness issue in the August rules, impact area considerations, Rules 604 and 316 D4 in the prior June draft rules that were properly discarded, and finally, air data and other issues. Joining me in the presentation will be Nathan Bennett, Director of Permitting and Compliance at Civitas, and Kathy Stearman, Director of Air Programs. Before we jump into the substance, I will briefly introduce Civitas to you, familiar to many of the commissioners, but perhaps not everyone. So Civitas was formed in 2021 with the merger of 4 Colorado companies and quickly emerged as an environmental leader. Civitas was Colorado's first carbon neutral oil and gas producer and is continuing with its environmental stewardship. For example, Civitas is committed to reducing Scope 1 greenhouse gas emissions by 40% from its 2023 levels by 2030. And in fact, Civitas has already achieved a 41% reduction in Scope 1 GHG intensity from its 2019 baseline. Civitas is constantly evaluating new opportunities to reduce or eliminate operational emissions through various emissions reductions projects, including the use of grid electricity where it's available, retrofitting legacy facilities, plugging inactive or legacy vertical wells, and robust inspection, leak detection, and repair protocols. Civitas is proud to provide responsibly produced energy to the market. Civitas supports common sense, reasonable and necessary regulations that will evaluate and address cumulative impacts while providing a stable framework through which the industry can efficiently and effectively operate. Civitas looks forward to its continued participation at this hearing, including reserving all time we do not use today for rebuttal and closing. I will now turn it over to Mr. Bennett.
Thank you, Ms. Ryan, and good afternoon, commissioners. I appreciate the opportunity to provide testimony as part of this rulemaking. The focus of my brief testimony today will be centered around Draft Rule 316C4A and the feasibility of what is being proposed. The proposed rule would apply to all oil and gas locations requiring a Form 2A on or after January 1st, 2025, which are located in a DI community in the ozone non-attainment area. As has been mentioned previously, almost 50% of the state of Colorado is considered a DI community. Geology being what it is, and petroleum reserves being where they're found, as a practical matter, this proposed rule would apply to an overwhelming majority of the DJ Basin. The broad application of this rule is unnecessary, unreasonable, and may result in unintended consequences. The prohibition of on-site storage tanks for liquid hydrocarbons and produced water and/or the requirement of oil pipelines at all locations is neither feasible nor practical. Permanent storage tanks for hydrocarbons are required in most instances, including when an oil and gas location is serviced by an oil pipeline. These tanks, which include emissions controls, are required to stabilize the liquids before they leave location via pipeline or via truck. From a safety perspective, the use of storage tanks provides a storage mechanism when maintenance or upset conditions occur on pipeline systems. Specifically, a location can continue to produce if an upset condition occurs on an oil or produced water pipeline gathering system. In the event a location cannot produce into these pipelines without tanks, the wells are always shut in and may require certain operations, for example, swabbing or liquids unloading, to restore production operations in the wells. A tankless location requires a high vapor pressure or HVP oil gathering system, which are rare. One of the key differences between tanked and tankless locations is where the liquids are stabilized. HVP oil gathering systems rely on centralized stabilization facilities where critical mass is necessary to justify the means. Typically, HVP systems are designed to serve a single operator and gather large volumes of their oil production. A complex network of midstream infrastructure is required to support an HVP system, including miles of pipelines. Similarly, produced water pipelines have limited applicability without being proximal to an approved underground injection control well or a centralized E&P waste management facility, especially and specifically in the DJ Basin. It is well known that the Niobrara and Codell formations in the DJ produce small quantities of water relative to other basins. Coupled with other variables, low water production and the current lack of produced water infrastructure throughout large portions of the basin, render this proposed rule an impossibility. Pipeline infrastructure requires a unique linear disturbance footprint that can be broken up into two distinct phases, temporary and permanent. For simplicity, let's assume that the temporary disturbance required to conduct a pipeline corridor is 100 feet wide. A disturbance of approximately 12 acres is required for each mile of pipeline that is constructed. The permanent disturbance corridor, required to maintain and operate a pipeline is approximately half that, 50 feet wide and 6 acres of permanent disturbance for each mile of pipeline constructed. While pipelines are often co-located with each other, if the destinations are different, say a gas processing plant, a centralized oil stabilization facility, and an underground injection control well, there will be a point at which these lines go in different directions, thereby necessitating multiple pipeline corridors with similar types of disturbances. Additionally, the greater the number of lines in the same corridor, the wider the corridor needs to be. Both the temporary and permanent disturbances fall into that bucket. Currently, local government is the sole jurisdiction with pipeline siting authority for the types of pipeline infrastructure contemplated by the draft rules. Local zoning designations can influence or impact the ability to site pipeline infrastructure, and in some instances, this could result in greater disturbance throughout the project area. Not only is a proposed pipeline subject to county and/or municipal code, an operator must also have a legal right to construct a pipeline across the surface estate. Since operators lack rights of condemnation and eminent domain authority for the types of pipelines contemplated in the proposed rules, if a landowner is unwilling to grant a legal right-of-way or easement across their property, the project is unable to move forward. That is, building a pipeline system is not as simple as connecting two dots with a straight line, which frequently results in additional surface disturbances miles away from an oil and gas location. All this is to say that not only are pipelines not always practical or possible, but their impacts can be significant and do not necessarily outweigh their benefits in every scenario. Obtaining the electrical power necessary to power permanent production operations at oil and gas locations is not practical. The electrical capacity, in whole or in part, needed to power facilities and other operations may not exist in many instances. The infrastructure needed to deliver electricity to an oil and gas location may be lacking and require significant improvements and investments to be viable. It could also be non-existent and require greenfield development to be viable as well. In the rapidly developing Front Range, there are competing priorities for electrical demand. Operators are competing with other development, such as new build residential or commercial land uses, which can be problematic when trying to source electricity for an oil and gas location. The engineering assessment needed to ascertain the availability of and timing for electrical services is complex and includes considerations above and beyond a single location and current electrical demand. These and other factors can result in timing delays and a lack of service. Further, it has been our experience that utilities are extremely reluctant to provide a written denial of service when they are unable to fill a service request. Commonly, the ability of a utility provider to service an oil and gas location with electrical power is couched in feedback providing in meetings where the feasibility, that is, what can and cannot be accomplished, of the service request is discussed and tacitly denied. The concept of using renewable energy to power operations at an oil and gas location has significant challenges. Most notably, both solar and wind power are intermittent. Oil and gas operations are not. Regardless of the technology, substantial surface disturbance is required for power generation and storage. For example, a solar array sized to power an oil and gas location could add an additional 8 acres of additional disturbance to an oil and gas facility. It's important to stress that storage, usually via large batteries, is a requirement given the intermittent nature of renewable power, specifically relative to the constant need for power at an oil and gas facility. The footprint necessary to site the batteries is not included in the previous example. It's important to note that our industry commonly does use solar power for certain functions today. Specifically, small solar panels and associated small batteries are commonly used to power automation equipment. Importantly, this equipment is also tied into the facility power source for redundancy and to ensure there's a constant power source where that power is needed. Lastly, I would be remiss if I did not mention that the standards proposed in Draft Rule 316C4A are not without merit and should be pursued whenever possible. To that end, for the reasons cited herein and elsewhere throughout these proceedings, we believe the Commission should encourage, not mandate, these standards. I will now turn the presentation back to Ms. Ryan.
Thank you. So I want to talk about a phrase used in the draft rules, specifically 315A4, that requires identification of, quote, other surface impacts in industrial facilities. As you heard from Koga, the APA requires agencies to adopt rules that are clearly and simply stated so their meanings will be understood. Here, we don't know from the rules what other surface impacts would be. We know they're not surface impacts from industrial facilities because those are mentioned separately. They can't reasonably be residences or water sources or high priority habitat or things like that because those resources are also separately referenced. So what are they? We're not sure. This phrase needs to be deleted or defined to satisfy the APA. The definition of reasonably foreseeable future development also deserves some refinement, as Koga discussed. Civitas would echo the trade's request that the SVP include information that publicly available does mean on the relevant local government permitting website or federal permitting website, as the case may be. And regarding our other two requests here on this slide, we just note that anyone can file a permit application, and quite frankly, filing a permit application in an area where there's an anticipated oil and gas permit application could even be an anti-oil and gas stratagem. And even for the many projects that are filed in good faith, we know that the permitting process can take many years and their project's size, scope, and intention can fundamentally change over time. For an application to qualify as reasonably foreseeable, it should be deemed complete by the relevant permitting authority if completeness is part of that permitting process and have its application fees paid. Without those criteria satisfied, the permit application is ineligible for approval and the opposite of reasonably foreseeable. It's important to get this right because there are hundreds, thousands of pending permits at any given time. The reasonably foreseeable future development in the impact area is going to be discussed at the pre-application consultation. Operators must provide narrative descriptions of impacts from reasonably foreseeable future development under Rules 315B, and at least 6 more rules I'm not going to bore you with. But the idea is that because there are so many cross-references in the rules to reasonably foreseeable development, we really need to know what this phrase means to make sure the cumulative impact analysis is helpful to the commission. A definition that Civitas agrees should be deferred for further stakeholdering is the definition of biological resources that was proposed in the June draft. Civitas believes that staff appropriately removed from its most recent draft this definition. That definition excluded undesirable plants and invasive mammals, but otherwise was essentially all organic matter that could possibly exist. And this is true even if the definition added the footnotes in the definition proposed by the Biological Resources Working Group. The definition does not comport with the APA requirement that operators know what is, quote, required to comply, end quote, with the several new proposed regulations that refer to biological resources, because that term, as proposed, encompasses literally millions, if not more, of species. With no limiting factors in either the definition or the draft statement of basis and purpose, neither operators nor staff would know how to approach the draft rules that request information and analysis regarding biological resources. It is entirely possible different staff members could come to different conclusions, and without certainty, there would be inefficiencies in returning permit applications to completeness review. Civitas is also concerned with the draft definition, including wildlife resources and wildlife habitats, because these resources are already addressed by separate draft rules. Furthermore, with such a broad definition, there is no way the EMC can prioritize avoidance, minimization, or mitigation of adverse cumulative impacts upon biological resources that relevant experts have determined merit special conservation efforts or analysis. Civitas acknowledges that some parties seek to endorse the June definition because it was the product of the Biological Resources Group, but that argument is not compelling for at least 3 reasons. First, the Biological Resources Working Group's report specifically states on page 16 that no recommendation will be put into a rule without a formal notice rulemaking where stakeholder input will be part of the process. And the report explicitly stated that the recommendations, including the definition, were not supported by all members of the Biological Resources Working Group. The working group acknowledged that through a rulemaking, the definition could be modified or omitted based on stakeholder, staff, and commission input. Here, staff's red line of its June rules that it came out with in its August 2 rules explained that striking the June definition was appropriate because there was not adequate stakeholder involvement on this point and further engagement was necessary. Staff also noted that House Bill 24-1117 identified a lack of data regarding biological resources and gave CPW a new mandate to study rare plants and invertebrates to determine appropriate conservation and management measures that ensure the ability of these species to perpetuate themselves. CPW's study will prove valuable to ensuring the ECMC gets the definition right in a future rulemaking. Second, when the Biological Resources Working Group was workshopping this definition, they were not, and obviously could not have been, thinking of how this phrase would be used in the proposed cumulative impact rules. The proposed rules ask for an enormous amount of information over an enormous impact area of 1 mile. Considering virtually all organic matter within a mile radius would lead to a preposterously large and unhelpful cumulative impacts analysis. We can't just slot this definition into rules that didn't exist. When you put it into the rule framework, it falls apart. Finally, even proponents of the definition recognize the broad scope. For example, wildlife hunting and angling groups witnessed Mr. John Holst recommends on pages 2 and 3 of his pre-filed written testimony that the commission develop a species list for biological resources, and he states that this will, quote, make the breadth of the biological resources definition more manageable, end quote. We agree with this estimation. Right now, though, because there is no such species list, and Civitas is looking forward to participating in a reconvened group and providing future input, if that is deferred, the definition is unmanageable. Civitas respects the efforts of the Biological Resources Working Group and believes a new group will be helpful. Civitas requests this definition remain out of the rules up for your consideration and agrees that biological resources will be protected by the August rules, focusing on, among other things, habitat types identified in Table 4 of the 2015 State Wildlife Action Plan, which is a new requirement in the August rules. Turning to impact area, Civitas supports the 1 mile impact area proposed by staff. Importantly, Civitas recognizes the impact area as the area of analysis and does not concede or mean to imply it believes oil and gas impacts are necessarily felt throughout the 1 mile impact area. I believe we gave the example of soil impacts. Those aren't going to be, you're not going to have soil disturbance 1 mile out. That being said, on balance, Civitas believes that staff's approach is fair, implementable, and should be adopted. The 1 mile impact area provides not just operators, but also communities and local governments with some sort of certainty for where to start. This is important because from concept to submittal, an OGDP application can take years and thousands of hours of preparation time. An operator must have some sense of the scope it will be asked to consider so it can plan how best to avoid, minimize, and mitigate adverse impacts and address cumulative impacts. The 1 mile radius is also consistent with mission change rules that use a 1 mile radius for data on the Form 2B CIDR form. There is nothing in the administrative record suggesting the commission got this wrong when considering the appropriate radius used to collect data that is in turn used by the commission and operators to address cumulative impacts. While the proposed impact area has its naysayers, it's not locked in, which is an important feature of staff's proposed rules. The draft rules provide the experts in oil and gas permitting, that is ECMC staff, with the flexibility to amend the impact area in the course of the pre-application process, which will also involve experts like CPW and CDPHE. Some parties would have the impact area be eligible for amendment after the pre-consultation process, but that suggestion is untenable. ECMC will not be able to evaluate an application for completeness unless the impact area is determined before completeness review occurs. If the applicant's impact area could change after submission, the applicant could be caught in an endless do-over loop of submission. If changed after completeness, then deeming the application complete would have been a misnomer and completeness review would need to begin again. Other parties have also suggested extreme impact area radii that are equally untenable. These proposals include using data analysis units to evaluate wildlife, which can span hundreds of miles, the entire Front Range ozone non-attainment area consisting of 8 counties to evaluate air impacts, and U.S. Geological Survey codes as long as 12 digits, which cover areas 20 to 40 acres in size to evaluate water impacts. These suggestions result in impact areas too massive to yield information helpful to a specific project. Moreover, providing, reviewing, and verifying the requested information for impact areas this large would be an impossible lift for operators and ECMC staff alike. Rules relating to providing cumulative impact data should be focused on generating quality data, not data just for data's sake in large areas for which there is no evidence in the administrative record that impacts extend. Importantly, none of the recently passed legislation has unwound the requirement under the Oil and Gas Conservation Act that regulations be necessary and reasonable. Statutes must be read as a whole, and impact areas in excess of 1 mile are unreasonable and unnecessary because considering cumulative impacts at that scope would result in a deluge of data that the ECMC couldn't possibly assess in any meaningful way that informs decision-making. Regarding Rule 604 in the June draft, Civitas supports its removal. First, the proposed siting requirement was unnecessary. If an operator seeks to site a working pad surface within 2,000 feet of residences on the basis of substantial equivalence, the existing rule already requires the commission to consider disproportionately impacted communities. Second, there is no evidence in the mission change rulemaking, and there is no evidence in this rulemaking that locations within 2,000 feet of residences harms public health. In fact, you just heard extensive testimony from Christy Woodward and Dr. Tammy McMullen on this point, explaining that the recent data confirms oil and gas locations within 2,000 feet of receptors not to lead in exceedances of air quality emissions above health guideline values. And you also heard that this data includes data directly from not only what industry reports, but CDPHE's camel monitoring. Third, the sensibly discarded rule would have given undue veto power to just one disproportionately impacted community member, and that could negatively affect other DIC members. Fourth, obtaining informed consent is not as easy as some parties make it sound. And it cannot and should not be assumed that lack of informed consent means that a DIC resident does not support a project. Among other reasons, persons may be unwilling to sign simply because they are busy and don't want to engage. They're nervous about signing a public document, nervous about what their neighbors might think, or they may have sensitive immigration status that makes them uncomfortable signing a document. With 48.8% of the state a DIC, it is highly probable that initial draft Rule 604C often would have the practical effect of a ban. Under the appropriate facts, this could even constitute a regulatory taking. The ECMC should not entertain reintroducing Rule 604C as initially floated in the June rules. And now I will turn it over to Ms. Stearman. Oh, I think I may have been one slide ahead. I apologize. This is still me. Long day for me, and I can only imagine what it's like for you commissioners. So this was also briefly mentioned in the trade presentation, but the June 14th draft included a provision at Rule 316D that would have allowed the director to enforce against individual operators should there be a failure to meet this so-called sector-wide NOx intensity target. And these operators could be perfectly, indisputably compliant with their own NOx intensity targets, and yet that wouldn't matter under the old draft. Not only would have this been fundamentally unfair and in violation of the APA because, among other things, there must be a violation predicate to pursue an enforcement, but the rule appears to have been based on a misunderstanding that there is this sector-wide NOx intensity target. Staff recognized this in the SVP released on August 29th that conforms to the August 2nd rules. Specifically, the SVP recognizes that there is no sector-wide target. So if there's no sector-wide target, there can't be an exceedance of something that doesn't exist. SB 24229 squarely gives the authority to create sector-wide compliance rules in line with the state's 2030 NOx goals to the AQCC. Draft Rule 1316D would have leapfrogged over this statutory directive and created within the ECMC a sector-wide compliance rule, which would have been incongruent with the statute. I will now turn it over to Ms. Stearman.
Thank you, Ms. Ryan. I would like to spend a moment discussing some parties' allegation that there is evidence of increased health risks within 2,000 feet of drilling and completions. Circling back to the 2024 study published by several authors with Colorado State University as evidence, I do want to re-emphasize 2 points, and I'll keep this short so I don't replicate many of Dr. McMullen's words. First, the study concluded that all weekly average benzene mixing ratios, even at near pad monitoring sites, remained well below health guideline values. Measuring emission changes, especially when sample points are so close to the facilities, and in many cases here, it was 300 feet, does not mean emissions were above health guidelines. Second, one public comment cited the Koo et al. Study for the proposition that pre-production operations should be banned during the ozone season. This suggestion is not found in the study and is inappropriate. First, the request is made before the wrong agency. The AQCC, the expert in air quality, has not found it appropriate to ban pre-production operations in ozone season, and neither should the ECMC. Instead, the AQCC has instituted rules to specify what engines operators are allowed to use during ozone season, and this will reduce emissions. Second, the request is unreasonable because pre-production operations must occur sometime. With wildlife stipulations, winter weather obstacles, and surface owner requirements, it's simply impossible to ban pre-production operations for over 40% of the year during ozone season. I next want to cover a few party proposals that I addressed in my pre-filed written testimony that this commission should not adopt. First, the proposals to create additional air monitoring frameworks referred to by parties as proposed Rule 616 are not right for the ECMC. The air monitoring proposal is unnecessary because the AQCC regulation, and actually commissioners, many local governments already require that robust monitoring, some even including up to 30 days. AQCC Regulation 7 was adopted and has been amended by significant rulemakings with extensive stakeholder participation, and the ECMC should not recreate the AQCC and the local government's rulemaking efforts. The Rule 616 proposal is also problematic because the threshold concentrations and the averaging times listed in Rule 616 table are not tied to health-based standards such as the EPA National Ambient Air Quality Standards, also known as the NAAQS, or the Agency for Toxic Substances and Disease Registry, or the ASTDR minimal risk levels, and they're overly restrictive. For example, the primary and secondary standard targets for PM 2.5 are for 24 hours or for annual comparisons, and they do not in any way require comparisons to a 1-hour measurement. For benzene, the ASTDR health guideline value is, you've heard it, 9 parts per billion for 1 to 14 days. But the proposed thresholds in the table are 1 part per billion, which was described to us during Friday's testimony as just 1/3 of the lowest threshold. Also, I'd like to kind of comment that that has no tie whatsoever to toluene, ethylene, benzene, or xylenes. Second, the proposal for ECMC to adopt a NOx ozone season budget should be rejected, as you've heard in previous testimony here today. The AQCC determined in December 2023 that an intensity rule was the best way to equitably allocate the state's NOx reduction targets. And finally, some parties request that the ECMC determine if an operator is anticipated to exceed its applicable NOx intensity target for an upcoming ozone season. This is unworkable. It would be impossible for any agency to look into the future of an individual operator on this scale and expect any meaningful data inputs to show predictive compliance without the intimate and proprietary knowledge of forward-looking production curves, proprietary contracts that we may have with our service providers, the schedule changes in the movement, and a company's plans to either expand or retract development that program. So each operator is subject to intensity rules, whether it's NOx or greenhouse gas. We must comply without exceptions, and with whether they comply or not will be determined by AQCC. The idea of predictive compliance was considered and rejected during the recent December 2023 AQCC rulemaking, and there is no value in reopening the conversation because the AQCC has determined that it provides no benefit over the clear and concise compliance reports that are written into rule. And it's unclear how the ECMC would evaluate an operator's anticipated compliance, and the ECMC or other parties should not be guessing at whether an operator will satisfy the regulation of another agency. And I will turn it back to Ms. Ryan.
So I would like to conclude by emphasizing some of the ways that the August 2nd rules provide enhanced protections for DICs and why adding the cumulatively impacted community concept is a smart idea. It seems like some parties might have thought that ECMC simply swapped out DICs for CICs, but that's not the case. The rules continue to focus on DICs where people live, and then add CICs as an additional subset of DICs to protect. As you've heard ad nauseum today, nearly half the state is a DIC. With so much of the state a DIC, the commission should focus its resources on those communities that need the most protections. Staff made a sensible policy choice in deciding to follow the recommendation of the Environmental Justice Action Task Force that was later adopted by AQCC to create the subset of DICs known as cumulatively impacted communities. The enhanced protections for both types of communities are substantial. The protections include increased public comment times, improved map and data submissions, greater transparency and improved outreach, formal meetings, and CDPHE consultations. And it's not just process, there are also substantive enhanced systems and practices required in several draft rules. As an example, draft rule 316 C4B requires the use of a lease automatic custody transfer system or technology that is demonstrably equivalent or superior. We appreciate your time and attention and are available for any questions. Thank you very much.
Thank you very much for the presentation. Commissioners, do folks have questions for the panel? Commissioner Cross, then Shea, then Oath.
Thank you, Mr. Chair, and thank you for the presentation. I just have, I think, 3 questions for clarification purposes, and I think they're all.
Hey, Mike, you need to get closer to your mic. Sorry.
Apologies. I think I just have 3 questions for clarification. I think they're all geared towards Mr. Bennett. With respect to the ESPs that you talked about potentially being feasible, 1, if ECMC were to state that pressure vessels are not considered tanks, would it still be impracticable to go tankless?
Thank you for your question, Commissioner Cross. It's my understanding that there are marked differences between a quote pressure vessel end quote and a storage tank quote end quote. And so the feasibility of a tankless location or a location with tanks requires a quote storage tank end quote in addition to any quote pressure vessels end quote that may be on location as well.
So that the pressure vessels not being tanks wouldn't change your opinion on it.
Correct. They're 2 separate pieces of equipment that serve 2 separate yet sometimes similar functions.
Okay. Not sure if you heard the testimony earlier today from some of the West Slope operators, but there was some discussion of the fact that, as you brought up, produced water and sometimes the ability to get produced water to an injection site or to a central facility. There was some discussion about the fact that if you can't have a produced water facility within a disproportionately impacted community, it could create problems. Do you foresee, given the geographical scope differences between DI communities on the West Slope and in the DJ Basin, do you foresee similar issues in the DJ Basin?
Appreciate the question. And if I understand the context appropriately, and I was able to hear the testimony this morning, I think given the kind of the expansive nature of how a disproportionately impacted community is defined, would in fact render that issue an issue in the DJ as well. In other words, an operator's inability to cite a produced water facility, assuming that was a viable technology in the DJ, would in fact be impacted by the presence of a DI community, in my opinion, again, based on how those communities are defined and the geography of those communities relative to the DJ.
Okay. And I was wrong. I think I have 4 questions, not 3. But the third question is, as you talked about, the infeasibility of some of these ESPs, especially in DI communities, how do you respond to the fact that proposed rule 316A4B still provides an out or off ramps and an explanation as to why you may not be able to use it?
Again, appreciate the question, Commissioner Cross, and I'll ask Ms. Ryan to chime in if she feels inclined. It's been my experience, right or wrong, that proving that you meet an exception, for example, it can be rather difficult because that is based on interpretation rather than being encouraged, if you will, to utilize an enhanced system in practice to the extent you can. And I do recognize the issues associated with that kind of practicable language, as has been discussed not only in these proceedings, but elsewhere. And so from a regulatory certainty standpoint, we would much rather appreciate knowing that if something is not attainable, we are able to continue with our operations and our plan of development rather than to have to seek an exception or go down an off-ramp based on, quite honestly, more of a subjective set of criteria than something that may be more objective, like a plain reading of a black and white regulation.
Commissioner Cross, if I may, the as practicable language actually doesn't apply across the board. And in Rule 316-4A, I think there was some early confusion among stakeholders about that because the thought was, well, if you prove it's not practical, what's the big deal? And as Mr. Bennett said, there's still challenges with that from regulatory certainty. But the fact of the matter is that that's not always available. So if you look at the text of Rule 316 D4A, it says that all oil and gas locations subject to this rule that are also within a disproportionately impacted community, operators will also implement the following. And then it says at all other, meaning at all others that aren't a DIC, they'll be implemented where practicable. So what our testimony was saying is that because just of the nature of the DJ and where the mineral resources are located, the majority of, quite frankly, unfortunately, for just how it is, lots of locations, we believe perhaps even the majority of locations will be in DICs. And so it ends up being mandatory because it's only at the non-DIC locations that have that as practicable escape hatch, let's call it.
Okay. And then I think one final question, and I think it's important, especially knowing where some of Civitas's operations are. There's been a lot of discussion about the fact that no permits have been issued in CICs in the last 5 years. I do know that there's been permits near CICs. Curious to understand if and how Civitas may be affected if it was to have CICs. Would that affect any, I guess maybe not even permits for directly where you're drilling, but maybe operations with pipelines, etc., access roads?
I appreciate your question, Commissioner Cross, and the short answer is yes. The application of a cumulatively impacted community would have an overlay, if you will, with Civitas asset portfolio. We do believe, however, in those instances where we may have a surface location within a CIC, that our alternative location analysis will clearly show that the location has the fewest cumulative impacts compared to the other locations considered as part of that project.
Okay. Thank you. Those are my only questions.
Commissioner Shea?
Commissioner Cross stole my question, so pass.
How dare you, Commissioner Cross? Commissioner Oath?
Thank you, and thanks for your presentation. Very helpful. I just have, I think, 2 questions. The first is for Ms. Stearman. So you testified that you feel that no agency, and ECMC in particular, would not be able to prospectively look at and assess whether or not an operator would be able to comply with their NOx intensity target in the upcoming ozone season. And I kind of want to push back on that a little bit and hear your response. So, so I'm thinking about an example where an operator in the previous ozone season was not in compliance with their NOx intensity target and has made no changes, or in fact, maybe is even proposing an expansion. It seems to me like a matter of anyone would be able to ascertain and use professional judgment to determine that if that was the case in the previous year, and if nothing has changed or they're expanding, that they're not going to be able to comply in the upcoming season. So do you have thoughts on that kind of a scenario?
Yeah, thank you for the question, Commissioner Oath. I think what you're referring to is kind of relating back to the previous year. So I agree with you that yes, you may or may not have been in compliance with your NOx intensity. What I think we're concerned about is if you're trying to project going forward more on a predictive basis, that you don't think you will comply. So in other words, I think some parties had suggested that the language in I forget the rule, but it says will not or may not comply with the NOx intensity. So it's the may not comply, or is, I think we have an issue when you're trying to make comparisons about whether or not you're close to complying or not close. We would like to keep it to either you comply or you don't comply.
Okay, but what you're saying is if we were to be looking at a sort of a regulatory setup where, AQCC adopted the NOx intensity targets, I think it makes sense for them to be the ones to take enforcement action if a particular operator is out of compliance with them. But there is a regulatory gap of kind of going forward and an opportunity here for ECMC to step in a way that AQCC does not have a tool to say, okay, if you've been not in compliance in the past, CDPHE can address that in terms of enforcement, but let's look at forward looking and ECMC's statutory obligation to help ensure compliance with the NOx intensity targets adopted by AQCC. That seems like a fair role, and that there could be circumstances where ECMC would be able to make that determination. And then I think what I'm hearing you say is just that from your perspective, that should only be if they will not comply, not if they may not comply.
Yes, Commissioner, that's correct.
Interesting. Okay, that's helpful. Thank you for helping me understand your position there. And then the other is following up, I think, on a question that was asked previously to the trades, and they suggested we ask the operators, and I think it's slightly different than Commissioner Cross's question, but maybe the same. But it has to do with, the testimony of how few permits have been approved within 2,000 feet within a DIC. And so what we've heard is, yes, there have not been very many in the past, but there are likely to be a number of those in the future. I'm really interested in trying to put that in context. How many are we anticipating? And so just curious if you can speak on behalf of Civitas.
Yeah, thank you for your question, Commissioner Oath. Putting a round number on that to answer your question is going to be something that's a little difficult, right? As most operators throughout our planning process, we look at a wide variety of criterion when choosing a site of location, one of which, as you would assume, is the type of community we're operating in or adjacent to. So while I can't give you a number that says, yes, Civitas will have X number of locations in a disproportionately impacted community or within 2,000 feet of a disproportionately impacted community, again, I can tell you that based on the geography of those communities, how they're designated, and where our assets are located, we will ultimately have locations in or immediately adjacent to disproportionately impacted communities at some point in time in the future.
Okay, thank you, Mr. Bennett. And you may not be able to answer this either, but just to be clear, I was wondering about the number of locations you're likely to be proposing within 2,000 feet of an RBU, school, childcare, et cetera, that is also within a DIC, not within a DIC or within 2,000 feet of a DIC, which is quite different.
No, understood. And again, appreciate the clarification, Commissioner Oath. I cannot, again, put a number on that.
Okay.
I can tell you, however, that we certainly prioritize certain criterion within that disproportionately impacted community definition that we, avoid. And so you mentioned schools, childcare facilities. We endeavor with each and every project to do our best to be as far away from those locations in any circumstance, but especially if those are located within a disproportionately impacted community.
Thank you.
Other questions from commissioners? All right, I'm not seeing further questions. Thank you for your participation with us this afternoon.
Thank you.
Commissioners, that will conclude our hearing for today. Prairie Operating is going to be called upon first thing in the morning. And then we've got a couple of more cases in chief, which we should be able to wrap up no problem tomorrow. So with that, we would adjourn this evening and return tomorrow morning at 9 a.m. See you in the morning.